Okay.
Some people waiting too, so you'll need to.
Yeah, sure. Okay, if everybody will go ahead and we're going to start the meeting, if everybody will rise for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, I'm going to go ahead and call the Planning Commission meeting for Wednesday, April 28th, 2021 to order. My name is Sumit Shah, and I'm the chairperson of the City of Milton Planning Commission, and this is a regular meeting of the City of Milton Planning Commission. This is a 7-member commission appointed by the City of Milton Mayor and City Council, created for the purpose of holding public hearings and making recommendations on rezoning, use permits, concurrent variance applications, comprehensive land use plan and plan map and other related plans, and amendments to the zoning ordinance. I'd like to go ahead and introduce all the Planning Commission board members. To my left, we have Fred Edwards, Zach Middlebrooks, Kurt Nolte, again I'm Sumit Shah, Ron Gilbert, Marty Locke, Jan Jacobus. The petitions will be heard in the sequence listed on the posted agenda. I would like to acquaint you with some of the rules and procedures conducting this meeting. The applicant and all of those speaking in support of an application will be allowed a total of 10 minutes to present the petition. The applicant may choose to save some of the time for rebuttal following the presentation by the opposition. The opposition will be allowed a total of 10 minutes to present its position. If time remains, the opposition will be allowed to rebut. Since the burden of proof is upon the applicant will be allowed to make closing remarks provided time remains with the allotted time. The staff of the Community Development Department will be keeping track of time and will inform you periodically of the remaining time for your presentation. Each speaker must fill out a speaker card before speaking and leave it with a staff member of the Community Development Department. All speakers will identify themselves by name, address, and organization, if applicable, before beginning their presentation. When an opponent of a rezoning action has made within 2 years immediately preceding the filing of the rezoning action being opposed, campaign contributions aggregating $250 or more to a local government official of the local government which will consider the application, it shall be the duty of the opponent to file a disclosure with the governing authority of the respective local government at least 5 days prior to the Planning Commission meeting. A violation of the relevant state statute constitutes a misdemeanor. Therefore, if you have contributed $250 or more to a council member and if you have not filed a disclosure prior to the Planning Commission meeting, the city attorney strongly suggests that you have someone else speak for your point of view. Each application has been properly filed with the Department of Community Development. Signs have been posted on each site, the matter has been advertised, and the notices have been mailed to property owners affected by the zoning as required by the Milton zoning ordinance. The Planning Commission's recommendation will be forwarded to the City of Milton Mayor and City Council for final disposition in approximately 5 weeks on the first Monday of each month at 6 p.m. in the council chambers. The Community Development Department has reviewed each application in conjunction with various agencies and departments, both internal and external, to the city. Staff's recommendations, findings, and conclusions are here before us in written form, which has been made available to all petitioners and to the public. Demonstration of any sort within the chamber is prohibited. So please refrain from any applause, dialogue with the person speaking, or outburst. Please turn off all cell phones or place them on silent. All remarks will be addressed by the Planning Commission. Please show the same respect to the person speaking that you will expect to receive yourself. In addition, the applicant shall not submit material to the Planning Commission during the meeting, unless requested to do so by the Commission. All material that you wish to be reviewed by the Commission in consideration of your application should be submitted to the staff of the Community Development Department to be included in the normal distribution of packages to the Commission. Finally, To the applicant, if your petition is deferred in accordance with the Milton zoning ordinance, you are required to update or obtain a new sign for reposting. Failure to update or repost will result in further delay. There are no exceptions. We've got a lot of people potentially on Zoom, so I've got a little speech. I'm going to talk about that. Welcome to tonight's Planning Commission meeting if you are attending virtually via Zoom. There are a few guidelines I would like to mention. Everyone is muted and your videos are turned off by default to minimize any disruptions. If you would like to make a comment during the public hearing portions of this meeting, please raise your hand by clicking on the icon labeled Participants at the bottom of your screen and then click the button labeled Raise Hand. If you are calling into the meeting on a phone, you can raise your hand by pressing *9 on your keypad. Once the moderator calls your name, please unmute yourself by clicking on the microphone button on the bottom of your screen or by pressing *6 on your phone. At this time, I'm going to call for any general public comment. Time will be limited to 2 minutes per person and not to exceed 14 minutes. Do we have any general public comment?
We do not.
Okay. The next item on the agenda is the approval of the March 24, 2021 Planning Commission meeting.
Excuse me, Chair, I think there was going to be a change of order agenda.
Yes, and I believe we were going to do that after this. Yeah. Okay, has everybody had a chance to review the action minutes from the March meeting? Does anybody have any comments or any motion?
I recommend approval of the March 24th action minutes as presented.
I second.
Okay, we have a second by Mr. Gilbert. All those in favor say aye.
Aye.
Anybody opposed? Okay, those minutes have been approved. Okay, next item on the agenda right now, and I believe we're going to have, does anybody have a motion to move any items on the agenda up? We can kind of switch that up.
I would like to suggest or move that we move the text amendments to the front of the queue this evening. Okay,
so Commissioner Gilbert has moved to move item number 6, which is the text amendments RZ21-05 and RZ21-06 up the agenda to the next item on the agenda. Does anybody have a second?
Second.
Okay, we have a second as well. All those in favor of moving that item up to the next agenda item, please say aye. Aye. Anybody opposed? Okay. Okay, so then at this time, we're going to go ahead and sound for RZ21-05.
Thank you. Good evening, Commissioners. I'm Sarah Ledart. I'm the Economic Development Manager here at the city, and I am back before you. I was here about a year ago speaking to you about breweries and distilleries and alcohol in Milton. And one thing that we found out, or we realized, is that we didn't include these because they're considered manufacturing. So we need to work that back into the tables in Deerfield and over in here in Crabapple. So just to kind of refresh memories, these are not people actively looking to locate in Milton. These are simply examples of what we're talking about when we talk about a brewery. Sweetwater, that's located downtown, is on 8 acres, and they create about 500,000 barrels a year. And then a micro distillery is like Old Fourth Distillery down in Old Fourth Ward. That's located in I think their space is about 2,000 square feet, but a micro distillery or brewery can be located in something as small as 1,100 square feet. We will be adding these 4 definitions to the beginning of Chapter 64. These mirror the definitions that are currently in Chapter 4, which is alcoholic beverages. Just defining exactly what a brewery, distillery, microbrewery, and microdistillery means, and the differential is the number of barrels that they produce a year.
Yes. This needs to go in front of the definitions in each form-based code section
Thank
of
you.
definitions. So
Sorry.
that's what's been advertised. So
Okay.
Thank you.
And then to the Crabapple form-based code, which is Table 9, under the other industrial, we would like to add the microbreweries, all 4 of them, as allowed by warrant in T4 open and T5. Currently, manufacturing is allowed by warrant in T5. And then over in Deerfield, the form-based code table 10, we want to allow them by warrant in the T4 open, T5, and T6 areas. This is the sections of Deerfield where they will be allowed. So keep in mind that just because it's allowed, so for example, the T4 open, which is that kind of bluish area on the left, a lot of that's already built out in residential. So you obviously, the community development director with that warrant is not going to allow a brewery to be built in between two homes. So those sorts of things aren't the intention. It's things like over in Crabapple, where the road structure, when we did the T4 open and T5, didn't incorporate the movement of the road. So now part of T4 open is part of what probably, if we knew where the road would be, would more likely be T5 now. So that's what it is. It's not, the intention is not to put these into residential areas. It's for those parcels that make sense that, of course, the community development director will assess after they answer the questions for that warrant. Questions?
I was just going to, if you could just kind of state for the record the difference between the warrant and a variance process.
Braun, can you?
Yeah, so in both form-based codes, Deerfield and Crabapple, it's exactly the same. A warrant is a ruling that would permit a practice that is not consistent with a specific provision of this code, but is justified by its intent. And a warrant would be processed the same as administrative variance and ultimately approved by the community development director. Warrants relating to a use shall be based upon considerations for use permits. So you'll become very familiar with those tonight because we're going to look at that a lot. So an applicant that's seeking a warrant would fill out and submit a letter to the director explaining the reasons why they want a certain use. Let's say if it was a microbrewery, and then they would go through those 10 considerations and spell out all those things that it requests, like parking, hours of operation, consistency with what's around it, et cetera. And then it's submitted to the community development director, and he evaluates it and then makes a decision whether to approve the warrant or not. Then the difference between a warrant and a variance is a request to the Board of Zoning Appeals to allow a certain, there's uses, there are some uses, no, I'm sorry. Usually a variance is when you want to reduce a setback or to change something in the code. And that's also allowed in the form-based code. But that's a full hearing before the Board of Zoning Appeals. It's about a 6-week process, and they make the final decision, a variance.
Sarah, a couple of quick questions for you. First, I'd like to confirm that we're talking about breweries and distilleries only in Crabapple and Deerfield?
Yes, sir.
Nothing in rural Milton?
No, sir.
Fine. Today, I'm thinking about the placement of these facilities. Say for liquor stores, we have spacing requirements. Are there any similar sort of requirements here to space out the distilleries and the breweries?
No, sir. And actually, most likely, having a concentration of them is what makes areas attractive. When you can come to somewhere like downtown Crabapple and have 3 or 4, whether it's distilleries or breweries, some combination of those, it becomes a destination and an experience to have all of them close together.
Okay. Which other application processes are handled as warrants?
So in these same zones that we're talking about, in both the Crabapple and Deerfield zones, liquor retail establishments, conference centers, outdoor commercial amusement, and gas stations are just a small snippet. I went through and kind of found things that were allowed by right and warrant in these zones
So
as
this
well.
is a well-worn path, is what you're saying?
Yes.
Okay, thank you.
And then there actually, if there is a warrant process, is there some sort of an appeal process if, somebody's application, is not approved by the warrant process and they wanted to appeal that?
So yeah, that would be a secondary variance to the Board of Zoning Appeals. So if the director decides not to approve it and the applicant is not happy with that decision, then it goes to the Board of Zoning Appeals for what's called a secondary variance, which is basically a protest to the decision of the director.
Okay. And, in terms of, again, kind of from a transparency standpoint, again, you have the variance process versus the warrant process. From the city standpoint, how do we know, are they looking for one brewery, two breweries? If somebody comes up and says, hey, I want to have the third brewery in Crabapple and they get denied, where does that come into play in terms of, should this be something that should be through a warrant process or should just be allowed through the normal variance process? And why is the request being made to potentially have this through a warrant process?
So when I came before both Planning Commission and Council last year, I thought when I included this under retail that I was including breweries and distilleries allowed by right in all of these zones, and that's how I presented it to everybody. So actually coming back and asking for this as a warrant is putting in another layer of protection that we didn't intend last March-ish. So because manufacturing in Crabapple requires a warrant, we thought that this was the appropriate way to go about it.
And then the timeline for a warrant is how long?
Would we reserve 30 days?
Basically, we just, once a submittal comes in, a request, probably within a couple weeks, we make a decision on it. So there's not a specific timeline requirement.
So you're potentially looking at a difference of anywhere from 2 to 6 weeks if you go warrant versus a variance process?
Correct.
Oh. Anybody else got questions?
I guess that's the one question. When you have the barrel amounts for the microbrewery and the how are those come about? The reason I'm wondering is I know a lot of that equipment is already pre-built. So I'm just wondering if that, and for example, the microbrewery on the front was 20,000 barrels. I'm just wondering, is that a doable amount based upon?
So these numbers came from the state. These are how the state defines them. So I should probably update that first slide. Sorry.
Anybody else have any other questions? No? Okay. Anything else, Sarah? Do you have anything else? I'll entertain any sort of motion that anybody may have.
Excuse me, we need to check if there's anybody for a public hearing.
Okay.
I don't have any cards, but I wanted to check online. If there's
Okay.
any.
Is there anybody online who has any sort of a comment?
You can please raise your hands.
They can please raise their hand.
Doesn't appear to.
No. Okay.
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 Mr. Chair, I'd like to move that RZ 21-05 and RZ 21-06 be approved as presented by staff.
A second.
Okay. We have a motion and a second. All those in
Just
favor?
to be clear, that'd be a recommendation of approval.
Pardon me?
Recommendation of approval.
Rephrase. I'd like to make a recommendation of approval that RZ 2105 and RZ 2106 be approved as presented by staff.
Still second.
I'll second that one.
He's still not happy.
The motion is to recommend approval to the city council. And I think it's understood.
I'd like to take away my previous approval of that. If it's stated properly.
Okay,
In other words, it will still need to go to the city council.
got it. Sure, okay. So we have a recommendation for an approval of RZ 21-05 and RZ 21-06 to be approved for city council's consideration. We have a second. All those in favor say aye.
Aye.
Anybody opposed? Hearing none, that's been approved for recommendation. Thank you, Sarah. Okay, next item on the agenda is RZ 21-07. And
Okay.
before I I'm going to sound for that, but
Yeah, so let me just go ahead. The applicant has submitted a letter requesting to withdraw the petition.
Okay.
And so I won't go through, obviously laboriously go through the presentation, but the applicant's representative is here if you have any questions or anything, but that's been the request by the applicant.
okay,
But Ms. Ledbetter's here to answer any questions.
problem. Ms. Ledbetter, if you want to make any remarks, you can.
I'm Rhonda Ledbetter with Engineering 303 at 108 Allen Street in Cumming. I'm just confirming the request for withdrawal for rezoning.
Okay, thank you very much. All right, does anybody else have any questions or anything else on that item?
And you'll just have to make a motion.
Yeah, sure. Okay, do I hear a motion to accept that withdrawal of that RZ 21-07?
I move to accept the withdrawal of RZ 21-07.
Okay.
I'll second that.
Okay, we have a motion to withdraw RZ 21-07 in a second. All those in favor say aye.
Aye.
Anybody opposed? Okay, that's passed. Okay. Next item on the agenda is U21-01, VC 21-03.
Okay, good evening, Planning Commission. It's so exciting to have you all together. I said that to the council the other week, so it's just makes me feel at home, but I'm just happy everybody's here. The first item we have tonight is U21-01, VC 21-03, request for a use permit for agricultural related activities. So I know you all see that there are three different items for the same property. So just bear with me. The first time I'm going to go through all the background material that is basically the same on all three petitions, so that when we get to the second petition, I won't repeat myself of what I did on the first one. I'll be just speaking to the pertinent information for that particular use permit. So the first one's going to be a little long, so again, bear with me. The applicant is the PFAJ Revocable Trust dated 2/7/19, and the applicant is represented by Ellen Smith of Parker Poe and Bernstein. The site contains 18.027 acres that include multiple parcels. The existing uses in general are a single-family residence, equestrian facility, and winery. The request for a use permit and a two-part concurrent variance to allow the existing parking areas, wood pavilion, horse arenas, and driveways within the 100-foot setback. Then secondly, to allow the structures housing animals to be located within 100 feet of a property line. So this is the location of the request. So it has frontage on Bethany Way as well as on Hopewell Road, and contains multiple parcels. So this is a zoning map. It's pretty boring. It's all AG1. Okay. This is a future land use map, 2035, and this area is the AEE, which is Agricultural Equestrian Estate Residential. This is the site plan that's submitted. This is the same site plan for all three requests. Just want to walk you through a little bit here. This is going to be the future roundabout, and in your packet, I included the transportation engineer included a drawing of what that roundabout will look like per the design. The applicant has very recently, right before submitting this use permit, acquired a piece of property in this vicinity, of which the right-of-way, I believe, either has or in process to be acquired. I believe it's already been done. So there is an entrance coming through this way, or a future entrance, and then there's another entrance off of Bethany Way, primary entrance. So there's already a lot of existing structures. There's a house. There is other outbuildings. There's a riding arena. There's actually two, one here, with various barns and fenced-in areas for the horses. Again, I've already said it's zoned AG1, and that they purchased a property on Hopewell Road that'll be part of the new roundabout, and I will not go into what I just said again. The Painted Horse Winery currently operates on the site, which is allowed by right within the AG1 zoning district. There's a tasting room located within the basement of the house, as well as areas on the lawn behind the house to sit and listen to background music. There are vineyards located on the property as well. Based on the applicant's letter of intent, Ms. Pamela Jackson and her family acquired the first tracts of property in 1991. In 1996, equine barns were built and horses were moved in, and in 2003, the farm at Pamela, Inc. was formally incorporated. Starting in 1997, the farm started hosting a variety of uses and events, including equine breeding, boarding and training, animal husbandry, an annual Easter egg hunt, ticketed live music events, and various corporate events and weddings at the property, including using valet services as needed, starting in 2002 and continuously since then. The farm has hosted summer camp as a week-long day camp for children, birthday parties, and other Boy and Girl Scout type of events. There have been a variety of ancillary uses to the farm, including various fruit tree and apiary agricultural uses, historically for more than 20 years. In 2018, Ms. Jackson planted her first vineyards, and in 2019, the farm became licensed as the city's and Fulton County's first farm winery. The applicant states that an additional 4 acres of vineyards are being added this year. During the summer and fall of 2020, the city received various complaints regarding an increased number of visitors to the site, issues with off-premise parking, and loud music coming from the property. The city asked to meet with Ms. Jackson and her legal counsel to discuss their programming on the property. The city, including Community Development Director, Zoning Manager, and City Attorney, met with Ms. Jackson and Ms. Smith, her legal counsel, approximately 3 times in November and December of 2020. At those meetings, the applicant asserted that the activities that she was holding were uses that were grandfathered or potentially legally non-conforming uses, and that she did not need use permits to bring the variety of uses in compliance with the city's zoning ordinance. As stated in the applicant's letter of intent, quote, "These applications are being filed, submitted in good faith by Ms. Jackson to further resolution of disputes between Ms. Jackson and the city regarding permitted and potentially legally non-conforming uses of the property. These are being submitted without waiver by Ms. Jackson and of her rights, claims, interests, or defenses with respect to prior, ongoing, or future events, uses, or operations at or on the property, and without admission by owner of the need for such permits or variances." On April 21st, 2021, the applicant submitted a revised set of proposed condition uses for the agricultural-related activities. These will be discussed below within each appropriate topic. She did it for all 3 use permits, and they'll be discussed within each of those reports. In regards to public involvement, we held a community zoning information meeting here at City Hall on March 23rd, both in person and via Zoom. And there were approximately 8 members of the community who signed in the attendance sheet. There appeared to be more in the audience. And the meeting was also held via Zoom. These were the comments in general that were made: traffic caused by the various current events and concern over the speed of existing traffic on Bethany Way, noise coming from music at the winery impacting enjoyment of nearby property owners, parking off-site at the Bethany Oaks subdivision pool area, concerned with people leaving the venue intoxicated. Do not mind the children-related events like birthday parties, painting horses, day camps, and equestrian-related businesses. At the Design Review Board, which the Design Review Board is tasked to give a courtesy review of any applications for use permits or rezonings. And the following comments were made at the meeting. The majority of members expressed supporting the existing uses on the property, such as the winery, equestrian-related uses, children's activities, but not to expand the uses as requested. In regards to the public participation report, so each application they're required to hold their own meeting, public meeting, to invite the public to come and to speak and to talk about issues that might come up. So they held theirs on April 19th at the residence or at the location. And there were 16 people in attendance that signed the attendance sheet. Their concerns were the following: noise primarily during ticketed live events, traffic congestion, off-site parking at Bethany Oaks subdivision. The response from the applicant were indicated on the public participation report. They would intend to measure noise levels at events, propose conditions to on-site parking, mitigate noise, including additional limits on allowable dB, hours of operation, frequency of events, and numbers of ticketed attendees. Requests on social media through parking attendants and off-duty police for on-site parking. Attendees not to park off-site and coordinate with Bethany Oaks HOA. In regards to city staff comments, the city arborist stated the canopy coverage calculations and any specimen tree recompense will be calculated when they submit for LDP, or land disturbance permit. The proposed parking locations do appear to involve tree removal, but appears not to be any specimen trees involved. Based on the size of the parcel prior to a combination plat, the canopy coverage requirement will be 25%. So in the recently adopted canopy ordinance, any parcels zoned AG1 that are more than 3 or more acres only require 25% of canopy coverage. The development engineer, stormwater runoff from all new impervious surfaces created by the construction of new buildings, gravel parking areas, and miscellaneous structures may be managed by stormwater facilities located either within the parcel boundaries or a shared facility off-site. I won't go through everything that this fire marshal said, but you can read them, various items such as they're proposing for the winery a new structure, and that would be sprinkled. And ultimately, the plan is subject to an in-depth review at the time of application of LDP. Transportation. Site improvements, including driveway locations, fencing, and stormwater pond, are to be coordinated with the underway Hopewell Road at Bethany Bend Way intersection improvement project. In regards to the environmental site analysis was completed. There is a stream on the property which identifies the appropriate state and city buffers. Further, there are no floodplains, steep slopes, archaeological or historic sites, endangered vegetation, or wildlife. The applicant has not submitted tree survey, but will be required to meet the tree canopy ordinance at the time of land disturbance. In regards specifically, now I'm going to step into the request for the first use permit, which is the agricultural related activities. So I have written down or provided to you what that is. It is the intent of this division to allow certain agricultural related activities with a use permit in compliance with the development standards below to preserve the nature of agricultural areas. Such uses shall include, but not be limited to, petting zoo, educational tours, dude ranches, picnicking, and pay fishing. So these are all the different requirements. I'm not going to go through all of them, but I will point out the ones that they do not meet the standard because they are requesting concurrent variances to them. And that would be under D and E. The first one, a minimum of 100-foot setback is required from all property lines for activity areas, including parking. And then secondly, E, all structures housing animals shall be set back a minimum of 100 feet from all property lines. So now I'll step into discussing each of those two-part concurrent variants. The first one is to allow the existing parking areas, wood pavilion, horse arenas, and driveways within that 100-foot activity setback. And then under each request, there are four standards that the zoning ordinance requires that when a variance is requested, that you can prove each of those standards. So the first one is relief, if granted, would not offend the spirit or intent of the zoning ordinance. Since these structures, and this is staff's response, since these structures and activity areas already exist and are primarily associated with the equestrian use of the property, this request would not offend the spirit or intent of the zoning ordinance. The second standard is there are such extraordinary and exceptional situations or conditions pertaining property. Staff notes that the proposed parking should be located outside of the 100-foot activity setback. 3, relief, if granted, would not cause a substantial detriment to the public good and surrounding properties. As mentioned above, the equestrian-related structures and uses currently exist and have been used on the property and would not cause a substantial detriment to the public good and surrounding properties, as there are similar uses nearby. The fourth one would be, and I would need to get that. It's not in here. Let me get it. Okay, so the fourth one is that the public safety, health, and welfare are secured and substantial justice is done. The location of the primary activity areas for the requested use permit are outside the 100-foot setback. In addition, there is existing vegetation on the property to help ameliorate the proposed use from adjacent and nearby properties, and therefore the public safety, health, and welfare are secured. Therefore, staff recommends approval conditional of Part 1 VC 21-03 to allow the existing structures and activity areas to remain as shown on the site plan received by the Community Development Department on February 25th, 2021, except for any proposed new parking. Okay, so now we'll go on to Part 2 request, which is all structures housing animals shall be set back a minimum of 100 feet from all property lines. The site plan indicates structures housing animals on the site plan. They are small in size and located within the eastern portion of the property. Relief, if granted, would not offend the spirit or intent of the zoning ordinance. Since these structures housing animals are small in size, already exist, and are associated with the equestrian use of the property, this request would not offend the spirit or intent of the zoning ordinance. There are such extraordinary and exceptional situations or conditions pertaining to this particular piece of property that the literal or strict application of the zoning ordinance would create an unnecessary hardship due to size, shape, or topography, or other extraordinary and exceptional situations or conditions not created by the variance applicant. Since these structures housing animals already exist and are small in size and are an integral part of the business of providing equestrian activities for the community, this is an extraordinary and exceptional condition not caused by the applicant. The third item is relief, if granted, would not cause a substantial detriment to the public good and surrounding properties. As mentioned above, the structures housing animals currently exist and have been used on the property and would not cause a substantial detriment to the public good and surrounding properties as there are similar uses nearby. And the last standard is that the public safety, health, and welfare are secured and substantial justice is done. The structures are small in size, and in some instances there is existing vegetation to screen them from adjacent property owners to help ameliorate the existing structures from adjacent and nearby properties, and therefore the public safety, health, and welfare are secured. Therefore, staff recommends approval conditional of Part 2 of VC 21-03 to allow the existing structures housing animals to remain as shown on the site plan received on February 25th. So here, the applicant submitted a revised set of proposed condition and uses for the requested use permit. The uses that they call out are summer and other children school break camps, birthday parties, agricultural, farm, equine, based educational events, Boy, Girl Scouts, or other community or church organized events, art-related events, limited farm animal petting, primarily associated with other events, no more than once per week for a limit of 3 hours. Events not expressly ancillary to single-family residence, farm, winery, or equestrian permitted uses, but tied to agriculture. They are seeking to prohibit no exotic animals, no kennel, no overnight camps or events. And they're proposing hours of operation, 8 a.m. to 9 p.m., and then capacity limits of maximum attendees for a single event not to exceed 100 people, and children camp, birthday party, educational events, maximum 35 children per event. And now we're going to step into every use permit has to be reviewed with use permit considerations, as I referred to in the prior discussion on distilleries and warrants. So basically, I'm going to just go through those. This first one is whether the proposed use is consistent with land use or economic development plans adopted by the mayor and city council. The proposed development is within the AEE land use category on the comprehensive plan map contained in the comprehensive plan update 2016. The proposed use permit for a rural event, for the agricultural related activities is permitted on the AG1 district. In addition, the following plan objectives are consistent with the proposed use. We will encourage the preservation of natural resource areas and preserve contiguous green open spaces, development of land in appropriately designated areas as development occurs. We will seek opportunities to provide pleasant, accessible public gathering places and parks throughout the community. We will encourage development that is sensitive to the overall setting of the community and will contribute to our community's sense of place. The second one is compatibility with land uses and zoning districts in the vicinity of the property for which the use permit is proposed. The adjacent uses to the north and northeast are large lots developed with single-family residences as well as equestrian-related facilities. Staff notes that a festival event, indoor-outdoor, was approved at 13895 Hopewell Road to be used as a wedding facility in 2014, but has not been operated in that capacity. To the east are scattered single-family residences and the Bethany Oaks subdivision, zoned AG1, and North Park subdivision. To the south are large lots developed with single-family residences and equestrian-related facilities. To the southwest is Cooper Sandy subdivision, zoned AG1, with single-family residences. To the west are large lots developed with single-family residences and equestrian-related facilities, again, zoned AG1. Based on these surrounding uses and zoning, it is staff's opinion that the proposed rural I'm so sorry. The agricultural related facilities uses is compatible with surrounding land uses if approved with the recommended conditions. The applicant has included a list of uses that they agree that shall not occur on the property, which I reviewed previously, and they will be included in the recommended conditions. Whether the proposed use may violate local, state, or federal statutes. The proposed use does not appear to violate any ordinances or regulations governing land development if approved with the recommended conditions and development requirements. The effect of the proposed use on traffic flow, vehicular and pedestrian along adjoining streets. The proposed use's effect on the traffic flow, vehicular and pedestrian uses along adjoining streets should be limited based on the variety of activities spread throughout the day and will not to exceed 100 attendees each, and children camp birthday parties shall not exceed a maximum of 35 per event, children. In addition, this should not be allowed during an event permit allowed under the rural event facility or festivals indoor-outdoor use permits. This would cause a burden on the adjacent and nearby streets. The location and number of street parking spaces. The location of off-street parking are scattered around the approximate 18 acres. There are 12 spaces near the western portion of the site and an additional 6 spaces to the north of the 12. Based on aerials, the 6 spaces appear to be where trees would be cut, but based on the overall tree canopy coverage, it would not impact the overall site if they were located there. In addition, there are 37 spaces located on the north, central, and eastern portion of the site, of which portions of these spaces are located within the required 100-foot setback for activity areas, which includes parking. It appears that these are sufficient room to relocate the spaces that are within the 100-foot setback as required in the ordinance. Staff notes that the agricultural-related activities use permit does not have a specific off-street parking requirement, but staff will use the same requirement as a rural event facility use permit, which requires 1 space per 2.5 attendees. The applicant has indicated the maximum number will be 100, and therefore 40 parking spaces will be required. In addition, there are 2 other use permits being considered, as well as the existing winery, which may require that parking be provided for these other uses concurrently. The amount and location of open space. The proposed site, again, is adequate open space since there's approximately 18 acres, including a stream that cuts through it and provides a required 75-foot buffer on either side, as well as pastures, vineyards, and other open spaces. 7, protective screening. It is staff's opinion that existing vegetation is located on the property and in most places located along or near its exterior property lines is sufficient to provide screening for the proposed 100-person. Well, this is not the rural event facility, but for the agricultural-related activities. Hours and manner of operation. The applicant has proposed the following days of operation: Sunday through Saturday, 8 a.m. to 9 p.m. Although these times are less than the allowed per the standards of the use permit, staff will recommend that a further reduction in hours of operation occur on Sundays, which should be 10 a.m. to 7 p.m. on Sundays. This will be reflected in the recommended conditions. The applicant has not indicated any additional lighting on the site except if lighting is required for life safety and will comply with the night sky ordinance. Lastly, ingress and egress to the property. There are 2 existing curb cuts on the property along Bethany Way. A future curb cut will be built by the city at the time of the new roundabout completed on Hopewell Road in Bethany Bend. The number and location of the entrance and exits will be sufficient for the use unless otherwise shown through a traffic study required by the Public Works Director. In conclusion, if approved with the recommended conditions, the proposed agricultural-related activities use permit is consistent with the City of Milton Comprehensive Plan Update 2016 and objectives. In addition, it is staff's opinion that the proposed use provides a way to help preserve the large lots within the city and contribute to the overall rural character, if approved with the recommended conditions. Therefore, staff recommends U21-01 be approved, conditional in addition to VC 21-03 parts 1 and 2. So I'll step through the recommended conditions. To the owner's agreement to restrict the use of the subject property as follows: agricultural related activities excluding exotic animals, kennels, and overnight camps or events on 18.027 acres. The next condition is just speaking to being substantial compliance with the site plan as well as other requirements at the time of development or seeking certificate of occupancy. 3, to the owner's agreement to the following use requirements. Days and hours of operation shall be the following: Monday through Saturday, 8 a.m. to 9 p.m., Sunday, 10 a.m. to 7 p.m. B, there shall be no more than 100 attendees for any single event and up to 35 children for camps, birthday parties, and educational events. C, limited farm animal petting primarily associated with other events, no more than once per week for a limit of 3 hours of the barnyard experience. Maximum continuous sound levels of 60 dBA and a maximum peak of 75 dBA at property lines. To the owner's agreement to the site development considerations, A, provide adequate temporary bathroom facilities, including handicapped accessible, until which time permanent bathroom facilities can be provided. Said facility shall be located at least 100 feet from any property line out of view from Bethany Way or Hopewell Road. Trash receptacles shall be located at least 100 feet from any property line. Allow the existing feet from any property line. Allow the existing parking areas, wood pavilion, horse arenas, and driveways within the 100-foot activity setback. Allow the structures housing animals to be located within 100 feet of a property line. So let me go back to C, but excluding the parking. Oh, well, it's existing parking areas, it's okay, but the proposed parking areas, I'm seeking not to be within the 100-foot, so not adding to that. 5, to the following requirements, dedications, and improvements. Access to the site and frontage improvements shall be subject to the approval of City of Milton Department of Public Works prior to the issuance of a business license, land disturbance permit, subdivision plat, or certificate of occupancy, whichever comes first. Entrances and frontage improvements shall conform to Chapter 48, streets, sidewalks, and other places, and Chapter 64 zoning of the City of Milton Code of Ordinances. B, if at such time the Director of Public Works determines that traffic generated by the site impacts the operations of Bethany Way or Hopewell Road, he or she may require the owner to conduct a traffic study to determine if the development warrants any additional improvements at no cost to the city. If improvements are determined to be warranted, owner shall install these at no cost to the city. And last, C, a stormwater management concept plan shall be submitted and approved by Milton Public Works Department prior to the submission of a land disturbance application, if required. So those, that's the staff presentation for the first item of U 21-01 VC 21-03. So I am open to any questions you may have for staff.
Anybody got any questions for staff at this time?
I'd like, Chairman, I'd like to ask a maybe preliminary question of legal. There it speaks of the grandfather clause. Is it or does it supersede at this time our ordinances?
The concept of a grandfathering means that at the time a use was begun, it was a legal use under the ordinance as it existed at the time, and it contemplates the fact that the city may have changed the rules, but the use is allowed to continue. That use is considered grandfathered or a legal nonconforming use. I haven't made it. That's a decision that's made with each particular use in each particular situation for each particular owner, and you have to go back and look at when did the use start and what were the rules in place at the time to find out if the use was allowed at the time. And I haven't done that analysis for this particular property for a particular use.
Doesn't that then leave us in a position of moving forward here? This, as far as not knowing that the ordinances that we pass or deny, those were in the grandfathered clause, they could maintain and do whatever was in those?
Well, I'm not sure about that application. I'll say in this case, I know that there is a dispute or a difference of opinion between the property owner and the city as to whether or not certain uses are applied. What the city has advised is that if a use permit were applied for and granted, that the uses would absolutely be allowed, and they suggested that the property owner proceed with obtaining those use permits to make it clear that is a currently allowed use pursuant to the use permit. So this would make it abundantly clear whether or not the use is allowed.
Okay.
Any other questions for staff? Done? Okay. Hearing none, Robin will allow the applicant to go ahead and make their presentation.
I'm going to read if that's okay. I'm going to do it in my reading here. So, good evening, Mr. Chair, Planning Commissioner, City staff, and my fellow Milton residents and neighbors. My name is Pamela Jackson. I am a long-term Milton resident residing at 2105 Bethany Way since 1991. I am the trustee property owner. I started my family here in unincorporated Fulton County when my then husband and I built what is known as the Pamela Farm at 2105 Bethany Way. However, my family's roots are deep in this community and started well before 1991. I actually grew up around the corner from Bethany Way in our family home on Haygood Road, and my daughter, son-in-law, and grandchildren still live in that home today. Our family has always loved this rural oasis and its close proximity to the city of Atlanta. My 4 children were raised on Pamela Farm. I have welcomed my first 3 grandchildren at this home. I have also endured a life-changing divorce in this home. And through much hard work, personal sacrifice, and the love of my family, I've grown my home into a thriving working farm that has preserved almost 20 acres of land from development. I come before you this evening as a part of the city's special use permit application requirements for activities that I have long believed are tied to and complementary to my equestrian farm and farm winery. I will allow my attorney, Ellen Smith, to focus on the details of the applications while I share more with you about my family's working farm. Our love for horses, animals, and farm life blossomed after moving into our new home. My daughter Juliet took her first riding lesson, and we knew she'd found her passion. We quickly realized that having our own equestrian facility made the most sense, and we set out to establish a working farm with the first horses arriving in 1996. Our working farm and vineyards now employ 26 people, 6 of whom are full-time. 8 of our employees are Milton residents, with one of those being my daughter, Juliet, who is responsible for our equestrian services and overall farm management. Being a part of this community long before Milton would incorporate in 2006, I was overjoyed when I learned that we'd be breaking away from Fulton County, and that the very reasons we love this area so much were the same reasons that the community sought to incorporate Milton: a desire to preserve our rural equestrian heritage and preventing overdevelopment. The community decision in 2005 only reinforced and invigorated our efforts to create a thriving working farm that could successfully stave off another 15 to 20 home development project. And if we could be successful with a small working farm, others could be too. And we'd have an even greater chance of saving our equestrian farms and discouraging the development of yet another subdivision. I am committed to preserving what makes Milton so special. That's why 20 years ago I applied for and received CUVA approval from Fulton County. By operating a thriving equestrian farm and vineyard, my family and I hope to preserve precious green space, do our part to retain Milton's equestrian population, and support Georgia agriculture and community education. As a long-term resident, mom, and grandmother, I want to build a strong community and be a good neighbor. As a small business owner, I want to preserve these 18 acres through a strong business model. As a Milton taxpayer, I want to do things by the book while receiving fair treatment and proper recognition of my agricultural and business operations that predate the city. I want our farm and winery to be something that all Milton residents can enjoy and be proud of. We are home to 24 horses. 12 of those are Milton horses. Over 100 Milton residents take riding lessons with us. We have hosted approximately 600 birthday parties for North Fulton children over the years. And countless Milton residents have enjoyed us for wine tastings, enjoyed picnics under our trees, and visited our animal petting areas. The Painted Horse Winery and Vineyards was Fulton County's first official farm winery. And I am actually the first woman in the history of the state of Georgia and in the entire history of the state of Georgia to have been sole proprietor of a winery and grown it from the ground up. Now, my family and I adore this community, and we love our family. We're human just like you all. We have made mistakes along the way, both in business and in life, but our love for Milton, our equestrians, and our farm winery is unwavering. And it is our shared love of Milton and commitment to preserving land that I hope will help bring these applications to successful completion. Thank you.
Good evening, Planning Commission members. I'm Ellen Smith. I'm an attorney with Parker Poe. My address is 1075, and I can't get my flash drive to go in here. 1075 Peachtree Street, Suite 1500, Atlanta. I have the pleasure of representing the applicant. And first, I have to say thank you to you all and to staff. Has been a discussion for almost a year now during a COVID year, and staff has spent a lot of time on this. The city attorney has, and I know you all have heard from us previously last summer when there was an application. Actually, it wasn't an application, it was a text amendment that was contemplating beer and spirits being a new use permit. That was withdrawn. We went back to the drawing board. None of the applications before you include any new alcohol licensing or permitting. So just because that has been a question, I wanted to make sure you all had heard that. I appreciate your time this evening, and you think lawyers get paid by the word. When you write something like this, I think your staff should get paid plenty by the word for the staff report. We can go through those technical things. I think what this will show you, though, is how difficult it is to write something that we believe already exists. So one of the concerns is, are we trying to expand? With respect to this particular use permit application, which I'll describe as the children's activities one, right? That's what staff has kind of called it, and we sort of agree. Things that are like children's birthday parties, things that are like, all of the other things that we've listed. The things that are listed in the table of uses are things that have been done on site. Your question was about legally non-conforming uses, and we do disagree with the city on that, and that's why we're here. We're here to clear the air, make sure we're addressing those, and move forward. So with respect to this limit of uses, it's one of those things where it's really hard to define all of the things that could happen on a farm that would be considered agriculturally related uses. The city's code says agriculturally related use, or activities rather, include things like a petting zoo, include things like, I'm not going to get it right, what's the word? Picnicking. Yes, we picnic. Pay fishing. No, we do not pay fish. We are not a dude ranch, although if you're an equestrian facility and that's a permitted use, it's kind of hard to know what you would call a dude ranch. So with respect, I would suggest to you, it might be easier to say what we are not. And that is for the reason that you have the proposed limitations, no exotic animals. That's because that is a particular category of use that the city's zoning code has. No overnight camp. It's because that's not what we do. We have had day camp for many years. This will be our 19th year, 19th summer, if we're allowed to move forward, having summer camp. So all of the things, and I take full blame, if it was not clear in the drafting, please blame me in the application. It was intended to present what uses are agricultural related activities based on the current ordinance as written and what those uses have been to date historically. I am more than happy to answer any questions. I did want to just point out a couple of things just so you're seeing it, and I can pull this up very quickly just to give you an idea. So the yellow highlight is the property. We do not have, I'm sorry.
We're coming
out of
upon
town?
10 minutes. We're about 15 seconds from 10 minutes, so if, I don't know.
Okay.
Pleasure.
Do you want me to just wrap it up?
You let me know, how much time do you think you may still have?
Maybe 2 or 3 minutes?
Okay.
And obviously, understanding that will be added to,
And then also, I
Opposition
believe
as well.
the procedure is anybody in support would also be included on the applicant's side as well.
Sure. Right. And for anybody in favor of that timeline is going to be a part of the 10 minutes? Or is that going to be on top of, or?
It should be
Part
whatever
of.
you add, would be as a total, the applicant and anybody in support.
Sure.
So we have quite a few cards of people in support who want to speak.
Okay. Okay. So let's do this first. Let's, if there's any motion to allow the applicant's attorney to finish her remarks, we can take that at that point. And then after that, we can decide about how much more time for hearing everybody else speak in the public. Do we have a motion to allow the applicant? Do we have a motion for 3 minutes? 3 minutes good? 3 minutes?
yes, sir.
Okay. I'll make that motion for allowing 3 more minutes. Commissioner Edwards has seconded that motion. All those in favor say aye.
Aye.
Opposed? Okay, you got 3 more minutes.
Thank you. I appreciate it. We also get paid by the hot air that comes out of our mouth. So just to clarify a couple of things on the site plan, I think Robin mentioned there were 2 curb cuts on Bethany Way. There are 3. Those exist. There are also 3 on Hopewell Road. Those exist. There are no planned changes except with respect to the city's roundabout that is coming. So I did just want you to hear that from a traffic perspective. There are also no proposed improvements with respect to any of these use permits. So just to be clear, with respect to the variances that have been requested that Robin detailed, that is for existing parking and existing barn structures and existing animal housing. Anything that is built after that would have to come before the city for a use permit, for a building permit, land disturbance permit, and would comply. So no, not looking to improve or infringe upon any of the setbacks. We did hear, a list of concerns at the community, at the CZIM, the public participation report. Those concerns related to traffic, noise, safety of people entering and leaving the property. They did not reflect any concerns with the proposed activities that are the subject of this use permit. The use permits that you're hearing tonight are listed in order of intensity of use. So this one is the least intensive use, and frankly, the one that we think is the most grandfathered, if you will. So just wanted to highlight those things. I should say this too. We do have a number of folks supporting us. They are all wearing blue shirts for the most part. So even if they didn't fill out a speaker card, please thank them for being here and recognize their support. I would say too that there has not been, I think I'm right in saying this, one of these use permits issued by the city. So there are other farms in the city that historically were in unincorporated Fulton County that have birthday parties, for example. My understanding is there's not one of these, so we're the first use permit. To that end, we are happy to accept the staff's proposed conditions. With one tweak, we would like the hours on Sunday to go to 8 p.m. because if you have a child's birthday party on Sunday afternoon in the summer, 8 p.m. might work as opposed to 7 p.m. With that, I'm happy to answer any questions that you may have. I appreciate your consideration of this application, and I thank you for your time.
Thank you.
You happen to mention the roundabout?
Yes, sir.
Was one of those entries, can't see it from the plan because you didn't know at that time about the roundabout, but that Bethany runs directly into that property with a gate.
Yes, sir.
That be an entry off of the
Roundabout, yes, sir.
roundabout?
And that's being discussed with the city. I think there's an active proceeding taking place, but
Okay,
yes.
But that include that in the number?
I did. There's also a driveway off of what used to be Scott Gronholm's property, so that's the house that you see on the screen here. The city has already taken that that right of way and will be demolishing that house as part of the city's activities.
Now, I mean, I know this is an issue, obviously, in the discrepancy in terms of difference of opinions and the whole concept of what may or may not be considered to be grandfathered.
Yes, sir.
So could you just state your applicant's position as to why you believe, these certain uses are potentially already grandfathered in and that you don't technically need another use permit for this, or a use permit for this, I guess?
I can. I would respect Mr. Fricke and say we're here before you to ask for this use permit anyway. The reason that we think it's grandfathered is it's been happening since the late 90s, and it's been happening. Our position is that Fulton County, obviously the city was not incorporated at the time, the city adopted Fulton County's zoning ordinance and obviously has made changes over time, but these use permits, this particular use permit was a category that was in effect in Fulton County. We're not the only farm that's had birthday parties, for example, in the city of Milton now, and no one has a use permit to do that. So it's not that there was any intent to do something without a use permit, it's that no one thought one was required.
Okay. Anybody else have any questions for?
So you planted an additional 4 acres of vineyards in 2019.
This year, we will be planting an additional 4 acres this year.
Well, you're going to plant an additional 4. How many acres of vineyards do you have now? One and a half to 5. Okay.
Yes, sir.
No, I had some questions in regards to, what you guys are proposing in terms of number of attendees that are going to be on site. And the way it's written, it's stating that it's per event, or, let's say 100 attendees per event. So is your intent that you would only be having one event that could have a maximum of 100 attendees, or would there potentially...
Under this use permit, yes.
Or would there potentially be multiple events going on at the same time, and each event may have a certain number of attendees? Basically, what I'm getting at is...
An aggregate limit.
Yeah, exactly.
Yes.
Is your intent that the aggregate limit would be 100 attendees on site at any one time, no matter if it's one event or 5 events?
It isn't drafted that way, but we're not opposed to it.
Okay.
And the reason that I say that is, and it's hard, you could have a wedding, which would be under the next use permit category that we're talking about, in the morning on a Saturday, second wedding, whatever it is, but also have 3 children's birthday parties staggered later that day. Or you could have a book club meeting, and we're talking about 18 acres. You could have a book club meeting or a yoga class at the same time you have a wedding. We're not opposed to a limit or to drafting something that addresses that concern. It's a challenge of how to put it forth.
And you obviously would understand, the concern that
Yes.
community members would have in terms of having,
Absolutely.
let's just say a lot more than 100 people. If you have 100 people just at a wedding, and then you've got 2 birthday parties going on, and there's 35 people at each of those, and you have something else going on, all of a sudden you've got 200 plus people.
I do, and we do, and I think that the challenge has been, how do we craft a written condition to address that? And so is it that you say there won't be more than 150 people over the 3 use permits? Or do you say, it's not an opposition to it, it's just we're trying to figure out the best way to address it.
Now, how many, again, if this was allowed and the variance was allowed or granted or whatever for what's existing in terms of the parking situation right now on the property, how many parking spaces would there be available right now on the property?
So I didn't get to this, and I don't know if you can see it, but this is by no means a traffic or a parking circulation plan. There are already existing parking spaces that are either paved or graveled that are permanent parking spaces. There are also parking opportunities in both of the horse arenas, so all of the gates open up. If there's a large event, they can happen in the horse arenas. So that this is intended to show you, and I will say this, this is very rough. It is not intended to say we won't meet the setbacks with respect to the 100 feet away, but there has been parking on site for up to 250, 300 cars or attendees. That doesn't necessarily mean the same number of cars. So what our plan is to have Kimley Horn, who did our site plan, also provide a better diagram for you, for the city, of where parking should be, but to meet all of the city's parking requirements, not to seek any variance with respect to them, except for those existing ones that currently are within the setbacks. The other thing that I should have said, and I apologize, one of the concerns that we heard, certainly from the Bethany Oaks subdivision, was off-site parking. We have taken steps to address that as well, both with respect to asking off-duty police officers and parking attendants when we have an event to request people park on site and to put out on social media that there's no off-site parking. They should not be parking on neighborhood streets or in Bethany Oaks pool or common area. Part of the challenge is there are people who live in Bethany Oaks who live in the back of Bethany Oaks. They drive and park their car as they can and should in their own common area, and then they walk over. So we can't necessarily police who is parking there, but we can ask people to park entirely on site. The other thing those parking attendants and off-duty police officers are asked to do once we hit capacity, they turn people away. And they do that now. They're instructed to do that now. They close the gates. You can't come in.
So right now, in terms of what's currently on site and what you're seeking a variance for, how many parking spaces are those?
I didn't bring my good enough specs. Robin, do you know I'm sorry, I should know that off the top of my head. It's on it. 55.
55 parking spaces?
I think those are the striped permanent, they're either permanent or already improved spaces that are delineated on the site plan. That doesn't include parking in the horse arenas and in the other locations that are shown on this highlighting.
And those parking spaces, quote unquote spaces that are in the horse arenas and all of those, are those already in compliance, or that's going to be a part of the variance because they're in the setback?
The horse arenas, I think one of them is located within a setback because of the way the corner property goes. I don't know if you can see it a little bit better. There is an arena that is close to the corner piece of property, closer than 100 feet.
Okay. And so just quickly, so Robin, is that a part of the variance request?
It is.
All those parking spaces as well in the horse arena?
So what I spoke to was the striped parking, but I do see new created parking spaces within the 100-foot. That's why I made that recommendation. There are some existing that are outside, but there's also some proposed that are inside the 100-foot.
That are shown on this site plan.
Correct.
And our proposal is to revise the site plan to take those out of the
So I
100
need
feet.
just to clarify that, because
And-
there was
and
on the site
I will
plan
clarify that.
encroachment of new parking spaces. they're delineated. So I think the intent of staff is, if you're going to have parking, we need to see all the parking, not just.
And we don't disagree with that.
In the parking that you circulated today with the colors, does that include the permanent parking that is there now, or is that permanent parking in addition to what you circulated today?
When I look at this parking, I don't include any parking spaces that might be used in the arena or other spaces. I was just basing the calculations and the summary and explanation off what is shown of those 55 spaces that are either existing or proposed. But again, the applicant's attorney is saying that they're going to relocate the proposed parking spaces.
And we're
Let me just
prepared
ask
to
it this
submit
way.
a revised.
How many of your parking places are you expecting to have on this facility?
I think whatever is required by code. So depending on, and I say that because I understand your question. We're proposing limits on the number of attendees, and that has changed per use permit since we filed the application. So if we are now asking, for example, in this use permit for 100 spaces, the city's interpretation is, or 100 people, attendees, the city's interpretation is that's 2.5 spaces per attendee, 40 spaces. I would tell you, I wouldn't base it on 2.5 spaces because this use permit is generally children. But I respect.
The plan that was circulated today had 210 spaces on it.
Okay.
And when you multiply it by the metric used by staff,
Yes, sir.
you come up to 525 people in attendance. The capacity that allows you to have 525 people there approximately. Is that the number of people you're expecting to have on this property at any given time?
No, and that's why I say.
What do you expect to have? What's the maximum you're looking for? Then you don't need all these parking places.
No, but I don't disagree, and I'm not trying to frustrate you. It's not an easy answer because we are still proposing limits on the number of attendees. So what I would say is we'll provide parking if this board and the city says you can have no more than 250 people over all the use permits total, or 200, then that's what we'll provide the parking for without reduction.
That's fine.
Mm-hmm. So we had 3 different iterations of what you're trying to permit here. And just to keep my simple mind straight, this first one is just to permit what you're already doing now. The farm winery, the equestrian, the birthday parties, that kind of stuff.
To be clear, the farm winery is a permitted use. That is not part of this application.
Well, it's listed here as one of the existing uses.
As a permitted use. So is the single-family residence.
So
But
this is...
Your question is, are we looking...
Attorney, just hang with me for a second here, okay? I can explain what I'm trying to get to. So this is something that's been going on for years.
Sure.
And you've got a winery, you've got horses, you've got a petting zoo. And what I read was on occasion, there's background music.
Yes, sir.
Okay. So that sounds very calm, and enjoy your glass of wine and listen to a acoustical guitar in the background. Why do we have all of these music decibel limits and that sort of thing? Does it get kind of crazy back there?
We have those because that's the city's code. For this particular use permit, there's a city decibel level that is in the city's code.
And there's been no issue with that?
My understanding is with respect to these activities, there's been no issue with that.
No complaints?
There have been complaints with respect to noise. Those have been with respect to the use permit that is the third item.
See, I'm trying to keep my mind focused here on what we're looking at right now.
I appreciate that.
Because to my way of thinking, for background music, this should not even be an issue.
I don't disagree.
I know it's an issue in the later one,
Yes, sir.
but in this one, it should not be an issue.
Yes, sir.
And parking. So you say for these uses, the most you're going to have is 100 people.
Yes, sir.
That requires 40 parking spaces.
Yes, sir.
You have those.
Yes, sir.
So we don't care about the 55 or the 100 or any. If you, just for this particular application, you're covered.
Yes, sir.
I guess I've got a couple quick questions. One is, for the parking areas already existing, as well as the structures housing animals,
Yes, sir.
do we know when those were built?
They were built at different times, and I can give you a timeline
I guess I'm looking at this, those variances are pretty easy for me.
before the city was incorporated.
Exactly. So all the things we're asking for on the variances were built before the city was incorporated. Can we check that? I mean, not that
No.
and then also, it looks as though, for this, we're looking at primarily children's. This is primarily children's activities.
That's been the city's interpretation, yes.
And I think I read somewhere where you're allowing 6 to 8 of these events a weekend, plus more during the week.
That's correct.
So you could have.
Not at the same time.
Right, but so, for example, on a Saturday, you could have 3 or 4 parties rotating through.
Children's
which would be,
birthday parties.
another 300 or 400 people coming and going on both Saturday.
And that has been the case for 20 years.
They've had an average of 3 parties. I guess that's the other question I have is,
Yes.
how many birthday parties have you had over the last, when did they start? We thought a total of 600. Was the number that was thrown out earlier. So that's 20 years, that's 30 a year. And we're looking at 8 for a
More
weekend.
than 20 years. So I didn't do my math well. My dad, who's a mathematician, would be dismayed. But the birthday party started in 2000? So
2000?
your daughter Juliet, who operates, knows.
Okay. So let's use 2000. So that's 20 years, you've had roughly 600 birthday parties. That was the number that was given. So that's only 30 a year, according to my math.
Well, it doesn't mean that there are going to be 6 to 8 every weekend. That's
I know, but I'm just saying, if we're looking at saying, I want to grandfather in what we've been doing, it should be quantity too, not just activities.
okay.
So that's what I'm trying to figure out, in adding, 400 people a day or 800 people over a weekend coming and going at the max. And again, we have to look at it from the worst case, right? We have to look at it.
I don't disagree.
Okay, so you've got 800 people on a weekend, added traffic to what's going on without that. And again, if we have some idea of how many you've had historically, then we can say, 800 is no big deal. Or we can say, boy, you've only had 1. That's a big difference. So that's what I'm trying to get my head around is how many have you typically had historically and the numbers. And again, the 600 that was given to start over 20 years only says 30 a year, and we're looking at more than that a month.
And I think there could be a limitation on the number of events in a day or in a week or in a month, if that's the desire of this board and the council.
Because again, just doing the quick math too, if you looked at, I'm jumping ahead, if you looked at all 3 of these, at any one time between like 8 a.m. and 9 a.m., you could have 100 people on. Between 9 and 4:30, you could have 200 people on. From 4:30 to 9, you could have 400 people. And from 9 to 11, you could get back to 300 people.
So, yes, as written.
Exactly.
Blame me for that. So the goal, and I've said this, and I respect the help for crafting something to limit it. Children, 35, Boy Scout, Girl Scout, we're now Scout, 35.
Plus parents. Get them there.
If they drop off. But those 35 kids aren't driving themselves,
Right.
most likely.
Hopefully not.
Okay. They might be if they're Eagle Scouts, right? So that kind of event, I don't think for children's birthday parties, the number has been 35. Juliet can correct me, that's 10 to 12? It's 10 to 12. So when you hear 600 birthday parties, that's not 600 times 35, that's 600 times 10 to 12. I'm not trying to slice and dice it too thinly. We're trying to be transparent about what has happened historically, and we're agreeable to a limitation, whether it is number of attendees, whether it is time of day, whether it is number of events per day.
Great, because, I mean, again, we have to go by the way this, this has been written, and again, we have to look at worst-case scenarios. And again, I really think when you look at almost everything I've read, almost everybody agrees that for the current uses, it's great. Everybody says it's one. I think for that part, the way it's been done, it's an asset to Milton. The concern I have is when you start looking at ramping this up, and the numbers can get out of hand pretty quickly. And so that's what I just want to be sure we're just aware of.
We gave you the worst case on what has happened on a Saturday in the past 20 years, because that's what you need to hear.
Right. Okay.
Yes,
While
sir.
you're there, Robin, do we include horse shows as event?
No,
So it's not covered?
not part of this use permit.
Not part of this?
Oh, yeah, we still have
Thank
everybody. I've got a couple more questions on the, the proposed, I guess, uses. And so, one was summer and other school break camps, birthday parties. And the next one was agricultural, farm, equine-based, educational events, boy, girl scouts, and then my question is, in trying to understand, when it says, or other community or church organized events, and what were you all envisioning that to be?
So, to be clear, this list is what has happened in the past. So it could be a church Bible study. It could be vacation Bible school. There have been, and that's why I said the challenge is saying what is there. This one is not, this use permit is intended to encapsulate without expansion historical uses. So, I thought you were going to say something. So it may be easier to say what we can't do rather than the type of use, or to address the concerns, whether it's traffic, by the number of people, irrespective of the use, if it meets the city's definition of an agriculturally related activity, which is open.
Because you're saying that, in terms of that definition of agricultural-related activity, per the city, what is it per the city?
It is, I just had it. It's broad. It's things that included petting zoo, picnicking,
Dude ranching.
fishing, and other. There's a catch-all at the end.
So it is the intent of this division to allow certain agricultural-related activities with a use permit in compliance with the development standards below to preserve the nature of agricultural areas. Such uses shall include, but not be limited to, petting zoo, educational tours, dude ranches, picnicking, and pay fishing.
So if you wanted to say educational tour instead of whatever language I had, educational events.
So in your opinion, based on that definition and, what's considered a catch-all, and again, I'm just generally asking this, are these, again, I'm all about birthday parties and everything for the kids or whatever, that's fine with me. But anyway, what I'm trying to get at is, it seems like the intent was for these activities to be agricultural related. And so our birthday parties and these other kind of, other school break camps and, art-related events or whatever, are all those, in your opinion, considered agriculturally related events?
As they have been operated by this applicant historically, yes. So birthday parties are typically tied with a pony ride or a horseback riding lesson. The Boy and Girl Scouts events have badges associated with either an equestrian use or with respect to an agricultural use. Summer camp, same thing, has an equestrian component. They go out and pick things that are growing. That includes figs. There is an apiary. There are any number of agricultural uses on this working farm. And so, yes, they're not just parties where kids are running around. They have activities that are agriculturally based, and they are all outside as well.
So even, the Bible studies, the Bible camp, and whatever else you're talking about in terms of what's considered community or church organized events.
Baby was born in a manger.
Again, I'm just trying to.
I'm kidding. Sorry,
I thought you were going to go for the loaves and the fishes myself.
I haven't personally been to a church event, but if there are Bible study, yes, they have been outside. I'll also say, it is not a perfect thing. We are coming before you to say, this has been in discussion with the city on where do these things fit. With all due respect, we suggested a while ago, maybe we should have a different use permit or revise the ordinance. That did not receive welcome contemplation. So we may be trying to fit a square peg in a round hole, but this has been based on, we came in, our first meeting with the city was, here are the things that we use, and here's the timeline, and here what we do, and how we have done it historically. And we parsed through those activities. So are church activities agricultural? I think it depends on the pastor you speak to.
Right, and again, that's where I'm trying to get at, because I'm trying to understand what we have per the city code, and, are these activities that you're wanting to have or already having, are they all agriculture related or not? Because then if they are not, then again, I think everybody would agree that that's not what the intent was, and it was the intention to be agricultural related activities that, come along with the farm license. Okay. So again, from your standpoint, from the applicant's standpoint, you have no preference or no recommendation in terms of, number of attendees, number of events that are going to be on the property. You're okay with,
No, we
coming
have,
up with some sort of, something with the city where, okay, we've got a limit on the number of attendees that may be on the property, potentially a limit on the number of events that may be on the property at a single time, single week, single month, single year.
we have proposed a limit on attendees. We've proposed 2 limits on attendees for this use permit, 100 and 35.
Right.
I have no problem.
But your 100 was per event.
Correct.
But you would be okay if it was an aggregate cap at 100. So if you have 10 events at one time on the property, you can have no more than 100 people on the property.
We would propose 250 as an aggregate max over multiple use permits.
Okay. And then that is going to be about, let's see, how many parking spaces?
5.
2.5, so okay.
100.
Yeah, so 100 parking spaces. And so,
No,
go ahead.
you're asking me to throw out, I think that there can be, with respect, I would say we could go back to the drawing board. I would also, though, say that not one of the opponents to this or the complainants have had a complaint with respect to the activities or the intensity of these activities that have happened historically.
When you say intensity, what do you mean?
Days of the week, hours of the day, number of events per day.
And you're talking about these, what's
This
considered
use permit.
this use permit, the children's activities.
Yes, sir.
Okay. Right.
Well, that's where I guess I'm still confused, on the numbers. At one point, we were talking about 600, and it was 10 to 15 people per party.
And I'm not saying we're not willing to address a cap on the number of attendees or under these 3 use permits. Absolutely, at a given time.
So
I don't know what that is. at
And
this
again,
point.
if we're looking at continuing what you're doing now, we don't know what that is. I mean, are there any records of what number of birthday parties you've done? So if we're looking at continuing
Yes,
what's
we've given
in
you the
place.
maximum. So 6 to 8 birthday parties on a Saturday with 10 to 12 children per party.
So every
on a
Saturday, well, I
Saturday.
mean, now, again, what we're agreeing to is every Saturday and every Sunday, or we're agreeing to 6 to 8 a weekend, okay?
No, you asked me, do you have historical data? And I'm saying that has been the maximum. I understand what you're saying. Let us come back then with a proposal on a limitation overall for number of attendees and number of events per day or per week or whatever the metric is. I don't think that what we've proposed addressed that concern.
To me, it seems it's the issue of what goes on in one day.
Understood.
No, if it's a Sunday and you've got 350, 400 people, I would imagine that that's an annoyance for the people around you.
And I think we have our operations folks here, and they could give you a better idea than I could on what their staff would handle as a maximum, if you would like to hear from them.
So, and I guess, so Robin, so again, depending on how many parking spaces may be on the property right now that would potentially be granted this concurrent variance, if, and, you know, again, this also depends obviously on the whole number of people that we're talking about in events and, you know, everything else that goes along with that. But in terms of parking, if additional parking, if they needed to or wanted to put additional parking on the property, again, they'd have to go through the normal procedure in terms of adding more parking onto the property, you know, following setback guidelines and whatever else is needed in terms of putting additional parking on the property, correct? After what potentially may already be on the property now that may be a part of any sort of concurrent variance.
Correct. So my understanding is that the applicant has stated that any new parking, although the parking shows on the current, that they would revise the site plan to show any additional parking would be outside the setbacks, new parking, and that they would have to meet the rules and regulations as the engineer stated in his statement, saying that any additional surfaces may require land disturbance permit. There's all sorts of rules and regulations for hydrology and new construction. And I mean, it doesn't have to be vertical, but horizontal. So they would need to meet anything that's required of that as well.
Okay. And then, I mean, and I feel like, you know, this is also kind of a disagreement or whatever, but, you know, in terms of your presentation where you stated that, you know, 2.5 parking spaces per attendee.
Right.
You know, where did that?
So that came from, as I stated in the report, there's not, so there's a section of the zoning ordinance that calls out off-street parking requirements. This use is not listed for any parking requirement. So it was my decision and opinion that we would take the 2.5, which comes from the rural event facility ratio, and use that for this situation.
Okay. Anybody else have any other questions for?
Yeah, just one other quick one here. We were talking earlier about the catch-all phrases that you've got here, and we focused a bit on the church
Yes, sir.
activities. Adjacent to that are community activities.
Yes, sir.
Could you give us some idea about what those might be?
I think in my mind, those are the same as maybe boys and girls. They might be schools, right? So school field trips that happen on site. So not intended to, again, limit whether it's public school or private school or middle school or elementary school, but those kinds of activities.
So you aren't contemplating here in this particular use a community concert?
No, sir.
Thank you.
And we could stipulate that.
Anybody else have any other questions for Ms. Smith?
I got a couple questions for staff. Could I ask those now?
Yeah, go ahead.
Thank you.
So, Robin, on page 8 of our package here, in the allowing the existing parking areas, wooded pavilion, horse arenas, one of these is, there are such extraordinary and exceptional situations or conditions pertaining. What are those? You know what I'm talking about?
Basically that they've been existing for a while and that they're related to the equestrian type uses, those structures and facilities.
So then there's, in the fire marshal section, it mentions a 12,000 square foot structure to be fully sprinklered. What's that?
So they put it on the site plan, but it's annotated that that's for the use of the winery. So I think they just wanted to be, have full disclosure on the site that sometime in the future, they're looking to expand the farm winery to include this 12,000 square foot building. But it's not for the use of this particular use permit.
Okay. All I could think of is the horse arena or something.
Right,
Why
yeah.
you'd
No,
sprinkler
it's
that?
not. According to the site plan, it's for the use of.
Yeah, I did see
winery.
that. I didn't know that referred to the winery. And then she asked about this Sunday hours being extended to 8 instead of 7. Does that pose a big problem?
It's up to you and what your position is. I mean, I don't see it as unreasonable. I just thought that the original timing was pretty late for every day. So whatever is your desire to recommend, but.
So the rest of the days, it's until 9, but on Sunday, 7. Fewer hours on Sunday.
Anybody else got any other questions for staff before we move to everybody who wants to comment in favor of this in the public? Do you know how many comment cards we have for in favor?
$13.
13. So, I mean, just in terms of,
13 for this.
Right.
yeah, that's what I was going to ask. So that's 13 just for this particular use permit only?
Yeah.
Okay. Okay, there's still an opportunity. If anybody else has not filled out a comment card and they want to make a comment today, please feel free to come up. There's the yellow cards over there. You can fill those out. We're going to allow everybody an opportunity to speak. Vote on it. There's not going to be any sort of a vote or anything like that, but we're just going to have in terms of how we're going to proceed going forward right now, we're going to move forward with people who may be in favor of this application for the use permit, and then we'll also allow people who may be opposed to it to speak as well. But right now, we're going to move forward with whoever's in favor, and if they want to speak. And we're going to set a time limit for... No, the reason why I was asking for that is to just get an idea as to how long we want to set the time limit for.
I can say I'm against it. I mean, in favor of it as opposed to being opposed. I don't understand why it's hard to preach that.
No, it's not. This is some.
No, but that's why
We need to get some more cards.
If, there may be people who want to speak for each item.
Okay.
So they may want to speak for each item, so,
Samit,
comment to this.
I'm sorry. Why don't you take this chance to explain, those in favor? It's for speaking only. Those in favor, it's not a vote. It's just we're trying to find out who would like to speak in the law.
Sure. Please, if we can have a little bit of order, please. The city attorney is going to make a comment.
Yeah. I just wanted to make it clear that at this point in time, we're in the public comment portion of this application. The state law and the city's ordinances require that those that wish to speak in favor and those that wish to speak in opposition have equal time. So the planning commission is attempting to get an idea of how much time to allot that both sides will get to speak in favor or against. The only reason to find out the numbers to figure out what that time might be. So right now, we're trying to get a sense of how many people are speaking.
The applicant's attorney stated there's just going to be one person to speak for in support.
Okay.
So we have 13 cards, and most of them said they wanted to speak, but they're just going back to one.
So as far as you know, there's one person wishing to speak in favor that hasn't spoken yet. Okay.
And represent.
Okay.
Take that into consideration if you wish. And right now, you've extended it once for 3 minutes. I believe that time expired. So if anybody else would like to speak in favor, you would need to extend an additional period of time, which would also be granted to those in opposition.
Mm-hmm. Okay. So at this time, I'll entertain any motion for a time limit for the person who wants to speak in favor of. Okay. So we've got a motion for 2 minutes. Anybody?
But before you do, can we make it clear that motion would be to extend those in favor an additional 2 minutes, and it would grant a total of 5 additional minutes to those in opposition to make it equal?
Yes. So again, we have a motion on the floor to grant an additional 2 minutes to speak in favor of. We had already previously granted an extra 3 minutes for the applicant to speak in favor of. So that's an additional 5 minutes that will also be granted to anybody who wants to speak in opposition of this.
Correct. Yes.
And so at this point, we have a motion on the floor for an additional 2 minutes to allow anybody in favor of. Do we have a second?
Second.
Second from Commissioner Edwards. All those in favor say aye.
Aye.
Anybody opposed?
Opposed?
Okay, we have one opposition. Okay, so that's 6-1, Robin. Commissioner Nolte opposed.
And I oppose because I don't think 2 minutes is enough. So that we can I guess I'm saying we can be extended after that too. Is that correct?
So it's a total of 15, I think, for the opposition.
For the opposition at this point, right. Okay. Okay, so if we can go ahead and have whoever has that public comment to be in favor of, they can please go ahead and come up. State your name and address for the record.
It's Nina Braun, correct? You wanted to speak? Okay.
It's just one person.
Yes. Right? Okay. Hi, my name is Nina Braun. I live at 15805 Thompson Road. So I've actually been at the farm at Pamela since I was 4 years old. That's when I started horse camp at Pamela. And then I started doing lessons at Pamela a few years later. And I have been working there since I was a young kid helping out. And I've been there my whole life. It has changed my life. My family has, growing up, I was never with, my family generations were never with animals. And Pamela has changed my life. It made my family move to Milton from Roswell because we fell in love with horses because of the farm. And now we actually own a horse farm. It has changed my career goals to be in agriculture and go to UGA next year from Cambridge High School to UGA to study agriculture and animal science. And it is such an amazing program. I help out at the pony parties and horse camp and lessons throughout the week. All the kids love it. They learn so much throughout the camp. It has changed kids' lives, especially mine and the people that I work with. Everybody has so much fun, and they get to learn about animals. And just to see how this farm in the 20 acres, 18 acres that it has, and is not changing into a development. My family had to go through this a few months ago about how a development wanted to come and take 15 acres and make 10 houses out of it and change what Milton is, because Milton is the horse community. And Pamela has been able to keep that ever since through her family, to keep the horses here. And it should definitely stay and be allowed to have horse camp and the music is all friendly. Everybody's friendly, and it's a community event. It really brings the community together.
Been 2 minutes. So.
Okay.
Thank you.
That's good.
Thank you so much. Okay, so we don't have any other?
No more in support.
No more in support, okay. So at this point, we're going to allow everybody who is in opposition to speak, and you had, initially 10 minutes, and then we'd already granted the side in favor of 2 extensions of 3 and 2 minutes, so we have 15 minutes in total at this point. Now, Robin, do you know how many comment cards you have?
So 1, 2, 3, 5, 6, and can you ask if there's anybody?
Yes, so
online?
is there anybody online on Zoom who has any opposed, or actually we need to go ahead and ask if there was anybody in favor as well. If you can please raise your hand. So first, we'll ask if there's anybody online who is in favor of, who would like to speak, please raise your hand.
Doesn't appear that there's
None, okay. So at this point, we're going to go ahead with, how many comment cards did you say you had?
no, this is opposition. It was like 7 or 8. Yeah.
Okay, so at this point, we've got 15 minutes for anybody in opposition of, and then, we can kind of see where we stand at that point. So, Robin, if you will go ahead and sound for the first person.
The first person is Tony Rich. No, it's first. So we're going to take a public hearing for each an individual use permit. So if you don't want to speak to the agricultural related event, then you can let me know that. Okay. Okay, so the next person is David Pritchard.
And if you could please state your name and address for the record.
David Pritchard, 2685 Bethany Creek Court, Milton, Georgia. I've known, we moved to Bethany Creek in 1995, and we carpool with the Jackson, Miss Jackson, Pam Jackson. It's great to hear the kids are going great. You have grandkids now. We don't. Very nice family, and they've been they've been nice, great neighbors. I moved out there 25 years ago, and was certain to see, I wanted to see cows and horses on the way home. It's tough to do that now, see them when you get there. I also have a 650-acre farm that I've gone around and around with the Corps of Engineers on a couple of years doing land use permits. So I can appreciate the Jackson's standpoint from, it's my land and I want to do what I want to do. But to be honest, over the last 25 years, I think they said they moved there in 1991. We've never had any issues. They've been great neighbors. Like I said, we carpooled kids together to school. I don't have grandkids yet, but I think that until recently, there has been no issues with them, but it seems like they're stepping up the commercialization of the farm, and maybe I'm speaking to the wrong permit here, but until recently, there's really not been any issue. I live in the very back, farthest you can get away from in Bethany Oaks, so I've not had any sound issues. But it has been recently that we said, what the hell is going on over here? So it's certainly, they've been great neighbors for all these years, no issues, but it just seems like they're ramping things up. And that's a very congested area as it is. So from our perspective, we don't think doing exactly what they've been doing is great, but if they continue to ramp up the commercialization of that particular piece of property, it's going to be difficult on that particular area there. So that's what I'd say. Thanks.
Thank you, Mr. Pritchard.
Okay, the next speaker is Joseph Knaus.
Good evening, Commissioners. I'm not Joseph Canals.
I'm Joseph Canals.
Right here. I'm Casey Sturm. I'm an environmental, land use, zoning, and litigating attorney with Weissman. Our offices are downtown Atlanta, Lenox Road, One Atlantic Center. I represent Joseph and Erin Canals as it relates to these issues before you today. I think it's important that you hear from all of these folks on the ground, so I want to be real clear right now. I represent Joseph and Erin. They live catty corner to the west of the subject property in the Cooper Sandy Cove neighborhood. So I represent their interest, but I will represent to you as well that through them I've also heard a lot from the community. And so some of the things I'll share with you are also things that we are hearing at large out in the community, okay? I'll let you, step aside for it. You wanna, let me add this. I'm gonna address some general legal things that I think are kind of a big deal as we kind of deal with this. And then I'm gonna ask Joe to come up and kind of talk about some of the on-the-ground issues that he can reflect way better than I ever can, okay? So from a legal side, what I wanna talk about is one, looking at this just from the nature of the questions that came out, and they were great questions. So I really appreciate that we have an engaged body here with lots of good questions. They were the same questions I had looking into this, and I will let you know I am last to the table, okay? Because I was only hired recently, so I've been put to the test to do a lot of scrambling in a couple of days to try to figure out what is going on, okay? So I want to represent that to you first and foremost. But in that, I think what comes out of this is that the approach here is problematic. We have a very piecemealed approach to what appears to be an overall scheme, right, of an operation. And so when I hear you say, and I hear Ellen represent, this is a children activities use we're talking about, I scratch my head and say, wait a second though, because it's part and parcel of this bigger operation that appears to be going on, right? And so when we get to these questions, when we look at what uses are authorized and what's not authorized, it's starting to beg the question, well, is something coming in that's not necessarily anticipated under this use only because it's not specifically prohibited? So let me start initially by saying, though, from a public engagement, public involvement spectrum. You heard me say I'm last to the table, but I want to be real clear that anytime we deal with public comment, the public is always starting out behind the 8 ball. And that's because a lot of times the applicant has the benefit of putting together their proposal. They know what they're seeking. In this case, it's abundantly clear, not only from the comments made today, but from me digging through your city minutes in a frantic way, that you all have had extensive discussions about what's happening. These folks in the community are given the 15 to 45 days to get their position together, to scramble to try to figure out what is going on, why is this happening now, why are there so many changes, why are we now being impacted, and why do we only have a short period of time to respond and get our ducks in a row? So I just want to raise that because it's a challenging position to be in, okay? And I also want to note for 2 reasons. One, none of us can overlook the elephant in the room that is this past year, the pandemic, right? The pandemic has been good for keeping down traffic, right? It has been bad for a lot of other things. And one of the things that has happened during the pandemic, and it's not unique to a particular area, we see it across Georgia, is that some of these land use decisions, these issues that come up, the public is even more at a disadvantage because they may not be traveling down that road. They may not be engaging in as many activities at city council or in their city community. And so they don't often pick up as quickly as they might originally to know this is happening. So it's a disadvantage. 2, in this particular case, I want to highlight that both the staff package as well as the applicant's position seems to suggest some kind of robust public engagement. And it seems to me from my discussions with my clients and from the folks on the ground, that's not at all what's happening. In fact, I've heard from several people that the public participation meeting that was held recently at the subject property, that several people who were within the vicinity to get notice from this body did not get notice about that meeting. So they did not have the benefit to attend and learn and engage and understand what's been going on. So there's a problem there. Another problem, and a big reason why that's a huge problem, is that there seems to be a huge disconnect here. There's a disconnect between what the applicant has put in the application, what the applicant contends has been happening, and what the public says has been happening. Now, I'm a native Georgian. I grew up in Roswell. I remember this area before, all of these areas before they went nuts up in North Georgia. But there are a lot of folks here, too, that have been in this community for a long time, and they're scratching their heads saying, I don't remember all of this activity happening. I don't remember these quote-unquote uses they're talking about being consistent and regular at this property. And most of all, there has been a distinct, observable change that this board and this body and this city has obviously heard about that took place during this pandemic, where all of a sudden there was a distinct change in use on the subject property, a change in use that had an adverse impact on the community at large. I raise that because you're in a tough position. You're always in a tough position. You're in a particularly tough position here because under your current and future land use codes, under your comprehensive plan, this is an area that's not only dedicated for equestrian use, for our agricultural use, but it recognizes the high value of these large lot residential holdings. That includes, and specifically identified in your comprehensive plan, these residential, high-value residential subdivisions with anchored amenities. So they've got their golf courses, they got swimming pools, they provide community benefits. And it says we want to continue to preserve those. They are a priority in this area. The roads in this area provide view sheds that we want to preserve. That is something specifically mentioned in your comprehensive plan, and which right now, what's happening at the facility is subject to be jeopardized, okay? One of the things I want to talk about is not only in that context of the distinct change, is from the community side, folks are saying, where did these ticketed music events come from? Because we don't ever remember this happening, okay? If you go on Facebook, you will see on Facebook a list of ticketed events. These are from massbigticketevents.com. You can go out there and buy your ticket. So these are promoted musical events. That is a distinct change from what has happened in the past. From a big picture perspective, I also want to talk about a legal issue that you all have kind of brushed up against. This concept of what is a grandfathered use and what is a legal non-conforming use and what is a vested use, right, or a vested right. And I think we have a real big problem here. And that problem is, one, based on the questions, I never heard a confirmed response as to what it is we contend is the grandfathered use, the legal non-conforming use. The other thing I would have to add is the tenets of law have a very stringent principle when it comes to grandfathered uses and when it comes to legal non-conforming uses and when it comes to vested rights. And that is, one, it had to be legal to begin with. Two, you are not enlarging or changing the scope or intensity. Here we have a problem because on the surface, the applicant acknowledges that they are expanding, both from a physical standpoint, the property is becoming larger, the conduct is becoming greater. And so it seems to me, and I know we're talking again about the children's, a lot of these concepts will go across the board, but we really can't pull them apart because it really seems to me what you're talking about is a new proposal. We are seeking to do a new idea on this property that embraces some of our older concepts, perhaps, but wants to enlarge both physical space and the types of uses being carried out. So it is a challenging it is a challenging issue to deal with, But we think it's a clear decision as far as where this body needs to go at this particular point in time, and that is that it is not in a position to be able to approve or take the recommendation of staff at this point in time. Our position would be that the only recommendation moving forward at this point in time, if you're going to take action, would be recommend denial.
Excuse me, we only have about 2.5 minutes for the total 15 minutes, and we still have a few other people to speak, but just to give that as an idea.
Thank you, Rob.
I will close up and turn it either to Joe or let him have others speak. I will note for the record, Paul, you can probably take it up however you want. We had it clocked as 15 minutes before you added an additional 2 or 3 for the in support.
I'm confident you added 3 and then 2 afterwards.
So,
Thank you for your time.
Yeah, thank you. Would you like to speak? Okay.
okay, we have Mr. Dudley Garrett.
Gentlemen of the Commission and Mr. City Attorney. The reason I said that, for 15 years I sat in Alpharetta City Attorney,
sir,
and nobody ever acknowledged.
Hold on one second for me. Sir,
I would do that
excuse me.
this time.
Sir, if you could please just state Sir, if you could please just state your name and address for the record.
Oh, I'm sorry.
Thank you.
Name is Bill Garrett, D. Dudley W. Garrett, Jr., 13450 Hopewell Road, Alpharetta, or Milton now, Georgia. And if you would, can I put that, it's on the board. If you can put that board up, show how, well, I guess, does it get up there? I can show you exactly where I live. How do you do that? That on the board? Yeah, okay. You see this line right down here? Right on the bottom, the long one. That's me. The little lady before me said that she's so old in Roswell, she knew all about it. I've been on that piece of property since 1975 when I built my house. I think I got her by a number of years. And I've lived there and practiced law in the state of Georgia and in Alpharetta since 1970. So that's where I live, and I am the most closely related person to the applicant in this case as anybody else, so I pretty well tell you what's going on. The first thing I wanted to say is that I understand that the objections to the situation here as far as people are concerned, and I've listened to what's been going on, and I've heard everything with the exception of talking to you all about what the actual statutes say and what you are allowed to do and what you aren't allowed to do. I know that under the statute and under the ordinances, you're bound by what the ordinance says you got to do. So I want to pick this up, if you don't mind. I'll take each one of the petitions one by one. The first one is under, the application for a permit for the agricultural related activities. Now that's seeking a summer school break camps for 250 people. Now the 250 people I found out before I walked in here has been dropped to 100 people. So that's, you can talk that way between yourselves. The other one is the birthday parties, I guess 100 people. Agricultural, educational events, 35 children. Farm educational events, 35. Equestrian educational events, 35. Art-related individuals, 200 or 100. And limited farm animal petting, 100. The four of the uses that I just read off, requested by the applicants, are in her specific plan,
Sir,
are already identified.
Sir, if you could just hold on for 1 second for me, because we are now currently at the 15-minute limit that I've just been advised by staff. So hold on 1 second for me, sir. So we're going to go ahead and, because I want to allow everybody an opportunity to speak today that has come here today. So at this point, let's go ahead and, is there any other motions that can be entertained for additional time for the opposition?
Are you cutting me off, sir?
No, I'm not cutting you off.
You get to still speak. They're just
I'm
adding
not
more time.
I'm not cutting you off. I'm just making sure that we've got the time marked as to how many additional minutes we're going to have to allow you to speak and everybody else to speak who's in opposition of this.
I have one more speaker after.
One more speaker after this?
Yes.
Okay.
That other speaker is an attorney, is it?
No, it's a homeowner.
More attorneys.
Hey. Attorneys are good. Okay. We have a motion.
To add 5 minutes.
5 minutes?
Can I make it clear? It'll have to be both sides.
Right.
Yeah, that'll be and then both sides will be getting that, of course. Okay, so we have a motion for an additional 5 minutes. We have a second here. All those in favor for an additional 5 minutes for the opposition to speak, say aye.
Aye.
Anybody opposed? Okay, go ahead.
I can see my 2 days' worth of work is going to go down the tube in a hurry. Okay, I'll try to do it as quickly as possible. Taking the first section, the agricultural and related activities, I hate to read but anyway, 4 of those requests are already in the ordinance. So there's no issue there. There's nothing for y'all to decide. They get that. The other 3 that they are talking about, which is the summer school, break camps, birthday parties, art-related events. That statute goes on to say that what it names as far as the first part is concerned, that these are included but not limited to. I think those last 3 that I read off to you would fall very easily in the not limited to. So there's no issue there, in my opinion. I think that's agreeable. It has to be agreeable with you. That brings us down to the issue in this case, which is the number of people in the situation. It leaves one issue, and that is they're asking for an authorization for 250, as I thought up until tonight, of 100 people to be allowed to attend the summer school and break camps, the birthday parties, and so forth. That's the issue for you to decide. There's 100 people on that. Now, the only thing I can testify to for that and would testify to is for what I've seen. 100 people coming in, assuming at least 1 car per person. Okay, that's 100 automobiles dumping in or coming in either Hopewell Road or Bethany Road and going out all at the same time. Now, I understand they have police officers up there to direct traffic, but that is a problem. And it is something that the neighborhood is having to deal with. Y'all don't have to deal with it. I do. Now, as far as that's concerned, Ms. Jackson has been holding gatherings and people over there for a long time, for several years, and there's never been any problem. We've never had any problem with noise or anything else up until about 3 months ago, maybe several months ago is the best way to put it. And since then, it has gotten out of hand. It's getting more and more and more. The parking, we can view the parking from our house. It looks like the place is loaded with automobiles. Secondly, I don't know if it's fine. I never have had to count them or tried to count them, but there is a lot of people that are sitting over there on the outside. And then I'm trying to rush this thing up, give you an idea as far as a date is concerned. April the 11th, they had a band, I won't say a band, probably a disc jockey with a record player, and he was doing all the yelling to the crowd, and the crowd was yelling back on that. And if we'd have had guests on our property on the backyard trying to have maybe a cookout or something, couldn't have done it. The noise was just out of hand, and that's what's been going on. Now, the applicant says, well, they want to go by the decimals, whatever the code says. I'm saying, who's going to have the machine there to determine how decimals are being done at the time of their parties? The only one that can determine whether it's a nuisance or whether it's too loud or not is the next door neighbors, and that's us, or the people that are still here objecting to it, which are neighbors. So that's one thing that I'd like to point out. I hate to be rushed. particularly after listening to all this other. Ma'am?
You're almost done, but if you want to speak at the next use permit regarding the next request, you can do that too.
Sorry, ladies and gentlemen, let me just finish up real quick. I'll slip over here to the last page, if I can. What this thing boils down to, I'm going to summarize, if you don't mind. I've got it so messed up, it's unreal. Anyway, what it really boils down to, gentlemen, Ms. Jackson, in my opinion, based on what I've seen and heard and understand from what I'm hearing, like the lawyer said a minute ago, this isn't children out there, this is a crowd. In her application, you'll see that she's talked about selling liquor, also for selling other things. She's, I think, barbecue or something, supposedly. But this is a business operation, and she's trying to expand the business operation. She's trying to turn the agricultural situation into a business, which is an outdoor, in my opinion, it's an outdoor nightclub, and that's what it sounds like. Thank you.
So we're at the additional 5 minutes.
Okay, that 5 minutes is expired now, right? Okay, and you said we have one more comment in opposition?
Correct.
One more comment in opposition, okay.
Motion we give another 5 minutes.
Yes.
Second.
You can wait. You'll wait till the next one? Okay. Okay.
Okay.
Okay. And
So is there anybody online on Zoom? If you can please raise your hand if you had a comment for opposition for this particular use permit.
doesn't appear to be, yeah.
No. Okay. Okay, so I guess we've had an additional 5 minutes for the opposition for this particular use permit, and so we will allow anybody in favor an additional 5 minutes to speak in favor for this particular use permit.
Lawyer or not. I mean, you're a lawyer too. I have had the opportunity, three things. One, I can't let the comment go without just correcting that there was public notice. It was not only mailed for the public participation meeting per the city's requirements and the city's list that we were given. It was also announced at the CZIM, the date and time, which was also by Zoom. It was also announced at the DRB meeting. Casey's clients have had my contact information because they actually were at, or Aaron was at our meeting last Monday. I'm more than happy to have conversation, but I do want you to hear that there was public notice and opportunity in compliance with the requirements. I'll also just point this out. Traffic. We all have experienced the lovely commute opportunities that pandemic has afforded us along 400, although that has changed as of recent date. But I would say to you that traffic on local roads has increased because people are home more. People weren't traveling. They didn't go on summer vacation. They were at home, and they were trying to get outside. And so, yes, the intensity and the use of the farm increased because of the pandemic. I would also say to you that that increase applies to the later use permit that we're going to talk about. God willing, we get through this. But also, I've had the opportunity to talk to the client, and after hearing your concerns, what we would propose is a limitation on the total number of attendees for an event under this use permit, Monday through Friday, of 25 per day. Saturday and Sunday, 50 per day, not per event, per day. And hopefully that addresses some of your concerns. And happy to answer any questions. Appreciate the time. Thank you.
Excuse me, those are limits on people on site at a given point in time? Or
attendees at an event, at an agriculturally related event, which is what this use permit is.
Okay. At 25 and 50. And are you proposing any limitation on the number of events at a given point in time?
No, because that 50 is total for the whole day on Saturday and Sunday, not per event.
At any one time? Is that, you're saying at any one?
Per day.
Total people, total attendees, so total children. There could be 5 birthday parties with 10 kids at each of those parties for 50 total.
Okay, so
on Saturday or Sunday.
Okay, so if you had one event and it was 50 people in the morning, you could not have any other events later on that
Correct.
day because you've already maxed your 50 people that you're going to have.
For this use permit.
Correct. Yeah, for this use permit. Okay.
Correct.
Just to
For
clarify,
this-
that includes Sunday, because at first
Saturday and, did I just say Saturday? I apologize. Saturday and Sunday.
For this use permit, do we need these decibel limits in here? Could we limit it to acoustical only?
I think that those decibels are in the code. So I mean, whether you put them in this use permit or not, that's what they are.
I'm just trying to differentiate between the use, this agricultural thing and the next one that we're going to get to. There needs to be some kind of a differentiation between what you're doing in these different activities.
Okay?
No?
Limit noise or acoustical. Yes, we could limit it to acoustical only.
I'm just getting back to the other comment about the disc jockey and the back and forth with the audience, and it sounded like it might be pretty loud, whereas if there was some guy with a guitar playing background music while people were having wine, he's not even going to hear that.
Paul, are we allowed to accept those changes or take into consideration those changes for our decision, or do they have to come again and present?
I think they're advising you that they would be willing to, they're willing to accept that. You can make any recommendation that you want. That's information that you can use.
Very good. Thank you.
Okay, thank you. Do we have any other time on?
I think there's about 3 minutes left.
3 minutes left for in favor of, okay.
In favor of, yeah.
So are there any other comments for in favor of?
Okay, so you're switching sides today.
Okay.
My name is Mimi Sullivan. I live at 2090 Bethany Way. I'm just across the street and down 1 or 2 houses from Pamela. I do not oppose this first agricultural use. I do not oppose the birthday parties, particularly since they've just been willing to limit the total number of people per day. You know, I had concerns when you started talking about how many parties a day and how many, and ooh, that got a little scary. But for them to say 25 people a day, Monday through Friday, 50 people Saturday, Sunday, we don't normally hear music that's disturbing. There's not a lot of traffic during these kinds of events on her farm. Those have been going on since I've lived here, 1996. I don't have any problem with those events occurring, so I am speaking in favor of that.
Thank you. Could you also please just state your name and address for the record?
It's Mimi, M-I-M-I Sullivan,
And your address?
2090 Bethany Way.
Okay, thank you. Anybody else in favor of? Anybody online and on Zoom? No? Okay. So at this point, we're going to go ahead and close out the public comment time in favor of. And at this point, we can, got any questions?
Well, no, I just have, my only comment is that I have a problem with the related activities being under agricultural.
Yeah. I mean, my comment or question, I guess, to staff and city attorney, and, this is just our overall for all of these uses and, the whole discussion and, disagreement as to what's considered, grandfathered or vested and what's not, and, what would it take for us from a city standpoint to determine what the city's position is on that, if there is anything that's going to change, or, do you think it's beneficial that we have any other research that's done? I'll ask Robin first, and then I can ask Paul.
Let me address, since most of that was built around the city's position on whether they're grandfathered. The city's position is they're not grandfathered in any the rights uses that would be covered under this permit, which is why we asked them to get this permit to make it a legal use. The city's position is that it is not a grandfathered use, therefore they would not be allowed to continue those uses.
Without this use permit?
Right.
Okay. Okay. No, so just, could you clarify your question about the agricultural and what your concern is still in terms of that?
Well, that in saying that it's agricultural related, and as some of the public has said, they question all of the other activities.
And if they're allowed under the agricultural related use?
Yes.
Okay. Robin, do you have any other comment on that?
I don't know if you're speaking to more the church-related Bible study, kind of those type of uses versus I think that was what I heard, was there was just some suspicions about, well, that wasn't really it was a square peg in a round hole, so to speak.
Mm-hmm.
So it's up to you all. You can make a recommendation whether to exclude those kind of uses or whatever your desires are. You don't have to accept what they've positioned. You can come up with your recommendations.
Okay.
It seems like we're all muddying all this stuff up. Can we just look at U21-01, the B on our agenda, and let's just vote on it? I mean, we just had the public support it. They're not opposed to ongoing activities. The gentleman that just spoke, hey, we've closed the discussion. It sounds like it's the last couple of months that are causing the problem. And I think those come into play on the next items. Is that correct? It sounds like the birthday parties, the petting zoos, that type of thing haven't been an issue for years and years and years.
Okay. Please, if you could please refrain from any other comment at this time.
We're taking, that was what I said, sir. We're muddying things up. Let's take it one item at a time.
Okay. So right now, let's just, if there's any other questions that we have for staff or the city attorney or anything like that, let's try to address that first, and then we can obviously open it up for any sort of discussion time that we may have, or if we need to bring anybody else up to speak on, So I would just say, do we have anything else for staff or any clarifications that we need from staff or city attorney or anything like that?
Do we have a definition of agricultural related activities?
So I provided in the staff report, there was no definition, but it was a precursor of what I read of the development standards, that that's what we have, is what defines that use permit, is on page 7, where it says, again, it is, and there's no other, if I look in the definitions, there's not a definition for agricultural related, but this use permit kind of calls out what it is. And it is the intent of this division to allow certain agricultural related activities with the use permit in compliance with the development standards below to preserve the nature of agricultural areas. Such uses shall include, but not be limited to, petting zoo, educational tours, dude ranches, picnicking, and pay fishing. And so it kind of starts with a general thought that the idea is to try to preserve the nature of agricultural areas. And then it lists some items, but it also says that's not all inclusive. So that's the best that we have that defines this use permit. So you can take it as you want to.
Again, as I said before, I think everything I've read, there's been very little opposition to the way it's been going up until, say, the last 3 months. Based upon the children's activities, my concern on this one was the increase in number and the increase in intensity. And coming back with the 25 per day and 50 per day, I think addresses that, for me. So again, whatever the architectural things are, if there's only 25 people there during the week or 50 people there during the Saturday or Sunday, that really helps me identify or wrap my head around what this is.
Anybody else got any questions for staff or city attorney? We can open the floor up for any discussion or... No? Okay. Then, we can open the floor up now for discussion. So if anybody else has got any other comments that they want to make.
I think if you take a look at the recommended conditions that staff put forward, I'm very comfortable with that, especially when we add the 25 people per day during the week and the 50 on Saturday and Sunday. Feel very comfortable with just this section on that.
Anybody else got any comments? Discussion? Okay. Then, hearing none, I'll open the floor up if there's any motion that anybody wants to make any motion.
I'll give it a shot. I recommend, I recommend approval of U21-1/VC2103, including the conditions by staff's conditions, and limiting numbers of total participants Monday through Friday to 25, and total number of participants, guests, whatever you want to call them, to 50 on Saturday and Sunday.
Can I make clear just that that includes the variances which are effectively items 4C and 4D?
Correct, including those variances.
Okay. Do I hear a second?
A second.
Okay, we got a second. Is there any discussion?
Were we going to do anything about the sound levels? They offered up acoustical only as opposed to decibel levels. Item 3D.
Yeah. I'll amend my motion to include, acoustical music, non-amplified music. Is that a better way to put it?
Yeah, that's good.
Okay. So we've got the motion on the table, amended.
For purposes of this permit.
Yes.
Yes.
Okay. Any other discussion? No? Okay. Well, then we'll call this motion to vote. So we've got a motion to accept staff's recommendations with the additional conditions that from Monday through Friday, they can have a maximum of 25 attendees per day, and on Saturday and Sunday, a maximum of 50 attendees per day, and that it will just be, sound levels at acoustical levels instead of what's in staff's recommendation right now in terms of the decibel.
When I understood to be music would be acoustical only as I don't know what acoustical levels would be. Is that, as I understood it, for
What would be do you have a suggestion on what may
well,
be?
if it was just music associated with these activities would be acoustical only,
Not amplified.
not amplified.
Okay, so the music associated with music associated with any of these activities for this use permit would not be amplified and would just be acoustical. Okay, so we got the motion on that floor. We have a second. All those in favor, say aye.
Aye.
Anybody opposed? Okay, then that passes. So now we are on to, okay. We will, are we good, or you okay to, you want to take a break or move forward? Okay, so now we're going to sound for U21-03 VC21-04. I'm sorry, U21-02. Sorry, that's the next one on. U21-02.
Okay, so I'm not going to bore you with all the other background information, but this is the specific request of a rural event facility, U21-02, at the same location, 2105 Bethany Way. So let me get to the slideshow. So basically, in regards to the site plan considerations, this petition has no requested concurrent variances. It's just a straight use permit. So the rural event facility means a permanently established facility to include indoor or outdoor and indoor or outdoor or both sites utilized on a regular or seasonal basis for public and private gatherings. The facility takes advantage of special rural characteristics such as natural features, historic structures, and landscapes, special views, open vistas, or a secluded pastoral locale. Types of uses may include, but are not limited to, weddings, corporate events, retreats, community events, private parties, and family gatherings / reunions. So let me just, this event facility permit was just done a few years ago, 5-6 years ago, and we did make a definition. So this is the definition that comes out of the definitions of the zoning ordinance. So with that said, these are the standards for the rural event facility. And according to the analysis of the site plan and the submitted information, staff sees that it meets all these regulations or standards. So I won't bore you with them all. So, but I will add that the above development requirements are addressed within the use permit considerations below, with the exception of noise. And 6, number of attendees. The applicant's revised proposed conditions state the following regarding noise. For this use permit, they're asking that live music to end no later than 10 p.m. and maximum continuous sound levels of 60 dBA and a maximum peak sound level of 75 dBA at property lines. The city's requirement for noise is the noise control ordinance in Chapter 20 of the City Code. Regarding this situation, the following regulations apply. This is based on the definition of commercial establishments that would consider the rural event facility as a commercial establishment only in the setting of the noise ordinance. So let me just clarify that a rural event facility, if you look at the rural overlay district, is considered an agricultural use. So, but when you look to the noise ordinance, because of the type of use it is, it falls under a commercial establishment. So, So I'm just going to go over this because I think this is an important fact when we talk about noise. And in Chapter 20, outdoor amplification and music at commercial establishments, it says it shall be unlawful for any commercial establishment to operate or allow the operation of sound amplification equipment out of doors or directed out of doors, or to allow live acoustic music out of doors. Okay, I repeated it, sorry. Other than during the times listed below, or so as to create sounds registering in excess of, and it goes through the different listing of the DBA for the days of the week and the timing. For purposes of this section, hotels, motels, or other short-term accommodations doesn't apply in this situation. And the decibel limits prescribed in this section shall be measured at the property line of the commercial property at which the sound is being generated. Okay. Although the proposed noise levels are below the maximum permitted, staff recommends that the applicant's submitted noise levels be included in the recommended conditions, being that the noise ordinance allows a much higher amount of noise than what the applicant is proposing. So if you so choose to go along with staff's recommendations, if you so choose to approve this, recommend approving this, then we're recommending what the applicant is submitting, which is less than what the noise ordinance permits. In regard to the number of attendees, the applicant has proposed to have a maximum of 100. It is staff's opinion that if this permit is approved with a maximum of 100 attendees, it would be an appropriate number based on the size of the property and frequency of events, and will be included in the recommended conditions. So this is the table of the uses that were and conditions that were submitted by the applicant on April 21st. The uses that they call out are events not primarily associated with the agricultural operations, farm, equestrian, or farm winery use of the property, including, for example, weddings, corporate events, holiday parties, picnics, team building, yoga or other exercise, physical activity events, or book clubs. Restrictions on use will be substantial compliance with the site plan and substantial compliance with events traffic management, parking and circulation plan provided. Months, days, and hours of operation: Sunday through Thursday, 9 a.m. to 10 p.m., Friday through Saturday, 9 a.m. to 11 p.m., facility to be closed at 11 with no more than 4 events per week. In regards to noise, live music to end no later than 10 p.m. and maximum continuous sound levels of 60 dBA and a maximum peak of 75 at the property lines. Alcohol service shall cease 15 minutes before music or event ending. Police, for any single event over 75 people, at least one off-duty police officer, and the capacity limit would be 100 for any single event. Again, with site development considerations, provide adequate temporary bathroom facilities, including handicapped accessible facilities outside of any required setbacks and in an inconspicuous area not visible from Bethany Way or Hopewell Road. B, no lighting except in accordance with night sky ordinance and as required for life safety. C, if at such time as the Director of Public Works determines that traffic generated by the property consistently adversely impacts the Hopewell Road, Bethany Way rights-of-way, he or she may require owner to conduct a traffic study to determine if any additional improvements are appropriate at no additional cost to the city. And lastly, sanitary facilities and trash receptacles shall be located at least 100 feet from any property line. And so now we're going to go into the use permit considerations, the 10 of them that we spoke about earlier, and the other one. Whether the proposed use is consistent with the land use or economic development plans adopted by the mayor and city council. The proposed development is within the agricultural, equestrian, estate, residential land use category of the 2035 comprehensive plan map, which is in the comprehensive plan update 2016. The proposed use permit for a rural event facility is permitted in the AG1 district. In addition, the following plan objectives are consistent with the proposed use. We will encourage the preservation of natural resource areas and preserve contiguous green open spaces, development of land in appropriate designated areas as development occurs. We will seek opportunities to provide pleasant, accessible public gathering places and parks throughout the community, and we will encourage development that is sensitive to the overall setting of the community and will contribute to our community's sense of place. In regards to compatibility with land use and zoning districts in the vicinity of the property for which the use permit is proposed. So this is the same analysis that I did with the previous use permit, with the various AG1 zoning districts surrounding it, whether it would be a subdivision such as Cooper Sandy or North Park, as well as the large estate lots that may have equestrian uses on it as well. The proposed use does not, the third one is whether the proposed use may violate local, state, and federal statutes, ordinances, or regulations governing land development. The proposed use does not appear to violate any ordinances or regulations if approved with the recommended conditions and development requirements. The effect of the proposed use on traffic flow, vehicular and pedestrian along adjoining streets. The proposed use effect on the traffic flow and vehicular and pedestrian along adjoining streets should be limited based on the variety of activities spread throughout the day and will not exceed the 100 attendees. In addition, this use should not be allowed during an event permit allowed under the agricultural-related activities or festivals indoor-outdoor use permits. This would cause a burden on the adjacent and nearby streets. The location and number of off-street parking spaces are scattered around the approximate 18 acres. Again, this is the same analysis I had on the previous one, that there are 12 spaces near the western portion of the site, additional 6 spaces to the north of the 12. Based on aerials, the 6 spaces appear to be where trees would be cut, but based on the overall tree canopy coverage, it would not impact the overall site if they were located there. In addition, 37 spaces located on the north, central, and eastern portion of the site, which portions of these spaces are located within the required 100-foot setback for activity areas, which includes the parking. It appears that there is sufficient room to relocate the spaces that are within the 100-foot setback. Staff notes that the rural event facility use permit requires 1 space per 2.5 attendees. The applicant has indicated a maximum number will be 100, and therefore 40 spaces will be required. In addition, there are 2 other use permits being considered as well as the existing winery, which may require that parking be provided for these other uses concurrently. Amount of and location of open space. The proposed site provides adequate open space since there's approximately 18 acres, including a stream that cuts through it and provides a required 75-foot buffer on either side of the creek, as well as pastures, vineyards, and other open spaces. Protective screening. It's a staff's opinion that the existing vegetation is located on the property and in most places located along or near its exterior property lines is sufficient to provide screening for the proposed 100-person, 4 times a week rural event facility. Hours and manner of operation. Sunday through Thursday, 9 a.m. to 10 p.m., Friday through Saturday, 9 a.m. to 11 p.m., facility to be closed at 11, music will end at 10, with no more than 4 events per week. Again, outdoor lighting, they don't anticipate outdoor any additional lighting except what would be required for life safety. Ingress and egress, there are, as now corrected, additional curb cuts on the property along Bethany Way as well as Hopewell Road, and there's going to be a new roundabout when it's completed, and the number and location of entrances and exits will be sufficient for the use unless otherwise shown through a traffic study required by the Public Works Director. So in conclusion, if approved with the recommended conditions, the proposed rural event facility is consistent with the City of Milton Comprehensive Plan Update 2016 and objectives. In addition, it is staff's opinion that the proposed use provides a way to help preserve the large lots within the city and contribute to the overall rural character if approved with the recommended conditions. Therefore, staff recommends approval conditional of U21-02. Just for the rural event facility. So if the Planning Commission recommends approval, these are the recommended conditions for rural event facility on 18.027 acres to be substantially compliant with the site plan received on February 25, 2021. To the owner's agreement for the days and hours of operation, Sunday through Thursday, 9 a.m. to 10 p.m., Friday through Saturday, 9 a.m. to 11 p.m., facility to be closed at 11 p.m., all music will end at 10, no more than 4 events per week. Alcohol service shall cease 15 minutes before event ending. There shall be no more than 100 attendees for any single event. Maximum continuous sound levels of 60 dBA and a maximum peak sound of 75 at property lines. For any single event over 75 people, at least one off-duty officer will be required. And lastly, not lastly, but number 4, to the owner's agreement to the following site plan considerations regarding adequate temporary bathroom facilities, including handicap. The said facility shall be at least 100 feet from any property line and out of view of Bethany Way or Hopewell Road. Trash receptacles will be located at least 100 feet from any property line. And lastly, to the owner's agreement to abide by the dedications and improvements that were also included in the last one. So I won't bore you with all that, but it's right before you. So with that, that's staff's presentation. So if you have any questions, I'll be happy to answer them.
I had a question on the standards. And so like number 2, where it says permitted curb cut access shall not be from local streets.
Right. So there's different categories and intensities of streets, and this either Hopewell Road or Bethany Way are not a local street. So typically a local street is a subdivision street. So.
Okay. Yeah. And then you're saying right now that the parking does meet the standard, the current parking that they have meets the standard for a rural or event facility?
Correct. So it's the same standard that I applied for the previous one of 2.5 per 100 people. So that's 40 parking spaces, and what was shown proposed and existing and would meet that for that use.
And it meets that standard even without, what we just talked about in the first use permit with the concurrent variance that was needed for those parking spaces to be allowed?
Well, so I think the applicant had stated that they were going to locate those proposed number of parking spaces outside of the 100-foot, so then it would comply.
The ones that are currently there, or you're talking about new parking spaces in a potential revised site plan?
So they're the same spaces, so the ones that would be proposed to be relocated outside of the 100, plus the existing ones.
So I think before they were saying something about 55 parking spaces that are on the property.
That were shown on the site plan.
Mm-hmm.
And I think they were speaking to additional ones, but I just look at the ones that are demarcated on the site plan.
Okay. But anyway, I guess I'm just trying to figure out, when you say it meets, or when you're already saying that this is meeting the standard for parking already, and that is not considering the concurrent variance that was potentially going to be given on the use permit for the first one?
For the location.
For where these parking spaces are, because obviously they're, it seems like they're in setbacks, and they require a variance for those to be allowed, which is what we discussed on the first use
So once
permit.
they take them all out of the 100-foot from the other one, then they would be in compliance, so.
But when you, I don't understand, when they take them out, how are they going to take them out? Because that variance is given?
Correct.
Okay.
Well, no, so, I'm trying to think. The variance could apply, no, it doesn't. So they would need to take all the parking out of the 100-foot from the property line to be in compliance.
Okay, and so,
And they could relocate it outside of the 100-foot.
okay, so if we're looking just at this use permit, how is that already accomplished if that you're saying that it's already meeting the standard?
So that they would have to meet that standard to be in compliance, to take all of the parking out of the 100-foot.
Okay, so that would be something that we would have to address.
Require that they would agree to take all the parking out of the 100-foot setback
And so.
to meet this.
To meet this, right? And so if they've been given potentially if they are given a concurrent variance on that first use permit, that wouldn't apply for this. You're
Correct.
talking about. So they would actually have to create new parking spaces then?
Well, they would remove whatever existing are there, and then any new ones would have to be outside of the 100-foot.
Okay. But then, what's the necessity on does that concurrent variance have anything to do with this then, basically?
No.
Okay, so they're given that, and those parking spaces potentially are going to be
I
where
see
they
what
are.
you mean. So that it's in conflict, yes. So in the end, they would end up taking all the parking spaces out to be in compliance with this use permit. Oh, okay. Well, I guess that's a question you can ask the applicant.
So, yeah, right now, they do not meet a standard for parking, and they would actually have to have potentially
40.
whatever parking is required,
Outside of the 100-foot.
which would have to be put onto the property if they don't already have it.
I'm sorry, what?
I'm saying they would actually have to put those parking spaces on the property if they don't already have those parking spaces on the property right now.
Correct.
Because, potentially what they have right now is, potentially going to be granted through a variance. They can keep those spaces as they are right now because they're obviously not meeting the requirements that were needed from a setback standpoint, right? So we're talking about potentially new parking spaces that they would have to have to accomplish the standard that's needed for this facility, for this use permit.
Correct.
There's a parking problem now. Whatever they're doing now, there's a parking problem because they're parking over in Bethany Oaks. When I drive by there, they're parked all the way out to Hopewell on that Hopewell entrance. So I don't know if they're more than 100 people in there or what happened, but there's not adequate parking now. If there are in fact 55 spaces, then they're putting in more than 100 people. The other question I had is in your recommendations on the alcohol. I know we read further that they're going to cater with Q Barbecue and Q is going to provide beer and the
So that's for
winery's
the
going to
other
provide wine.
request. That's for the
I
third
understand.
request. Okay.
I understand, but this just says alcohol.
Okay.
So are we assuming that that's beer and wine, or is there going to be distilled spirits as well?
Well, typically with the event facility, like if you had a wedding and that they had alcohol being served at the wedding, that's what I believe that they're speaking to, that the alcohol would cease for that specific use at that time. So when it says alcohol service shall cease 15 minutes before event ending, so if you have a wedding and it's going to end at 10 o'clock, then the alcohol serving has to stop at 9:45.
I get that, but it could be any alcohol.
Well, this speaks to this use, to
I
this
think
special event.
I've had drinks at a wedding.
Right.
I've had champagne at a wedding. So what I'm saying is, what should we define alcohol? Right now, it's a farm winery. You serve wine at a farm winery.
I mean, if you want to be more specific, you could be, but
It'll likely be a catered event, like most weddings you had been to, and I would assume you'd probably have all kinds of alcohol there.
So,
It's different when you're looking at this specific use permit. Think about that separate and apart from what's allowed under the farm winery.
okay, but this would require a liquor license.
They would get an incidental
Caterer's
license associated with the caterer.
Gotcha. Okay.
I had another question, Robin, on the required standards, which was number 5, where it talks about activity areas such as outdoor dining, entertainment areas, including parking, shall be at least 100 feet from any lot line unless the special event facility and adjacent lot are in single ownership. And you said this meets the standard. And so which way did it meet the standard? Or
So I believe that that the activity areas that were being used for this event would be 100 feet away. So the applicant can speak to that. Which facilities on the property would be utilized for the event for this use permit?
okay, which are, so,
Anything outside of the 100-foot.
but in terms of like, I guess what would be considered facility?
So I think that's a question for the applicant to ask them what they would be utilizing for this specific use permit.
Okay.
Robin, is it typical for outdoor facilities to have music during the week till 10 p.m.?
Yeah, this is, I think these restrictions or timings were taken from the Little River Farms event facility. So I think the applicant looked at other facilities likewise, which there's really only one in operation, to see what their limitations were. So, yes, that.
And does that change depending on where they're located in the community?
Correct. I mean, it's all very subjective to the location and what's going on around it. That's correct. You don't have to go by this. This is just what the applicant requested. If there's another time or if they come into agreement to lower or shorten the time, that's fine.
10 p.m. just seems late during the week with so many communities so close. I mean,
Let's see what the end. So for the time, Sunday through Thursday, yes, 10 p.m. Friday, Saturday, 11. So yes.
Does Little River have a limitation on how many people can attend?
They do. And I don't have it right in front of me, but they do have a limit. I think it's around 200. No, you have it, thank you. 250, even more. I was being conservative.
But they're a bigger facility as well.
Yeah, they have approximately 40 acres total.
Okay.
Any other questions for Rob? No? Okay. Thank you, Robin. We'll allow the applicant to speak.
I'm going to read again if that's okay. And I'll just say good evening. And I'm Pamela Jackson. I'm a long-term resident residing at 2105 Bethany Way, and I am the trustee property owner. I would like to incorporate my comments from the immediate prior application, not to be repetitive, but to elaborate specifically with respect to this application and use request. We applied to be a rural event facility because that is what the city zoning ordinance calls this use permit. And we listed the types of uses that we have held in the past, including weddings, corporate events, and we had at one point a wedding with 350 people in 2009 or 10, and decided that was too big. Since then, we have hosted several weddings, but they are typically much smaller, and we don't want to be a full-time events facility, but we do want to afford folks the opportunity to use our green space and property on a limited basis. Again, I will let Ellen Smith, my attorney, speak to these particulars, but we are looking to complement and supplement the working farm and winery use. As a long-term resident mom and grandmother, I want to build a strong community and be a good neighbor. As a small business owner, I want to preserve these 18 acres through a strong business model. And as a Milton taxpayer, I want to do things by the book while receiving fair treatment and proper recognition of my agricultural and business operations that predate the city. And I invite any of you to please come out during our winery open hours or otherwise. Thank you.
Thank you.
Good evening again, Planning Commission members. I'm Ellen Smith, Parker Poe, 1075 Peachtree Street, Suite 1500, Atlanta, Georgia. I have the pleasure of representing the applicant, and I won't go through the full description. Robin and the staff report you have does that. I do want to clarify a couple of things. One is with respect to the building that is shown on the site plan. It's approximately 12,000 square feet. That is shown on the site plan so that everyone knows there is a new building proposed. It is not to be an events facility. It is to be the farm winery business operation and tasting room. Currently, all of those operations, winemaking, the wine tasting room, happen in the basement of the existing single-family residence. If and when that building is built, we'll comply with all zoning requirements, we'll comply with all setback requirements, we'll comply with all parking requirements. The operations for the winery will move out of the basement of the single-family residence. That will be reconverted to, I hear, a workout room, but single-family residence, no public invitees at all, and that will be a winery tasting room. It will not be an event facility, and we're happy to stipulate that. I did want to, there was a question asked about Little River Farms. These proposed conditions were taken from the Little River Farms approved use permit that was, I think, maybe the first or second one. I think there's one other that has been issued but not used for a wedding facility in town. But just to give you an idea, we did also propose to our discussion in the last use permit request no more than 4 events per week. We also proposed attendees not to exceed 100 people per event. I'll just say this too, from the city's perspective and what we understand from the city's perspective, if you think about the last use permit, agriculturally related activities as children's, think about this one as the adult version of that. Is kind of what we've been told and guided to. With respect to the parking question, just to clarify, because that is confusing, what I would say is you don't have to remove parking if a variance is granted to allow it to remain for one use. You can say with respect to this use, that parking that is within the 100-foot setback that is currently existing could remain, but not be used for these events. And I would also say or propose a condition, should you choose to entertain it, that requires the applicant to submit a revised site plan that shows all new parking to comply with the provisions of this use permit to be outside of the 100-foot setback, but also to comply with all arborist comments and considerations. So with respect, we hear that and appreciate it. I was neglectful during the last one to not say, thank you for considering this, and we respectfully request your approval with conditions. We agree to the staff recommended conditions and would propose adding that one with respect to additional parking. And I know there are other folks that you haven't heard from, and you've heard plenty from me. I'm happy to answer questions now or for you to hear from other folks and to support however you propose.
I'd like to ask a question.
Certainly.
Just looking at the uses here, weddings, corporate events, etc.
Yes, sir.
Will music be involved in any of these events?
Certainly.
Okay.
With a wedding, for example.
Okay. Will it be amplified music?
Yes.
Okay.
It could be. Doesn't have to be.
In the last discussion, you indicated that music was not a part of the agricultural things, except you'd be doing it in acoustical, without amplification.
Sure.
This will be amplified, correct?
Could be.
Could be, maybe.
Yes, sir.
Okay. Where do your free public concerts fit? In this one?
Yes. In this
Okay,
one.
that would be in here. And music bingo, I guess that's in here as well?
Yes, sir.
Okay. Again, we're back to the question of how many people are going to be here.
Yes, sir.
Let's sort of cut through it. We had this conversation once. 100 people per event. You have multiple types of events you can have here. What's your proposal for the total for this?
So we proposed no more than 4 events a week. We also had proposed a limitation on the number of people. I think our proposal for a combined number of events in a day for this use permit, the number of people, I'm looking at Laura, 150? 150.
So maximum 150 people?
Yes, sir.
On a given
Attendees.
day?
Yes, sir.
Total, in aggregate, right? So 75 may come in the morning, 75 comes in the afternoon. That's your 150 total aggregate.
Correct.
We know you're not good in math. You said that already, but that's 150.
It's a detriment for being my father's daughter.
Okay. Let's check it.
So I have you have any more?
No, that's fine.
So one question I have was, and I posed this to Robin as well, and I'll pose this to you, where the definition seems like it says rural event facility means a permanently established facility to include indoor or outdoor.
So all of our events are outdoor. So if we want to propose a limitation that no rural agricultural event happen indoor, that's a limitation. Currently, where they happen are existing facilities on the site plan, and I'm not going to be good enough to pull that up, but there is an approximately 750-foot stage shack. I mean, it's a platform that is right next to the residence. None of them are within 100 feet of the property line. There are a couple of gazebos where weddings have happened. Those are also very close to the house location on site, but no proposed new facility.
Okay.
There's one gazebo out by the cemetery. I don't imagine there's very many weddings out there.
People are strange. They had a wedding with horses, so not my choice.
Okay. And so, again, the question about parking, and so if additional parking is required based on, all the related factors, is the intention of the applicant to actually put then additional parking spaces on the property to meet the requirement that may be needed for this use permit, and it's going to comply with setback standards
Correct.
and whatever else?
Correct. It's the applicant's position. There is parking already there, room for parking, whether it is in a horse arena or otherwise, and that we would show that. In other words, there may not be a land disturbance permit. There may be a directive for an event for where people park, and we will show that on the site plan.
And basically, you're just saying you would need to revise the site plan
Correct.
to show that?
Yes.
Yeah, I don't want to beat up this parking thing, but we calculated earlier that roughly 55 spaces that we've identified today. And if you had an event with 100 people, they're going to consume 40 of the spots.
Yes, sir.
Then you've got employees, vendors, and entertainers, and that 55 could...
There are parking spaces in the driveway and other parking areas that weren't included where vendors, musicians, caterers, vans park on the other side of the house. There's a multi-car garage.
That's not over at that Bethany Oaks swim and tennis.
No. But what I would say is we need to show you that. You don't just need to take my word for it, and we can do that.
So is there a reason why this wasn't on the site plan?
Timing?
Okay. Timing from the vendor who was creating your site plan?
Timing to meet the agreed upon deadline with the city to file the application.
Okay. So is that already in process, I guess?
Yes.
Yeah. Okay. And do you expect that to?
In the next week?
Okay.
Apparently, not necessarily to parking, but with this roundabout.
Yes, sir.
And you said earlier that there would be an entry
Yes,
off
sir.
of that. So that means that most of the parking, I assume, will change because your location of your winery and tasting room is now down at the point of where the people will come in. Is that correct?
Yes, sir. When the winery building is relocated, it would have to meet all parking requirements for that building, which include, I think, no front yard parking. It would have to be around on the
ADA.
back, all of those.
ADA
Correct.
would have to be.
Absolutely.
Lost it.
During the conversations before, there was several comments made about, it seems like in the last 30 days or so, there's been more noise complaints than previous years. Is there anything that's changed in the operation to cause that?
Not with respect to this use permit. I think with respect to the next use permit, yes. The intensity and number.
I guess I just had a clarification because, building on what Ron was talking about, there's a number of events, music bingo, free music, the Van Morrison Tribute Band, all those.
Van Morrison Tribute Band is a live ticketed concert, and it falls under the festival's outdoor events.
Okay. But in the definition that you had written up, it says that there may be live music at these events, like a band at a wedding, but the music is not necessarily the draw or the primary event.
Correct.
So it seems like if it's free music is not, I'm assuming, is that the primary draw?
That was an example of a wedding where people go to the wedding to see the people get married, but they stay around and party afterwards because the band is good.
Right. But in this case, you're promoting music.
With respect to the third permit.
Well, so the free music, that is the music and festival? I thought earlier it was mentioned that was this
on
one.
the website that I don't know about.
Well, there's music bingo, there's free music with John Oswald.
There is not a limitation under the Rural Agricultural Events Facility that says you can't have music.
Right, but
And we're not proposing a limitation that says you cannot have a concert.
Okay. I just didn't see that when you say in your description, the music, not necessarily the draw or the primary event. Seems kind of at conflict with, advertising and promoting the music and saying that fits this. It really doesn't.
Okay.
Yeah, in my view. I mean,
I'll second that. So where does that fit?
If it is, the city's definition is, and determination has been, if it is a live ticketed music event where music is the primary draw, it falls under festivals, outdoor events.
Are you aware that they're having free concerts at the facility
Yes.
not associated with weddings or any other activity? They're just promoting free concerts. You're not aware of it, are you?
There are music events that are promoted on the website that are associated with the winery, where people come to the winery. I think there's a difference between whether music is the primary draw. Just because there is a list of a live music event advertised on a calendar of event where someone comes to the winery and buys a glass of wine and listens to music in the background.
It doesn't
the
say
city
on
would
your
prefer
website, it
that
doesn't
we
say
not-
anything about wine associated with these concerts. Just, that's it. Let's not dwell
Okay.
on it.
Anybody else got any questions for?
Well, I only one on it, just to make clear that these events, when it's event, but there are actually two going on. I used horse show, whether they do have horse show or not, and had music. I want to make clear that that maximum is 150 people. Max, is that
Yes, sir.
correct?
That's correct. And the sound levels, as Robin presented, are significantly lower than under the city's current noise ordinance. And that is whether two events are happening at the same time or not.
Has it always been that way, or is that the direction it's headed?
It's always been that way.
Okay.
Anybody got any other questions for Ms. Smith?
Right now.
Not right now. Okay,
Thank you.
thank you. Okay, so at this time, we're going to have hear any public comment in favor of this use permit.
So we wanted to have the next.
You know how much time you have left, just to check?
Robin, do you know how much time we have left?
Yes, I'm sorry. Oh, well, I'm sorry, what?
How much time did we have left?
5 minutes.
Okay.
They took 5 minutes outside of the questioning with the applicant, so.
So five.
Yeah.
So 5 minutes left still?
5 minutes left, yes.
Okay.
So we do have David Jackson.
Okay. Please state your name and address for the record.
I'm David Jackson. We live at 2055 Bethany Way, so right next door. Over the past year that the music's been going on, it's been fine. I mean, we can hear it if we're at the fence, and as far as decibel level, it's barely noticeable. I think only one time we've heard it inside our house, but it was indistinguishable. I mean, you couldn't even hear what was going on if you're inside the house. As far as weddings and things, I think that's been going on over there for the almost 10 years that we've lived there. It's never been a problem. Even over this past year where everybody's talking about it escalating, traffic's never been a problem. I mean, I'm just thankful that they have a sign now so that they don't turn around in my yard. They're actually pulling into the correct driveway. So that's all I got. Y'all have any questions for me, being the neighbor?
Good. Thank you.
Okay, the next speaker will be Cheryl Smith.
Good evening, gentlemen.
Good evening. If you could state
My
your
name is Cheryl Smith. I am the Agritourism Manager for the Georgia Department of Agriculture.
Give your address, ma'am.
My home or my work? My home is 6416 Cannon Drive, Flowery Branch, Georgia. I have an hour drive home. I'm here because both the winery and the farm are listed on the official Georgia Agritourism Registry for the state of Georgia. The winery, it had applied for and was approved for the Georgia Agritourism Signage Program, and I'm responsible for that for the whole state. Many agricultural operations, they have to diversify in order to be sustainable. And I will tell you, I worked in North Georgia and Northeast Georgia for the State Tourism Office for 31 and a half years. And I was always happy to see a winery go in because it was agriculture, it was manufacturing, it was retail, and it was tourism, and it brought dollars into a community. Multi-use agricultural facilities that offer a variety of agricultural activities, they enhance the quality of life for not only your citizens, but people who come into your community and spend money. And with the millennials and the Gen Xers, they're looking for a place just to hang out, listen to music, and I don't know of any winery in the state of Georgia that does not play music as a background for people coming to visit them. It's not what people go there for, but it enhances the atmosphere and the agricultural ambiance of the winery and vineyard. With regard to economic impact, it keeps, as I said, the dollars in your community for people who visit your community, who live in your community, as well as people from outside. And that's really all I have. Thank you.
Thank you.
Okay, we have another speaker in support, Doug, can't read the last name, but.
Would have mispronounced it anyway,
Okay.
for sure. Hey, I'm Doug Haney. It's H-E-N-E, but it's pronounced Haney. I live at 1994 Bethany Way, so next door to the Sullivans, across the street from the Jacksons, kind of catty corner from the Painted Horse, what we're talking about. Lived there for 12 years, or owned the property for 12 years. I went to Milton High School. I'm originally from here. I love everything that Milton is all about. I was at and sorry for my attire, I came straight from a lacrosse game where Kingsridge won 22-1 in the playoffs, which was pretty awesome. So to me, the opposition really boils down to two things. There's two concerns. They are the noise, which was my concern too, and then the amount of people, the amount of traffic that we're going to get. And I was the first one when my wife and I were talking about, I was like, I don't want, like, the rumors that I'm hearing, which the rumors are out there, everyone's hearing about, oh, we're going to have like the next mini Verizon or the next Ameris Bank or whatever it's called now. And they're going to build a venue over there and there's going to be tons of people. And I was like, I don't know that we want that across the street. I certainly don't want the noise from it and everything else, but we haven't heard anything. Like from my house, and again, from where my house is and where the stage, which it's a platform, is, it kind of directs towards my house. And I don't hear it. Now, granted, the one concert, true concert, ticketed concert that's happened so far, I was out of town for. I didn't hear it. I do understand this. You hear me out? I'm not done. I was out of town for that one. That's not what we're talking about right now. We're talking about everything else. We're talking about the live music that goes along with the winery, which I have been to that. I've been there. I've been up here 3 minutes?
Well, no, the 10 minutes is done.
The 10 minutes is done.
Golly, I didn't talk that much.
Okay,
No,
okay.
you didn't.
Okay.
Is this, how many other,
This is the last one.
I got 2 minutes left in me.
okay. Can I entertain a motion for 2 more minutes?
Make a motion for 2 more.
Okay. Second. All those in favor say aye. Aye. Anybody opposed? You got 2 minutes. Go ahead.
Thanks. Okay, so I don't hear them. What we're talking about right here in this second one, I don't hear the music. It's not loud. And I've been to the winery when this music is playing, and it can be debated, are people there to hear the music, or are people there to have wine? You know, when you go to the wedding, are you going for the wedding, or are you going for the music afterwards? Whatever. That's debatable, right? The point is, it's like singer-songwriter music. It's not loud. And even still, when we had the meeting at Pam's house that some people chose to come to and others didn't, they talked about decibel levels. And she said, I'll keep it down below what is even in the statutes of the law or whatever the terminology is. The noise isn't so much a bother to me. Not for this one, not for number 2. The other thing is the amount of people. Everyone talks about the traffic. You know when traffic is bad on my street? It's in the morning when everyone's going to school, and it backs up all the way past my driveway. The only time I've been in this building, and I've been in this building twice, the only other time was a lot of us were here because people fly on my street. And I've been begging the city adjust the speed limit, adjust the speed limit. It's 45 on my street. It's supposed to be 35 in the curve, and people haul tail down there. You know what them having events does? It has a cop out there on Friday and Saturday nights. You know what that makes everyone do? Slow the heck down. So if anything, are there more people on the street? Maybe. But are they driving slower? Yes. Since I've lived there, there have been a dozen car wrecks, overturned cars across the street, in my street, in my neighbor's yard, all over the place. You know who's driving those cars? High schoolers that are flying. Not adults like you and me out on a date night or going to a winery. And if you've got a cop out there and blue lights flashing and more people slowing everyone down, to me, that's not bad traffic. That's actually regulating traffic, keeping everyone driving slower. The only thing the cops told us we could do differently was to self-regulate. Get out on the street and drive a tractor.
It's been
do
2
something.
minutes.
Awesome. This is the next best, though. I'm done. Thanks.
Thank you. Okay. Anybody else in opposition here? I mean, in favor here?
No, but you might want to ask.
Yeah. Anybody on Zoom who is in favor who would like to speak? Could you please raise your hand? You wanted to speak in favor? Have you already filled out a comment card?
Okay.
Oh, hold on 1 second. Okay.
Well, now they'll have to add more.
Yeah.
But there's nobody online.
Nobody else is online? Okay.
I'll take their place.
Hold on 1 second then. All right. So we're going to have an additional probably 2 minutes. 1 minute. 2 minutes.
How much time you need?
3.
Okay. 3 minutes. Okay. And a motion for 3 minutes?
So moved.
Second.
Just to be clear, it would be for both sides, be a total of 15
That's
at
right.
this point.
That's right. Okay, so we've got a motion for 3 minutes and a second. All those in favor say aye. Aye. All those opposed? Okay, you're on.
Start the clock. My name is Donna Klein. My husband is Don Stepanek. He could not be here tonight, but he is
Just state your address.
2325 Bethany Bend. And he has been at the residence for 19 years. I've been there 12. So we would be considered one of Pamela's closest neighbors. So I'll read you the letter that I sent. I think I sent it to Robin. So I'll read this letter real fast. It says, to whom it may concern, I am reaching out in response to the city meeting March 23rd concerning Pamela Farms and the Painted Horse Winery. My husband and I were unable to attend, but we were able to watch online. As one of the winery and farm's closest neighbor, we were confused about the noise issue because we can actually see when the leaves are off the trees, we can see the lights over there, we can see people walking around, and when we go over to the winery to walk, we walk right across the street through the back gate, and we almost have to get all the way up to the winery to actually hear the acoustic music. And when we're in our backyards, sitting around the fire pit or whatever, we wish we could hear the music because it's wonderful when you go over there. It's not loud, it's soft, and it's like background music. So as far as the traffic goes, we live on the corner of Bethany Bend and Hopewell, which is one of the busiest intersections. It's where the roundabout's going in. We have seen no difference in the traffic situation being any worse on the weekends because people are coming and going all the time from there. It's not like after work traffic or when the schools let up. And, our main concern is the noise as far as when the younger people have their windows rolled down and the music is up so loud in their cars, it rattles our windows. And everyone with the loud exhaust. But as far as anything going over there, it's not affected us at all. And we are very close. And that's what I have to say.
Thank you.
45 seconds left.
Okay. Anybody else? Is there anyone else who would like to speak in favor of? Okay. All right, at this time, we'll close that comment section, and now we will open it up. So we're going to have 15 minutes total, okay, 10 minutes plus 2 minutes that we granted, an additional 3 minutes that we granted for 15 minutes total for the opposition to speak. And Robin, if you will call the first.
Amy.
Boy, am I glad to be here. My name is Mimi Sullivan. I live at 2090 Bethany Way. This use permit is so incredibly inappropriate for our neighborhood. And it is a neighborhood. It is surrounded by residential homes. There is no other commercial pods near us. They are miles away from us. What she is proposing is a commercial use. There's nothing to do with agriculture. One of y'all said, what does this have to do with agricultural use? Nothing. Nothing. This isn't about promoting wine. People aren't coming to free concerts for the wine when Q is also catering and there's all the free beer you can get. And certainly on white columns, not free beer, they're paying for it, but it's free beer and it's wine. And if you're at a wedding, you have use for all the other kind of alcohol that the caterer is providing. So I hear someone say, don't worry, we're not going to come back and apply for an alcohol permit. Well, no, I wouldn't either if I was going to cater all the events and they were going to come in and supply all the alcohol. I wouldn't need to do that. This is a neighborhood. This is not an appropriate use. I've heard all this talk about sense of place, community sense of place. We have tremendous community sense of place. We all moved up there to be in a rural community. We didn't move in near Avalon. We didn't move down near downtown Alpharetta, where they have plenty of live outdoor music. If anybody wants to go hear live outdoor music, there's plenty of it all around us. We're not denying people the ability to do that. But this is a neighborhood where people live. They go to work, then they come home. They want to relax on their own property. They want to play their own music. They want to entertain people in their own yards. And they don't want to have to listen to music. I live across the street. I live up on a hill. I can hear the music inside my house. I have new windows on my house. I've lived there 25 years. Last Saturday night, I could tap my foot to the beat while I was sitting at my computer. I've called the police innumerable times because they've told us that's the only way that we get to complain. They're probably tired of coming to my house. But every time they come to my house and they pull up in front, I say, you can hear the music, right? You can hear the words they are singing. You can hear them talking to the crowd. In fact, on the night of the concert, April 10th, I wrote down the time and the name of the song and the lyrics to the song that were being played. I can tell you exactly what songs were going on and exactly what time it ended after Jeremiah Was a Bullfrog. It is disturbing to our neighborhood. Whatever the noise decibel level measurements are, you need to revisit those, because if that noise is inside your limits, you've got a problem with your limits. And I'm not making this up, and that's why I call the police, because I want someone to say, yes, indeed, we sure did hear it. And I've even recorded the music, and I've shared it with people on my phone. The traffic is intense. You all already know that corner is insane. There are no turning lanes. It's 2-lane roads. It's all the traffic coming from after school. It's all the people coming home from work, back and forth. We already are a mess. Y'all know that, and that's why we're working so hard to get a roundabout in there, a roundabout that was engineered before anyone thought about the additional traffic that this winery event space might throw back onto that road. We have had the police hold up the traffic in order to let people pull in and out. It has backed up in front of my home. I live on the curve. We have a terrible problem with speed on our road. People will come into that curve at 60 miles an hour. We've had cars turn over in our yards. It might be the teenager driving the car, but it was an old couple that ended up upside down in my front yard. So it's not just teenagers. The problem is when people come from Haygood down to that curve, it's a blind curve. You come around the curve at 50, 60 miles an hour, you don't know the traffic is backed up to our curve because the police are letting people in and out of the winery. So we've already got a dangerous road. We've already got a speed problem. Now we're adding a bunch more volume onto that road, and that is just a problem. It's a problem for all of us that live there. The noise is a problem. It doesn't meet our rural character. It's not a good residential use. The music is loud. It needs to be looked at. The alcohol is a worry. It is a worry. And how would you like to live next to an event space or a concert space? I don't know if any of y'all live in White Columns or not, or the Manor, but I'm guessing if somebody bought the farm right next to there and they opened up an event or a concert space and they started playing loud music only 4 days a week. Oh, instead of 7, we're only going to do 4 days a week, till 10 or 11 o'clock at night. I think you all would be hearing from these people. But it's nice to know that White Columns sent out on their Nextdoor page that they're going to have a White Columns night out at the Painted Horse Winery May 22nd. Free concert, live music, 5 to 7. Come on over there. They'll have queue there, and you can buy alcohol, and you can sit and visit with your neighbors. And all of us here that live right next to it are cringing when we see that. Because we don't want to have all these cars, all these people, most of them who don't live right next door to it, coming and piling into this place. So you've heard before, because we've met with the city, we've met with Robin, we've met with lots of people, and we've told them the traffic is a problem, the noise is a problem. The other big problem I think City of Milton has to think about is how many of these event permits are you going to be willing to issue to adjacent properties? So Fortitude Farm, which is across the street and just on the other side of the intersection from Painted Winery, already has an event use permit. They're not using it, but they have it. If someone buys that space, they can decide to start having weddings. They may have to negotiate with the variances with y'all, but they already have the event permit. Bethany Oaks has an event farm on one side of them, and this would be another event farm across the street from them. They would be surrounded by event spaces. Is there some kind of idea in Milton that we don't want these right next to each other? How many can you have within a mile or half a mile or right next to each other? Is there any minimum size for how big do these places need to be? Because 18 acres is not enough. 40 acres, that's a lot of land. People are farther away. 18 acres is not enough. So you potentially have a problem where any farm in Milton, people are going to come by a house, by a neighborhood, next to a nice rural farm, and the next thing they know, that farm is going to be an event facility, and there they're going to be. So this is not promoting what Milton is trying to promote. And, you know, we are very annoyed, and we have a problem with that. We hope that y'all are hearing us. And certainly I'm not making up the whole noise issue. So I had a couple of comments for people that commented. The dollars this is bringing into our community, or it's not going in any of our pockets. The dollars are going into Pam's pocket, maybe into Q's pocket, but it's not coming into any of our pockets. We're being inconvenienced, but we're not being paid. That's for sure. It's not enhancing the quality of our life. And music is not background music. This is not little quartets that are playing so you can drink your wine. This is loud music. Doug's my neighbor. I love him, but he's out of town a lot. And he's not here on a lot of weekends when there's music going on. And I went and spoke to the couple on the corner at the Roundabout to find out how they felt about Pam's Winery. And we talked outside by their garage at the gate. The sound of the traffic turning onto Bethany Bend and turning that corner was so loud, the traffic noise, that I could hardly hear them talking to me. We were almost reading each other's lips at the gate to try to hear what each other was saying. And I was thinking to myself, I bet they don't even hear that music here because this traffic is really loud on this corner, and it's only going to get louder with the roundabout. So obviously, I'm in opposition. Thank you for your time.
Thank you.
So the next person to speak is Tony Rich.
How much time is on?
Oh, so we have about 5.5 minutes left for the opposition.
You have a lot more speakers. I don't want to take the whole 5 if you need to spread it out.
That's up to the.
How many speakers are there?
How many more speakers do you have?
The only one was Mr. Garrett.
Okay.
Unless there's anybody else who wanted to
on the
speak.
next one. You'll go after Mr. Rich unless you want to speak to the next.
Okay, thank you. My name's Tony Rich. My wife and I live at 1960 Bethany Way in Milton. Good evening. My wife Sarah and I moved to Milton from Sandy Springs, and we purchased our farm in 2017. And we were drawn to Milton for a peaceful, small-town lifestyle. We like to ride horses. We like to play farmer, tear things up, get dirty, and we really enjoy living in the country. We moved up here to get away from the city and the crowds. We live approximately a half a mile straight down the road from the Painted Horse Winery. You know, when we first heard about the creation of a winery in Milton, we were pretty excited about it. This seemed to be a very unique, creative use of agricultural property, and we enjoy wine. What's not to like? At some point in early 2020, we noticed a noticeable change of what was going on at the winery. You know, we always noticed a few cars there during the day, but out of nowhere, the crowd seemed to get bigger and more frequent. Then one weekend, we heard music. We were sitting on our back porch one evening, and we heard music, and we couldn't quite figure out where it was coming from. We thought it was coming from our neighbor's basement, but it didn't take us long to realize it was coming from a half a mile away at the winery. Several times we've turned onto Bethany Way and found police cars sitting on the side of the road with blue lights flashing. The first time I thought it was a car accident, and I was really concerned. But now when I see the police, I know it's just another event at the winery. Weekends really haven't been the same in quite a while, and they've gotten worse in the last several months. The loud music and the traffic seem to happen almost every weekend. This small, quaint winery that we were very excited about on the front end has evolved into a full-blown commercial business that's impacting everything we love about living in Milton. The first time we met Pam Jackson, you know, we were here at City Hall attending the community information meeting on March 23rd. We expressed concern over the music during that meeting, and we were told by Pam that night that we were mistaken and that the music couldn't have come down from the winery because they're down in a hollow. And we weren't the only neighbors that night that brought up that concern. You know, as good neighbors should do, we went over a few weeks ago and we met with Pam individually and took a tour of the winery. And in all honesty, it's an absolutely beautiful place, and she's done a great job creating a niche boutique business in a nice, pleasant atmosphere until the crowds show up and then the music starts and then everything changes. There's nothing peaceful about it, especially sitting on our back porch a half a mile away. The amplified music is a problem, and I think Pam knows it. You know, acoustic background guitar music goes great with a glass of wine, but amplified music that we can hear a half a mile away at our house does not go well with wine. Let me say for the record, we don't have any issue whatsoever with this winery being in Milton. My wife and I would very much like to support Painted Horse, and we would go down there as frequently as we can to enjoy a glass of wine. And we support her application for the agricultural permit. And that's what Milton's all about, is riding horses and getting kids involved, and we are very much in support of that. But these other two permits, and I'm not going to come back up here and talk about the concert facility, but these are so incredibly dangerous for our small town of Milton. They have absolutely nothing to do with making wine. But what they do is it sends a strong message to us that this winery is nothing more than a plan to try to attract big crowds for more lucrative events like concerts and weddings. as a good buddy of mine told me recently, he said, if you go to a wedding, you want to do one thing. You want to drink and party and stay late. And if we allow weddings to happen down there, we're going to see quite a bit of that. I do think the traffic is an issue, but the unpleasant noise pollution, that's really going to impact all our property values, which is a real concern of ours. If we really want to, work on this and really make it an enjoyable, nice facility, I think you really need to think long and hard about these kind of events. Somebody referenced a minute ago about Little River Farm. I looked it up. Little River Farm is on 80 acres. Painted Horse is on 18 acres. I think someone commented that Little River Farm can have 250 people at an event. Well, Painted Horse is 22.5% the size of Little River Farm. So if you run those ratios, Painted Horse should have more than 56 people at an event, not 250. So, the numbers don't lie. Someone referenced the community event coming up. White Columns did send something out that on May 22nd, they're having the Bourbon Brothers Band. And we took a minute and we looked up the Bourbon Brothers website, and they've advertised 4 or 5, maybe a half dozen upcoming events at the Painted Horse Winery. And their website actually calls the Painted Horse Winery an outdoor amphitheater. So I think that's something that is very, very pertinent. So thanks for your time. Appreciate it.
Thank you.
So we only have about 30 seconds left for the 15 minutes.
Okay, thank you.
And we have 2 more speakers.
2 more speakers? Okay. Okay, if we want to go ahead and call up the first speaker, and then we'll see how much time they've got.
But Mr. Garrett?
Bill Garrett, 13450 Hopewell Road in Milton, right next door to the applicant. Gentlemen, best thing to sum up exactly what the applicant has in mind in this case by her own words. In the third application, which you're talking about the use for the rural and agricultural events facility. In her own words, he said, instead, the applicant is telling this commission, quote, in other words, events not related explicitly to agricultural, equestrian, or farm winery uses. So that's what she's doing. She's asking to be allowed the use for something other than what's authorized by the ordinance itself. The applicant is asking you to effectively rewrite the ordinance. They want you to eliminate the requirement of an 8-foot high, 100% opaque fence around to protect the neighbors. They want you to change the activity area standards, allowing parking to within 100 feet of a residential dwelling. They're asking you to modify the ordinance section to allow live music or band or disc jockey, to allow alcohol to be served, which is sold, up to 15 minutes before closing, and to allow an indoor entertainment business for 100, they've changed the 250 to 100 attendees, which is customers at any one time. And they want you to allow all events to continue 7 days a week, 10 o'clock Sundays through Thursdays, 11 o'clock Fridays and Saturdays. They want you to limit the noise factor to a maximum of 75 decibels. We've already talked about that as far as that, and nobody's going to be checking that.
Mr. Garrett, hold on 1 second for me, sir, if you could. So we've reached our limit.
Well,
Okay.
we're actually at 16 and a half minutes, but.
Okay, we're at 16 and a half now, so 1.5 over plus. Okay. Let's just incorporate that into potentially a new motion for additional time for the opposition to speak. We have Mr. Garrett, and then we still have at least one more. Right. Okay, and he's already 1.5 over. Okay. All right. Okay. Additional 5 minutes of motion has been made by Commissioner Gilbert.
Be clear, it'll apply to both.
Yes, it will apply to both sides. A second by Commissioner Locke for an additional 5 minutes, which includes already the 1.5 that we're over. So that's 3.5 more minutes left. All those in favor of additional 5 minutes, say aye. Aye. Anybody opposed? Go back. Mr. Garrett, you're on.
I'm trying to finish in less than that. Thank you. Already mentioned as far as the loud music is concerned, and that lady that was up here just a few minutes ago ahead of me, she described it exactly what's going on, and there's no need of me belaboring that at all. But approval of this request violates any approval of these last two requests on the part of the applicant, in my opinion, and I think if you look at it very closely, you're going to violate your duty as the councilman to approve it. The applicant is requesting a total rewrite of this section for personal gain and a total disregard of the surrounding property and owners and their neighbors. The applicant request is for one purpose and one purpose only, and that's to turn the property into a commercial entertainment center. This request has absolutely nothing to do with the intent of the statute. If you look at the intent of the statute, it pertains to the agricultural, excuse me, the agricultural I'm sorry, tenure of the area. And it has absolutely nothing to maintaining that standard. So, ladies and gentlemen, I'm asking you, I think the evidence would show, and I think what's been said here today, if you'll read the ordinance itself, it shows that these last two requests of the use should be denied. Thank you very much.
Thank you. And how much time do we have left, Robin?
2 minutes left.
2 minutes, okay. Yep, and you've got one.
Joseph Knaus, I'm sorry.
Hi, I'm Casey Sturm with Weissman, 1 Atlantic Center, 3500 Lenox Road, Atlanta, Georgia, and I'm here on behalf of Aaron and Joseph Knaus. I just want to make a couple of quick points, and that is, one, incorporate the comments from my prior discussion on the last use permit. That's for the record. Number two, I want to reiterate kind of one of the issues we've been talking about is that here we've got a bleed over again. So there's a problem between the use permit you were just dealing with and this current use permit. If you look at the last bullet item under the agricultural related use permit, it says events not expressly ancillary to single family residence, farm winery, or equestrian permitted uses, but tied to agriculture. If you look at the use designated here, it says events not primarily associated with agricultural operations, farm, equestrian, or farm winery use of the property. I mean, you just, in essence, approved the same thing in the last use permit. So we've got bleed over and we've got inconsistency. And that becomes a problem when we go to enforce. Is somebody going to be out there saying, are you here for the children use permit or are you here for the adult use permit? How do we characterize this and how do we enforce it? So that creates a legal problem for us as far as moving forward and how we deal with it. The restrictions on use, substantial compliance with the site plan that doesn't yet appear to be in the public record fully set forth. I will represent to you that I represented Mr. Harden up in Banks County. Banks County approved a land use based on a site plan that was not formally in compliance, did not have all information on it. We took it up to the Georgia Supreme Court. They overruled that land use decision. Based on noise, keep in mind that you are applying a noise concept that is geared towards commercial properties. So even though the applicant says they are reducing it, you are still applying a noise use directed towards commercial properties. So now you are now holding this residential community to a higher standard when it comes to violation of a noise ordinance, okay? Because that is not geared towards that.
Time's up. Okay.
And lastly, I would just say that, again, I think you get into the inconsistency between the two for enforcement.
Sure, okay. No, and I'll allow you to finish as well.
Any questions for her? I mean, she knows what she's doing too. I mean, there's a 5-minute question and answer with the soft talker, the other attorney. I think we're all talking soft to let this thing go through, but these are real issues for the real.
Okay, we'll allow any more comment. Obviously, we can allow any more comment as long as we'll make a motion for that. So let's go ahead and, is there any motions to allow additional comment on the opposition? I think this is is this the last comment? This is the last one? Okay. Okay. We have a motion for 5 more additional minutes, and we have a second. All those in favor? Anybody opposed? Okay, we have additional 5 minutes. Continue.
Thank you. I appreciate you all doing that. And I'm not here to take all 5 minutes. I think it's important you hear from this community on the ground. The only last point I will make as it relates to this particular use permit is this concept again with concurrent events and how, one, we identify those as concurrent events and how we deal with capacity that seems to be something we're maybe trying to impose as a body. And then on the flip end of that, how do you go about enforcing it? Is it something that legally can be enforced on the ground? And that to me is a huge problem, and how it's being presented is that I think the city is walking into a situation where on the ground we have a legal problem with enforcement. And then does this include the concepts again? So we talk about restrictions on use, and I'm looking at what the applicant updated it with, which I believe coincides with what the council or the staff has recommended. Again, this kind of substantial compliance with a traffic management plan that hasn't been circulated, that hasn't been put before the public, puts the public at a disadvantage to even be able to articulate clearly whether or not that plan is going to be beneficial in addressing any of their concerns. And so we raise that as a legal issue as well. And then does this particular use include these other music events? I think you've covered that in some of the comments. I think that's before you, but it seems to me that we've run a very slippery slope here with the concept of where is our agricultural use that is supposed to be first and forefront in the use designation here? Where has that become secondary to what is trying to be accomplished here? Thank you for your time. Thank you for listening. I'll turn it to Joe for on the ground.
Couple things. I have young kids. I have a 6-month-old. I have a 5-year-old. I have a 7-year-old, and I'm the closest house in Cooper Sandy Cove. And no disrespect to Mr. Garrett, but if he hears it, you can pretty much sure that it's being heard. It's heard in my neighborhood. I'm concerned about a few things. Counselor for the applicant keeps saying, well, we'll make these changes. We'll make these changes. I say deny everything until we see the changes. Can't rule on the fly. We can't actually analyze what they're doing when they're saying, well, we'll reconsider this and we'll reconsider this and well, we'll agree to this. Again, no enforcement. They've had a chance to meet with the zoning manager, the planning staff, et cetera, so they could craft their plan on how they're going to sell you and how they're going to destroy our property values. Everybody knows there's 2 high schools, there's a sports park on that road. And again, this particular use is going to combine alcohol and booze with teenage drivers and high traffic. So I'm trying to remain calm, but it's freaking ridiculous. Number 1, there's complaints. Number 2, I don't believe they're in compliance. Number 3, and I think they should have to cease and desist the activities they have now. You guys permitted something with this uncorked concert, but again, you cited the website. They've got 18 events on their calendar now. 18. There's like 7 of them that you approved for the whole series. And they are literally flouting the law right now. They're flouting noise complaints. They're flouting our concerns. Yeah, we can't clap. But the reality is, what's to say once you approve one thing, they don't flout it. They're not going to do a count. They're not going to pay the cops to turn people away. And the last thing, this is not relevant, but I don't think they're permitted, it was in your minutes last time, to sell foreign wine. I may be wrong, but they're not just selling their wine, they're selling everybody else's wine. 1.5 acres. 1.5 acres is being planted. All of this in a beautiful neighborhood. So I would ask you to deny everything and table it till they have a complete plan, so we have the ability to look at it, even their grandfathered stuff. Because the grandfathered stuff that they say they're continuing to do is what's continuing to be an escalating problem. So apologize if I raise my voice, but thank you for listening.
Thank you.
So that's pretty much the entire time.
That's the time. Okay. Do we have any other in opposition on Zoom? If so, please raise your hand. Okay. Okay, so I believe we added on 10 additional minutes, right? 5 and 5, 2 motions for 5 minutes and 5 minutes. So we have 10 additional minutes for those in favor of, and allow them an opportunity to speak.
Mr. Garrett is unhappy that I just walked up again. So a couple of things. I sort of don't know where to start, but let's start with this. Little River Farms, there is not a limitation on the use. Little River Farms falls in the same category as rural/agricultural event facility. Unlike the last use permit, where it was agricultural related activities and the code said need to be tied to agriculture, and we had a whole discussion about that. This section of the code does not require an event be tied to agriculture. That is why it is a rural agricultural event facility, because it is on agriculturally zoned property. So I'm not standing before you, no one is standing before you saying that a wedding is tied to an agricultural event, and that is not a requirement of the code, and no part of the applicant's application has included that. With respect to the parking in the site plan, and due respect to counsel who's won at the Georgia Supreme Court, congratulations, that is not saying that this body and the mayor and council, when they consider an application, cannot consider conditions on a site plan. I have admitted that we would provide, and should you choose to consider this as a proposed condition, that we would provide a revised plan within the next week to show parking, to comply with the numbers that we have proposed this evening, both with respect to the first use permit, with respect to this one, when we get to the next one with respect to it. With respect, I'm not suggesting that you recommend approval of a site plan that is not to be put in the record. And so I'll just put that out there. Mr. Gilbert, you asked when I spoke before, would we agree, and will we agree regarding live concerts? We would agree to a condition that says we will not have concerts. Ticketed, not ticketed. We will have live music. It will be in addition to, an ancillary to an event, whether that is a wedding, whether that is a corporate event, whether that is a birthday party. It will not be a standalone concert, and we will agree to that. We also, just so you're hearing it, we have had noise complaints. Mrs. Sullivan has called the police. We have not violated the noise ordinance. There has not been a noise citation issued ever with respect to this property. I say that to say, no one is saying, we did say, and it was a mistake at the CZIM, that you couldn't hear something. It wasn't arguing about whether someone could hear. It was a surprise that someone could hear it and it would violate the noise ordinance. The noise ordinance is not a requirement for silence. That is true for any property owner. Any property owner can have a party in their backyard without a use permit. The city's noise ordinance applies, whether it's a residential use, whether it's a commercial use, or otherwise. To that end, the average decibel readings that the police of Milton have taken when they are off duty and serving at our facility is between 52 decibels and 64 decibels. We have not exceeded 64 decibels. And we would agree with respect to this use permit to reduce the levels that we've proposed to a maximum continuous sound level of 57 dBA and a maximum peak sound level of 65 dBA at property lines. That is more than 20 dBA, there's my math for you tonight, lower than what the noise ordinance otherwise allows. We would propose that. I'm happy to answer any other questions. I appreciate your time. We respectfully request your approval of this use permit with the conditions that the staff has recommended and that we've just proposed. Thank you.
You have additional time?
Less than 6 minutes.
Okay. Is there anybody else who wants to speak in favor of? Okay. Have you already got a comment card? Okay.
Hey, I'm Brandon Johnson. I live at 13865 Haygood Road. Just want to say that, there's all this talk about preserving the rural character and the agricultural character of the city of Milton. And this is the perfect opportunity to help support agricultural business. I think that we need to make every effort to support all these local agricultural businesses, because if we don't, they're not going to be here for too much longer, because these large tracts are going to slowly turn into neighborhoods. This is an opportunity to do, what we say we're going to do and support agricultural business. And I hope you approve this. Thanks.
Thank you. Anybody else in favor of who would like to speak? All right, duly noted. Anybody else who wants to speak? Comment cards, okay. Do we have anybody on Zoom who would like to speak in favor of? If so, please raise your hand. No. Okay. At this time, then we'll go ahead and close the comment in favor of and open up the floor for any questions that the commission may have, staff, or applicants.
So have there been any noise complaints submitted to the city? Have there been any noise complaints submitted to the city regarding the music at this venue? There have been, okay. And how about the fortified farms permit? It's issued, it's not being utilized. Is it basically the same kind of permit?
Going to have to turn that over to Robin.
The special event permits you're speaking to?
Over across the street,
Across the street.
the runner place.
Oh, I'm sorry. Yes. So the applicant received that use permit a few years ago, I think 2014. They never initiated starting that business. So it does not operate at this point, but that is true. The other attorneys and other people stated they could utilize the use permit, but the concurrent variances have been expired. So if someone was to seek purchasing that property, I believe it's up for sale, and they could come to the Board of Zoning Appeals to ask for the appropriate variances to start up that use.
So as we speak, there's no way that there could be two events across the street from each other at the same time.
I'm sorry, there could be, because we do not have any distance requirements between use permits for rural event facility. We do for other use permits, but not for this one.
So on the music, you agreed to lower the decibel levels. Would you also be willing to do acoustical only, no amplified?
I don't think so on this, only because I don't know about wedding bands. I mean, I'm not an expert on that, but I think that, to be fair, the city's noise ordinance isn't limited on acoustical versus amplified. My understanding too is you could have an acoustical guitar, but amplified voice, right? So you could have so I think it's splitting the hairs too finely. If we agreed though to the decibel levels significantly lower than.
I'm trying to figure out a way to make this work.
I know.
And I'm getting two different opinions. Where it's operating now, the neighbors can hear it. So if we want to continue to offer music at the venue, we have to figure out a way to bring the volume down somehow. so that neighbors aren't interrupted or complaining about it.
With respect, my understanding is that the live ticketed music events have been where the bulk of the complaints have been. And to clarify, I didn't say there hadn't been complaints. I don't think there have been any citations issued for violation, just so we're clear. I'm happy to ask the client that question, but like I said, I think there's a difference between having a microphone for vocals with acoustic guitar from a noise level or hearing it. I'm not sure that that's the best way to judge, but I'm not a sound expert. Certainly you could make that a condition. Yes, sir.
Could you bring up where the exact location of this?
I can if, how do I get off?
I guess the stage.
Yes, sir, I will.
Now, is that, oh, that's okay.
I have it.
No, it's
on my
already
notes.
on here, yeah. I have it on the other one.
Sorry.
It's okay.
I have the site plan in front of you. I can. Sure.
Well, I can do this.
That's fine.
There we go.
That's on there.
Right, okay.
There's the house,
Okay.
the pool.
Okay, we have it here, so if you want to point, you
That
can
little
just
thing
point.
right there. I'm in the middle of the yard.
It shows up better on,
It's right where in the middle of the cursor. So that's, sorry, about a 750 square foot wooden platform. I have a picture of it if you
Same thing, yeah.
want to see it. Sorry. I guess I'm the low talking attorney. Is that what I was called? It's the stage soft. It's the stage is right in the middle of the four arrows and where the cursor is pointed.
But my question was going to be that in the proposed future wineries and tasting room is now going to be moved out very, very close to the roundabout.
And as an enclosed, that's a fully enclosed building, yes, sir.
Understand, but is the entertainment going to be there at the tasting?
There could be inside, acoustic guitars or musicians inside, yes.
Oh, that's going to be inside.
As part of that building is enclosed. It is a winery building. It will primarily house the winemaking, and our winemaker is here, and the offices for the winery, but also there will be a tasting room. Currently, the tasting room is limited to no more than 15 people.
Thank you.
Yes, sir.
I know whenever you had stated that, and again, I don't know if it's just a terminology or whatever, but you were saying rural agricultural use facility, but there's no different. We just have rural event
That's what
facility.
it's called.
Rural event facility.
Rural event facility.
Is it not rural/agricultural event facility?
Okay. So one,
It says rural event.
I think it's rural/agricultural, whatever the ordinance says.
okay, I just wanted to make sure there was
They're
no,
not two.
there was no, yeah, there wasn't two. Okay.
It is rural or agricultural.
Rural agricultural event?
Or.
It's a slash.
Got it. Okay.
It's not a slash, it's an or.
Okay.
Okay, got it. But it's just one, it's the same, one and the same.
One and the same.
One and the same, okay. Now, and again, I'm just gonna, broad questions, but number one of the recommendations that staff had mentioned was something about the facility being closed at 11 p.m. And again, I had asked you earlier, kind of, the intent here is an outdoor event, basically, or this is gonna be outdoor event. So if there's a condition that says something where, quote unquote, the facility is gonna be closed at a certain time, And from your standpoint, what would that mean? Would that mean, I mean, that's it, nobody else
That
is
means
there?
nobody's there.
The people working there,
Everybody's
nobody is
gone.
there. Everybody is gone by that time.
Correct.
No, we're not just only talking about attendees, we're talking about,
People are gone. They're- Except for the people who live there.
except for the people who live there.
Yes, sir.
Nobody else can be there.
Correct.
That, if on Friday and Saturday nights, the event goes till 11 PM, there's no way everybody can be gone at 11 PM.
If there is music associated with it and it ends at 10, and they say you have to clear out,
It says all music ends at 10 PM, but it says the hours of operation on
Yes.
Friday and Saturday are 9 to 11.
And that's the recommended condition that staff had presented, yeah.
Yeah, there's no way that the facility can be.
yeah, there
always
is, and it's
by
that
11.
you tell people who are booking an event that they have to be gone by then, and you start clearing out by then. That's no different. That's like saying a bar closes at whatever time your bar's closed. They have to be gone by then.
So, yeah,
They live there, they don't.
right. So if they live there, they don't, but, you know, in hearing what we've heard, we're talking about a number of staff and the number of people that may be at events. I don't know how everybody, including staff, could all leave by 11 o'clock and the place is shut down.
How is you say that's the end?
Yeah, I understand. No, I understand that. Again, I'm trying to clarify because I'm not sure if these recommended conditions kind of came from you all in discussion with
They are-
staff. And
They are
you know,
directly from Little River Farms, conditional use permit.
as to what they have.
It is.
But does Little River Farms, you know, I know we're using that comparison, and again, it's potentially a different property, but when we're talking about facility, is there some sort of a actual structure of a facility, or you're talking about outdoor events as well, only over there as to what you're talking about here?
I believe there's also an indoor
They have indoor facilities.
facilities.
They have outdoor, but they also have indoor, so, yes.
Outdoor and indoor, and they're
I
having,
just want to clarify that the use permit only covered 40 acres. I know the Ivy family owns 80 acres, and part of it, they're developing into a subdivision. But the use permit for the rural events or agricultural permit is for 40 acres, so.
If there's a concern about the hours of operation, we're certainly happy to try to address those.
right. I mean, obviously, I mean, again, there's plenty of opposition and plenty of complaints about noise and traffic, and that's a huge concern. And again, you know, as been stated already, and I don't know if there's a happy medium. I don't know if there's any way to, you know, have something like this here and make it so that it's not going to infringe on other people's, you know, and where, you know, nighttime traffic, music, this and that, you know, whatever the case may be. And again, I'm just trying to get an understanding from, and I'm glad you stated that, but I'm trying to get an understanding of where these kind of conditions came up, you know, and just kind of contemplating, like, how can we figure out something here that may or may not work, I'm not sure, but, you know, just trying to get some answers or some more background as to kind of where, you know, where you all are coming from. What's the plan? What's the business plan? What's the, you know, what's the goal with this rural or agricultural event facility? And that way we have a better idea and know, hey, this is what the vision is. It's, you know, this is what our plan is. This is what we foresee this being. And, you know, again, I don't want to create a situation where it's open-ended potentially, and you can keep on doing other things, you know. And again, if we have a defined parameter as to what you are intending to do and what this facility is supposed to be, then we can kind of, you know, have more of a discussion on hours and operation and, you know, how we can figure this out.
Understood. So this is no different than the last one in that the goal for this particular application is to reflect historic uses and to reflect the intensity of historic uses aside from live, ticketed, solely music-driven events, which we did have in the past, but the intensity of which has increased. So with all due respect, I think what you've heard tonight is that music events and noise and traffic associated with primarily music-driven advertised events is the concern. So with respect to this particular application, if we are agreeing that music will not be the primary event, and we are agreeing to limit the number of people, and we are agreeing to limit the number of events per week, and we are putting forth hours of operation, and we are putting forth significant limitations on sound and noise, I'm more than happy to say we are only going to have these events within the existing structures that are built. And I say structures, the stage, which I pointed to, I should note, and it's not up anymore, but there's a rectangle right to the north of the stage that was to be a covered picnic area, like a rain shelter. That is not going to be built with the revised site plan. That will come off. But I'm happy to entertain additional limitations or considerations to give you an idea. But the idea is to self-impose limits. The term that the city has used to us has been mission creep. I think at one point there was conversation about expanding nonconformity of uses. There has not been an expansion of additional property. Ms. Jackson has bought property that is going to be used for the winery building, and she has had property that she is having taken from the city for the roundabout. So if you look at the net, there is not an expansion from a property or a use perspective, and that's not the goal. The whole purpose of being here is to address the question of grandfathering. We dispute, the city has taken a position, we are here in good faith to try to resolve that. So there would not be a question about what we claim is grandfathered or what is not. This is the opportunity to say what we can do.
Right, and I understand that, and again, that exactly is one point then where if you're not going to basically go forward with this continued argument about a grandfathering, then you can't also then say historically this is what we've been doing and we want to continue historically with going forward, because potentially it wasn't allowed, and now we're looking at a use permit to allow some of these things to happen. So just because it may have been happening before doesn't mean that it's supposed to be happening. And going forward, we may want to change the way that it's going to, what's going on here, so that it can be controlled.
I respect that. Both the city has reserved its rights with respect to its position, and we have reserved ours. But before you is the question of, let's define, and again, just like the last one, it may be easier to define what we cannot do. We will not build a new facility that will be an event structure. We can't. We're limited by a site plan which shows structures. I'm happy to identify the other locations where there are weddings. There are 2 or 3 gazebos. There's the stage, which I've pointed out. Everything else happens outside.
Anybody else got any other questions? No? Okay.
Thank you.
Thank you.
Have a complete plan?
Oh, please. Okay. Any other questions for staff or the applicant, city attorney? So, I have a question for the city attorney, and again, so going back to, again, this is obviously coming up for a use permit. If this were to be denied, or we were not to recommend this use permit, and then it would go to council, and let's say council does not recommend this use permit, then at that point, are these events that are going on right now that they're wanting this use permit for, would they no longer be allowed?
That's the city's position.
Right, okay.
I mean, you said these,
Like basically.
There are certainly events
Sure.
that occur as part of an event facility that the city's position is it would not be.
It would not be allowed because the city's position still is, this is not grandfathered. They need to have this use permit to be able to do these events. And obviously we could set whatever parameters we want to set in our recommendation for this use permit.
Correct.
Okay.
Is that only after council, if council were to reject it, or is that currently ongoing? Is the city's position currently, no matter what we decide here or not, that those events are not allowed? You know what I'm saying?
Well, I think the city's position is that they're not allowed. If this were to legalize them, by approving the permit, kind of seeing which direction it goes. Or doing something that initiating.
Yeah, that was at the beginning, Paul, that was where I was trying to get clarified, was whether or not the grandfathered part of it, after we did this, comes into play again.
If this were denied, the dispute over whether or not it's grandfathered would then be the current state of affairs. The city would take the position that it is not grandfathered use and would proceed with whatever enforcement action.
Okay, but I'm sorry.
Necessary.
But back to what Samit.
Please.
What Samit said, these 20, and I hate to get to this because it's in the next part of the concerts, but they're scheduled at 22, I believe. But again, back to that point, are we saying as a city that those can continue until such time under said, whether it's right or not, grandfathered?
You talking about for the festival events?
Yes.
I'm not aware that those have been allowed to proceed.
Okay.
So basically, again, and even if we were to recommend something right now, technically speaking, until council were to approve this use permit, they could not continue forward with these events under a rural event, facility use permit or whatever category of events that they're trying to do until it actually gets approved by council.
It's my understanding that the city has voluntarily for the rural event facilities a limit, well, I don't know, rural event facilities?
No, they're not.
No, just for the winery.
You can, they wouldn't be able to have a wedding right now.
Right.
Okay.
Put it in plain language. This would have to go through the process now, and it would go before council. If council were to deny it, they still couldn't have weddings. And in fact, the only way they could have a wedding or a similar type event would be if it was approved by council.
Mm-hmm. Okay.
But they've been having weddings for years now.
Similar to what I believe Paul said earlier, or someone did say, just because these things went on does not mean they were allowed to go on.
Right.
It doesn't create a grandfathered situation.
I understand.
Right. Okay. Anybody else got any other questions for staff or applicant? Okay, then anybody got any motions? Or just, yeah, any other discussion? Yeah, we can have any other discussion.
I just have a comment. I guess number one, I like the idea of having the farm winery in our community. And I know that a lot of wineries have, to the point that the Georgia person was talking about, they have had to diversify to make their businesses more equitable for them. A lot of wineries host weddings. Some of them have guest cottages and all kinds of things. They've got a lot more property than we have here in Milton, but it's not an uncommon thing for a winery to get into weddings and family reunions and events. So I don't think that's such an unusual request that they're making. I'm very sensitive to the neighbors. I wouldn't want a farm winery right next to me, even though I enjoy wine. But I think that based on the size of this, it's 18 acres. It's small in comparison to little farms or some of these wineries up in North Georgia. And it could be, I think it could be a very good event facility for our city. Again, if we put the right kind of restrictions in it on the size and keep the music down where it's not keeping the neighbors up at night, and we monitor the traffic with traffic control and close it down at appropriate hours, I think it could be a real nice asset to the community. But clearly there's some issues now, and if we can address all of those and make it fit, I think it could be a good thing for us.
I think part of the issue is having the late hours. At least for me, that seems, the later you get into the evening, the more problems you come because of traffic and darkness. And to me, it seems unreasonable to think that you're going to shut a thing down at 11 and everybody's going to be gone at 11. So now you're at 12 or 1. Mm-hmm. Maybe it might be wise for us to send this back and let them rethink the hours of operation. Me, I think there's a big difference between, daytime weddings and et cetera versus these that are in the evening that disturb a lot of the neighbors and can create traffic problems, especially if people are drinking and it's dark.
I'd like to make a comment as well. I don't think there's anyone up here that isn't supportive of the agricultural activities that are at the Painted Horse or the winery. The birthday parties and pony rides are hits in the community. Prior to the meeting this evening, I spoke to a few people around town. And Pam, you should know, you have created a lot of fond memories and love around here. And as a matter of fact, the young lady who came up and spoke earlier was sort of emblematic of that. As I think about it, I get the sense that things are beginning to change. You have begun, you have ventured further afield if not in this particular area, then very clearly in the subject matter we're going to be talking about next time. And there's a morphine that I see going on here from something that's agricultural, winery, pony rides, et cetera, to something that's more commercial, becoming more commercial. And with the commercial comes, the side effects of the commerciality, the noise, the traffic, and in this case, some additional liquor consumption. And I'm beginning to conclude that this may well be inconsistent with what we would want in a character area of rural Milton, and especially because I believe I'm hearing that it is beginning to impede people in the quiet enjoyment of their own homes. And so while I really appreciate what you have done for the community thus far, it's going to be a long putt for me tonight.
Well, I mean, I guess my big issue with this is the frequency. You know, based on this, I could have something till 10 o'clock every other day. Yeah, and up to 100 people, or is it 100 people every other day till 10 or 11 o'clock, I think is not appropriate for that area at all. You know, I like the fact that, you know, they're willing to reduce the decibels, and I guess on the original one, on the first one, I was willing to concede that be more willing to work, because, yeah, this is what was there. This is new and additional, and again, I don't think this is the place to hammer out, you know, what should we do? I think we should vote on these, because this is something new completely as what we have here, as a packet with the information we have here. So I guess I'm not willing to bend or add additional conditions to it, because again, it is new, it is more commercial, and I personally don't see it fitting where it is.
Else got any comments?
I think when you look at the events they've named, I think the likelihood of having 4 events a week is slim to none. Maybe around holiday season, but weddings are maybe on a Friday. Most weddings are Saturday. So
most of what they have on the calendar right now,
but I think that isn't the 15, again, it's kind of all getting blurred, but isn't the 15 go to the next issue?
We don't know. We were told that the free music fell under this one.
Now, I thought the music in this one falls ancillary to a wedding. They've got it spelled out: wedding, corporate events, team building events, and that's where it comes to 4 events a week. I think about holiday parties. You've got it basically November to January, maybe wedding season, spring. So
hold on.
That's what I'm just trying to clear up. I think that, I guess personally, I'm okay with where we are right now with the rural event facility. I think it sounds like some of the concerns come to the next. We keep talking about these 22 events and this thing with white columns. Sounds to me like, unless I'm missing something, you guys tell me that that's in the next item.
No, that's in this one.
But the next one's got very specific dates, once a month.
Okay.
What they'll do, ticketed events. That's it. That's why I was asking.
These are free. Free concerts.
These are
and,
free concerts.
Music bingos here.
Yeah, so here's what they're doing. Next one, ticketed events, those are the only days there. So, and again, there's some ambiguity around that too, as far as what are the things on their calendar? Where do those fall?
Got you.
Anybody else have any other discussion? Okay. Anyway, any other questions for staff? I'll open the floor up for any motion or.
Well, I'd like to move that we recommend the denial of U-2102.
I'll second that.
Okay, we have a second, and the motion is to deny U-21-02, that use permit. Any discussion? All those in favor say aye.
Aye.
Anybody opposed? Commissioner Middlebrooks he's in, yeah, okay. He's in opposition, okay. All right, so U-21-02 has, our recommendation is to deny that use permit. All right. You good to go forward? You may need a break. All right. We are calling and sounding for now U-21-03 VC21-04.
That one, are we going to consider this one?
Okay, our last and final use permit request is for festival or events, indoor, outdoor, U-21-03, VC-21-04. that contains 7 part concurrent variants. Festivals or events, this section includes, but is not limited to horse shows, carnivals, dog shows, arts and crafts shows, music festivals, etc. So this is the definition that comes under the use permit itself. These are the standards that are required for the use permit. There are some that are met, and then there's a few that are not met. First one is the 8-foot high, 100% opaque fencing around adjacent to residential districts or AG1 districts used for single-family dwellings. They're requesting a concurrent variance for that. Further on, for a maximum continuous sound level of 60 dBA and a maximum, I'm sorry, I'm getting late, I'm sorry. It's number 4. Activity areas, including parking, shall be at least 100 feet from a residential district or AG1 district used for single-family dwellings. They're asking for that. Number 6 was a sunset clause, or not a sunset clause, but the festival or event shall be limited, yes it was, to a 3-year period from the date of the city's council approval, not to exceed a total of 180 consecutive days in a calendar year. And since the original submittal, the applicant has said that they would be willing or want to cease that operation after their December 2021 concert. So this is the applicant's revised of the 21st of April request. Uses, festivals or events including ticketed live music concerts and events that are not merely background accompaniment to augment the permitted agricultural operations, farm, equestrian, or farm winery permitted uses, community events like an annual Easter egg hunt. Restrictions on use, maximum stage and area for ticketed live musics. A, maximum 250 square feet for live music stage, the wood pavilion on the site plan. And B, maximum 7,500 square foot area for live music lawn, concert attendees, including covered picnic winery shelter. Substantial compliance with site plan, substantial compliance with events traffic management, no temporary tents over 400 square feet, no portable generators, portable electrical cables, or other open temporary electrical systems, no pyrotechnics, fireworks, or other open flame devices, only food to be sold on site through Q Barbecue, only alcohol to be sold will be through Q Barbecue offsite catering license and through the farm at Pamela via the farm winery wine only, and no temporary or other event signage to be used. The months, days, and hours of operation, only the following Saturdays, after which they're proposing to terminate. So they have the listing of the 7 events, and then musicians to arrive at 4:30, gates to ticketed attendees to open at 5, music to be performed between 6 p.m. and 10 p.m., and facility to be closed at 11 p.m. So notes that they included were live music to end no later than 10 p.m. And then again, the maximum continuous sound level of 60 dBA and a maximum peak of 75. Alcohol service shall cease 15 minutes before music event ending. At least 2 off-duty police officers on site for each of the requested 7 events. Attendees not to exceed 200 for any single event. Site development considerations, these are similar to what was previously regarding bathroom facilities and trash and lighting. So we'll get straight into the concurrent variances request. The first one is to delete the requirement for an 8-high 100% opaque fence adjacent to residential districts or AG1 districts used for single-family dwellings. Staff states the required 8-foot opaque fence would be inappropriate for the rural landscape that is indicative of Milton. The subject site already has an equestrian-style fence surrounding most of the property. An opaque 8-foot high fence is not an allowed type of fence where it can be seen from the right-of-way per our code. Relief, if granted, would not offend the spirit or intent of the zoning ordinance based on the intent of the area to be rural in character by utilizing an equestrian-style fence and existing landscaping instead of an 8-foot opaque fence. The request does not offend the spirit or intent of the zoning ordinance. Number 2, there are such extraordinary and exceptional situations or conditions that requirement or is the amount of 8-foot high opaque fencing surrounding the 18+ acre property will negatively impact the bucolic rural atmosphere that currently exists on the property. The requirement for an 8-foot high opaque fence in this situation is an extraordinary and exceptional situation or condition not caused by the applicant. Relief, if granted, would not cause a substantial detriment to the public good and surrounding properties. The actual activity for the music venue is located inside the property, and the proposed equestrian fence and existing landscaping provides a demarcation of the site, and so as not to cause a substantial detriment to the public good and surrounding properties. Lastly, the proposed fencing and landscaping provide for the public safety, health, and welfare, and that substantial justice is done. Therefore, staff recommends approval conditional of Part 1, VC 21-04. The second concurrent variance is to allow the existing parking within the 100-foot from a residential district or AG1 districts used for single-family dwellings. There are 13 parking spaces that exist within 100 feet of the property line. Relief, if granted, would not offend the spirit or intent of the zoning ordinance. Based on the small number of existing parking spaces and large area to relocate the parking to other locations, the existing parking in the 100-foot setback would offend the spirit or intent of the zoning ordinance. There are such extraordinary and exceptional situations or conditions pertaining to the particular piece of property that the literal or strict application of the zoning ordinance would create an unnecessary hardship due to size, shape, or topography, or other extraordinary and exceptional situations or conditions not caused by the variance applicant. The location and number of parking spaces can easily be relocated elsewhere on the property, and therefore there are no extraordinary and exceptional situation or condition not caused by the applicant. Relief, if granted, would not cause a substantial detriment to the public good and surrounding properties. By allowing the existing parking within a 100-foot setback, it would cause a substantial detriment to the public good and surrounding properties based on the location near adjacent property lines. Lastly, that the public safety, health, and welfare are secured and substantial justice is done. There are only 13 parking spaces located within the 100 feet of the property lines, adjacent properties, and the applicant has sufficient area to relocate them, and therefore the public safety, health, and welfare are not secured. Therefore, staff recommends denial of VC 21-04, Part 2, to allow the existing parking to remain within 100 feet of adjacent property lines. Part 3, to eliminate the 3-year period from the day of the city's council approval based upon the updated information, staff is recommending withdrawal of that concurrent variance, Part 3. Now we're going to turn to the Rural Milton Overlay District. We dealt with the development standards for the actual use permit and any associated variances. Now we're going to turn to the Rural Milton Overlay District. The site plan meets most of the rural standards, but there are some that do not, and we're going to talk about that. Also, I want to note that this proposed use permit falls under in that table in the Rural Milton Overlay under the commercial type uses. So that's where we go to look for the development standards. So Part 4 is a requirement that they're asking relief of to allow the 10-foot wide strip along all public streets to be planted with existing landscaping vegetation along Bethany Way and Hopewell Road. Relief, if granted, would not offend the spirit or intent of the zoning ordinance. There is significant vegetation landscaping that exists along these two roads that over time has become very natural and organic to the area and is very rural in character. Therefore, the existing vegetation does not offend the spirit or intent of the zoning ordinance. Again, there are, number 2, such extraordinary and exceptional situations or conditions pertaining to the particular piece of property that the literal or strict application of the zoning ordinance would create an unnecessary hardship due to size, shape, or topography, or other extraordinary and exceptional situations or conditions not caused by the variance applicant. The amount of road frontage to install a new 10-foot wide landscape strip would be onerous to the applicant, as well as the existing vegetation provides the intent of the ordinance. It is staff's opinion that this requirement would be extraordinary and exceptional, not caused by the applicant. 3, relief if granted would not cause a substantial detriment to the public good and surrounding properties. Again, the existing vegetation along Bethany Way and Hopewell Road will not cause a substantial detriment to the public good and surrounding properties. That the public safety, health, and welfare are secured and that substantial justice is done. It is staff's opinion that the public safety, health are secured and that substantial justice is done if the concurrent variance is approved to allow the existing vegetation to replace a 10-foot landscape strip. Therefore, staff recommends approval conditional of VC 2104, Part 4. Part 5 is, again, this is to the rural Milton Overlay District, to reduce a 75-foot wide undisturbed buffer or alternative screening design with a 10-foot improvement setback and a 10-foot improvement setback adjacent to all AG1 zoning districts where existing structures, driveways, activity areas, and parking are shown on the site plan. Relief, if granted, would not offend the spirit or intent of the zoning ordinance. The approximate 18-acre site contains both pastures and a large amount of tree cover, of which some are adjacent to exterior property lines. In addition, where the primary activity areas are located near the northeastern property lines, there's some trees that abut the adjacent properties that provide some screening. Adjacent to the west and the southern property lines, there is an 85-foot setback, of which a large majority provides significant screening to adjacent properties or parcels. Therefore, it is staff's opinion that relief, if granted, would not offend the spirit or intent of the zoning ordinance. Staff notes that the existing parking within the buffer should be relocated outside of the 100-foot activity setback as required. Sorry, so that was from the last one. So therefore, it's staff's opinion that relief, if granted, would not offend the spirit or the intent of the zoning ordinance. There are such extraordinary and exceptional situations or conditions pertaining to the particular piece of property that the literal or strict application of the zoning ordinance would create an unnecessary hardship due to size, shape, or topography, or other extraordinary and exceptional situations or conditions not caused by the variance applicant. The required 75-foot undisturbed buffer and 10-foot improvement setback would create unreasonable constraints on the property, given the large size of the lot, and possibly render the equestrian and vineyard areas unusable, and therefore exceptional situations not caused by the applicant. Relief, if granted, would not cause a substantial detriment to the public good and surrounding properties. The existing large setbacks and existing vegetation along some of the adjacent property lines would not cause a substantial detriment to the public and good and surrounding properties. Lastly, that the public safety, health, and welfare are secured and substantial justice is done. It is staff's opinion that the public safety, health, and welfare are secured and that substantial justice is done if the concurrent variance is approved with the submitted site plan. Therefore, staff recommends approval conditional of VC 21-04, Part 5. Part 6, to eliminate sidewalks along Bethany Way and Hopewell Road. That's another requirement of the rural Milton overlay. Relief, if granted, would not offend the spirit or intent of the zoning ordinance. The elimination of sidewalks would not offend the spirit or intent of the zoning ordinance because there are no public parks or public schools within a quarter mile of the site, which is the metric used when evaluating if a sidewalk is required for non-commercial type uses. 2, there are such extraordinary and exceptional situations or conditions pertaining to the particular piece of property that the literal or strict application of the zoning ordinance would create an unnecessary hardship due to the size, shape, or topography, or other extraordinary and exceptional situations or conditions not caused by the applicant. Although the use permit is considered a commercial type of use, it is located within a large lot, equestrian type area of the city where there are no existing sidewalks on the same side of Bethany Way and Hopewell Road, and to construct sidewalks for the entire 2 frontages would create an unnecessary hardship due to size not caused by the applicant. 3, relief, if granted, would not cause a substantial detriment to the public good and surrounding properties. Based on the fact that there are no sidewalks already existing on the south side of Bethany Way and the west side of Hopewell Road, it would not cause a substantial detriment to the public good and surrounding properties. Lastly, It is staff's opinion that the public safety, health, and welfare are secured and that substantial justice is done if the concurrent variance is approved without the sidewalks constructed. Therefore, staff recommends approval conditional of VC 21-04, Part 6. The last concurrent variance is to allow for a lighting plan without light pole installation. The overlay district requires parking lot lighting with light poles. The applicant intends to keep the parking areas informal and they are scattered throughout the property. The intent is to only provide lighting that is needed for safety and accessibility. Relief, if granted, would not offend the spirit or intent of the zoning ordinance. The applicant will only install low to the ground and or required lighting for safety and accessibility that will still provide a minimum amount of light to blend in with the rural character of the area and therefore would not offend the spirit or intent of the zoning ordinance. 2, there are such extraordinary and exceptional situations or conditions pertaining to the particular piece of property that the literal or strict application of the zoning ordinance would create an unnecessary hardship due to size, shape, or topography, or other extraordinary and exceptional conditions not caused by the applicant. Based on the rural character and small areas of parking, this is an exceptional situation to require light poles for parking not caused by the applicant. 3, relief, if granted, would not cause a substantial detriment to the public good and surrounding properties. By not installing traditional parking lot lights on poles, but low to the ground lighting, it would not cause a substantial detriment to the public good and surrounding properties. Lastly, that the public safety, health, and welfare are secured and that substantial justice is done. It's staff's opinion that the public safety, health, and welfare are secured and substantial justice is done if concurrent variance is approved without the use of parking light poles. Therefore, staff recommends approval conditional of VC 21-04, Part 7. So again, in the next set is we're looking at the use permit considerations. So this is whether the proposed use is consistent with the land use or economic development plans adopted by the mayor and city council. The proposed development is within the AEE land use category of the 2035 comprehensive plan map and contained in the comprehensive plan update 2016. The proposed use permit for a festival event indoor outdoor is permitted in the AG1 agricultural district. In addition, the following plan objectives are consistent with the proposed use. We will encourage the preservation of natural resource areas and preserve contiguous green spaces, development of land in appropriately designated areas as development occurs. We will seek opportunities to provide pleasant, accessible public gathering places and parks throughout the community. We will encourage development that is sensitive to the overall setting of the community and will contribute to the community's sense of place. 2, compatibility with land uses and zoning districts in the vicinity. So this again is the same where we have various large lots to the north and northeast with single family residents as well as equestrian related facilities. As noted before, there's the festival event indoor outdoor was approved at 13895 Hopewell Road to be used as a wedding facility in 2014, but has not been operated in this capacity thus far. Again, to the east are scattered single-family residences and the Bethany Oaks subdivision, zoned AG1, and North Park subdivision. To the south are large lots developed with single-family residence and equestrian-related facilities. To the southwest is Cooper Sandy subdivision, AG1, with single-family. To the west are large lots developed with single-family residence and equestrian-related facilities. Based on these surrounding uses and zoning, it is staff's opinion that the proposed festival event outdoor-indoor use permit is compatible with surrounding land uses if approved with the recommended conditions. The proposed use does not appear to violate any ordinances or regulations governing land development if approved with the recommended conditions and development requirements. The proposed use effect on the traffic flow, vehicular and pedestrian along adjoining streets should be limited based on the applicant's request to have only one event per month, but ceasing after December 2021. The maximum number of attendees proposed is 200. In addition, this use should not be allowed during an event permit allowed under the agricultural related activities or rural event facility use permits. This would cause a burden on the adjacent and nearby streets. The location of the 55 off-street parking spaces is scattered around the approximate 18 acres. There are 12 spaces near the western portion, as I mentioned before, and an additional 6 spaces to the north of the 12. Just continuing on, in addition, there are 37 spaces located on the north, central, and eastern portion of the site, of which portions of these spaces already exist and are located within the required 100-foot setback for parking. It appears that there is sufficient room to relocate the existing spaces that are within this 100-foot setback, as well as relocate the proposed spaces outside of the 100-foot setback. Staff notes that the use permit requires music festivals related seating to provide 2 spaces per 1,000 square feet of seating area. The applicant has stated there is 7,500 square feet of seating area, which would require 15 parking spaces. In addition, the existing winery may require that parking occur concurrently with the music venue. The proposed site provides adequate open space since there is approximately 18 acres, including a stream that cuts through it and provides the appropriate 75-foot buffer on either side, as well as pastures, vineyards, and other open spaces. It is staff's opinion that existing vegetation that is located on the property and in most places located along near its exterior property lines is sufficient to provide screening for the proposed limited impact of the requested use permit. The hours and manner of operation. The applicant has proposed the following days' times of operation on the following Saturdays, after which this use permit will terminate. So there's a listing of 7 different events, June through December. It says musicians to arrive at 4:30, gates to ticketed attendees to open at 5, music to be performed between 6 to 10 p.m., live music to end no later than 10, and facility to be closed at 11. The applicant has not indicated any additional lighting on the site except if required for life safety and will comply with the night sky ordinance. And lastly, ingress and egress of property. There are 2 existing curb cuts on the property along Bethany Way. Again, it was corrected. I believe that there's additional curb cuts on both Bethany and Hopewell, but a future curb cut, new one, will be built by the city at the time of the new roundabout is completed at Hopewell Road and Bethany Bend. The number and location of entrances, exits will be sufficient for the use unless otherwise shown through a traffic study required by the Public Works Director. If approved with the recommended conditions, the proposed music venue is consistent with the City of Milton Comprehensive Plan Update 2016 and objectives. Therefore, staff recommends that U2103 be approved conditional and further VC 21-04 parts 1, 4, 5, and 6 and 7 be approved and part 2 be denied and part 3 be withdrawn. So with that said, if the Planning Commission chooses to recommend, these are the recommended conditions. 1A, notwithstanding the initial approval of this use permit, the city may begin the process of a city-initiated action to terminate this use permit effective no earlier than December 23rd, 2021. Said process shall include full compliance with Georgia's zoning procedures law and the city's zoning ordinance. B, existing structures indicated on the site plan, but excluding structures associated with the winery. 2, again, this is the general condition regarding a substantial compliance with the site plan received by our department on February 25th, 2021. And so again, we'll go back through to the owner's agreement to the following requirements, the months, days, and hours. We reviewed that in the use permit conditions. Then number 3, to the owner's agreement to the following requirements. There shall be no more than 200 attendees at any given time for each concert performance. At least 2 off-duty officers on site for each of the requested 7 events. Stage and area for ticketed live music. 1, maximum 250 square feet for live music stage, wood pavilion shown on site plan. 2, maximum 7,500 square foot area for live music lawn concert attendees, including covered picnic winery shelter. Only food and alcohol to be sold on site through Q Barbecue, off-site catering license, beer only, and through the farm at Pamela Farm.
Well, a lot of these are very similar. Yeah.
Shall not be allowed during events allowed under the agriculture-related activities or rural event facility use permits. And then 4, provide adequate temporary bathroom facilities. No temporary tents over 400 square feet, no portable generators, portable electric cables, or other temporary electrical systems on site, no pyrotechnics, fireworks, or other open flame devices, no temporary or other event signage to be used, no lighting except in accordance with night sky ordinance and as required for life safety. Sanitary facilities and trash receptacles shall be located at least 100 feet from any property line. So now we get into the conditions regarding the recommended concurrent variances. Delete the requirement for an 8-foot high, 100% opaque fence to allow the 10-foot wide strip along public streets to be planted with existing landscaping, vegetation along Bethany Way and Hopewell Road, to reduce a 75-foot wide undisturbed buffer alternative screening design with a 10-foot improvement setback adjacent to all AG1 zoning districts where existing structures, driveways, and activity areas are shown on the site plan, but relocating existing parking outside of the 75-foot wide undisturbed buffer and 10-foot improvement setback. To eliminate sidewalks along Bethany Way and Hopewell Road, and to allow for a lighting plan without light pole installation. And then to the owner's agreement to the following requirements. The first one, access and to the site and frontage improvements shall be subject to the approval of the Public Works Department and various code requirements. B, if at such a time, Director of Public Works determines that a traffic generated by the site impacts the operations of Bethany Way or Hopewell Road, he or she may require the owner to conduct a traffic study, determine if the development warrants any additional improvements at no cost to the city. If improvements are determined to be warranted, owner shall install those at no cost to the city. And stormwater management concept plan shall be submitted and approved by Milton Public Works Department prior to submission of the land disturbance, if required. So that concludes the staff report, and so I'm here for any questions you may have.
Anybody got any questions for staff? Okay, thank you, Robin. Now we'll call the applicant.
I'm going to read again. My name is still Pamela Jackson, and I still live at 2105 Bethany Way, and I'm still the trustee property owner. And I would like to incorporate my comments from the immediately prior application, not to be repetitive, but to elaborate more specifically with respect to this application and use permit request. Last summer with COVID, getting folks home and stir crazy and folks' desire to be outdoors and experience normalcy, we entered into an agreement with other Milton residents to host what we called the Uncorked Series, a ticketed live music event that would be held once a month at the farm. We received overwhelming interest and support. Although we have held similar music events in the past, they were not held with the same frequency. After hearing from my neighbors in the city, I understand that these are the biggest concerns in terms of traffic and noise. The only thing I'm asking for at this point is to allow us to hold a total of 7 more events with limitations on the number of tickets and guests in order to honor my agreement. No other events will be done after that. I'm only asking for the 7 more events just so that I can honor my agreement. Thank you.
Thank you.
Good evening, and we'll try to keep it to not good morning. I'm Ellen Smith with Parker Poe, 1075 Peachtree Street, Suite 1500, Atlanta, Georgia. I have the pleasure of representing the applicant with respect to this use permit. I respect the Planning Commission's recommendation with respect to the last use permit. With that, I do think, to Commissioner Milderbrook's comment, and to reiterate, with the prior 2 use permits, it has been the position that those are events and activities that have been happening on site. And there has not been historically grandfathered, whether there's a dispute with the city or not, that those events and activities were grandfathered. We say the same thing with respect to live ticketed music events. The difference has been they have increased in the number of intensity and the number of people coming. And we have heard that, we respect it. You've just heard Ms. Jackson say when she entered into this contract, she did so believing that she had every right to do so. She is only asking for the right to hold 7 more events. The dates are specified, the hours are specified. The city also, in addition to use permit applications, does have an administrative special event permit process. There was an event at the farm last month for which we applied and received a special event permit. There is one that is advertised on the website for May. We have applied for, we have not received yet, a special event permit. The city limits all property owners within the city to 2 special event permits a year. By the way, those special events permits could be for 1 night, or they could be for a festival that is up for 2 weeks. So technically 28 days worth of events. We're asking for this use permit to be limited to 7 events, once a month, with hours of operation limited, and I'm happy to answer any questions. We appreciate your consideration of this application. Thank you.
Anybody got any questions?
Why are you ending them?
Because we heard our neighbors.
How long was this contract for?
It was for the year signed in August or September of 2020 to run through December 31st, 2021.
And this is a contract with who?
I apologize, I don't have it in front of me.
Okay. And so again, if you do not have this use permit, then basically, I mean, the standpoint from the vendor who wants to continue to have these concerts that they've contractually agreed to with them, you're in breach of contract at that point. And so again, the position from the applicant was that, you tell me again, they felt that they had the right to just have the series here?
Yes.
Okay, without any use permit or anything like that?
Yes.
Okay.
There have been concerts in the past, again, not with the same frequency. We readily admit that, and not with the same number of people.
So have you already applied for special event permits? Okay, and have those already been, where do you stand on those?
We applied for 2 last year, and for November and December. Those events happened in November and December, once a month. We applied for 2 this year, one that was this past month, 3 weeks ago, and one for the second Saturday in May. And it is pending.
Okay. And so then you were also mentioning something about a 2-week permit, festival type of a permit?
That's the special events permit that the city issues, that the city has a separate code for special events permits, and any property owner can apply for those. You're limited to 2 a year, but those permits could be for a festival that is 2 weeks at a time, 14 days.
Mm-hmm. Okay. And
So 2 of those.
Yeah, and you have the opportunity to apply for those 2 for this year still?
No, we have applied for the 2.
You
We have
have.
applied for one, and
One
we
already
held an
happened.
event last
Okay.
month, and
And then
one
one
for
more.
the event in May.
Got it, okay.
Again, to fulfill the contract.
Okay. Anybody else have any other questions for the applicant? No? Okay, thank you. Right. Robin, how much more time do we have? Okay. Do we have any Speakers in favor?
Good evening.
Good evening.
My name is Nathaniel Lack, and I reside in the Bethany Oaks subdivision at 13935 Bethany Oaks Point. Across the street, our subdivision is across the street from the applicant. I do not know the applicant personally and only met the owner last week. Until recently, I wasn't even aware of the presence of the farm across the street. I never noticed any traffic issues or noises coming from the property that would have caused me any concern. After hearing of the permit applications and considerable complaint from just a handful of very vocal neighbors, I decided to go over to the facility myself last month at one of their uncorked music performances when the issues would be at their peak to try to relate to the concerns of my neighbors. My understanding, they had sold 190 tickets. What I found was a well-organized, low-traffic event that could only serve to be an asset to our community. The neighbors with whom I had shared the evening with agreed, as I do, and others as well in our community. One of the complaints I had heard involved the fear of people parking across the street at our clubhouse. I believe you made mention of that as well. What I found, however, was that nobody was actually using that parking lot. In fact, the only people who considered it was myself and other neighbors who live in the back of the neighborhood to then park there and walk across the street. And when I got to the parking lot and it was empty, I decided I would see how the parking situation was at the facility itself and found that there was more than enough parking to accommodate a full house. Another complaint I had heard was the fear of increased traffic, yet I witnessed nothing of the sort. Traffic moved quickly in and out of the property at a time when few cars were on the road. Another complaint dealt with the sound levels. As a ticketed concert goer, I had noted that while one of the singers' volume was at perfect levels for a crowd of 50 to 60-year-olds, the other entertainer was a bit too loud and could be heard in our community. I will note, however, that the community more frequently hears the sounds emanating from the two nearby schools, including marching band practices and performances, and yet I've never heard any complaints about those. This and other issues were raised at the community meeting at the farm last week, which I would note was well publicized. We got a letter from the applicant via mail, emails from HOA president in our community, and I posted it on our community Facebook page, so that everybody in the community was well aware of the meeting. And this meeting with the owner and the neighbors and the farm had agreed to lower the sound levels. I think their actions showed good faith on their desire to be good neighbors, and they agreed to adjust further should the proposed volume levels still cause concerns. In light of their actions and good faith attempt to address those isolated concerns and the fact that many of the issues raised are speculative at best, I stand here in support of their permit request.
Thank you. Do we have anybody else? Okay, thank you. Do we have anybody else in favor of? No. Is there anybody on Zoom who would like to speak in favor of? If so, please raise your hand. Nope. Okay. All right, calling once, twice. Okay. We will end that comment section for in favor of, and now we will open the floor up for anybody who wants to speak in opposition. Is there anybody who'd like to speak in opposition?
Hi, I'm Amy Sullivan, 2090 Bethany Way. So there's two main things I want to focus on. One is that we are truly a very residential community. We don't have any businesses embedded there. We don't have any businesses nearby. It's all residential. It's all people in their homes that live in and around there. The second thing I want to emphasize is that I have lived here since 1996. I have been there all the time, every day, in and out of my driveway. Until the beginning of last year, I never noticed all the traffic or all the loud music coming from that facility. It was markedly different. It started at the beginning of last year. First, we thought, okay, they're having a party, you know, but then the next weekend it went on again, and then the next weekend it went again. So our questions amongst ourselves have been for over the last year. Why are these events continuing to be allowed to happen when they do not have the use permit? They may have applied for 2 use permits last year, but there was probably at least 30 events last year. What about all the other times, all the other music, all the other traffic? We kept contacting the city of Milton and saying, don't they have to have use permits? Do they have use permits? Why don't they have use permits? And then the conversation went into the alcohol thing, and then it went into, you know, whether or not this was grandfathered. I've had a wedding at my house. I've had an Easter egg. I've had 3 Easter egg hunts at my house. I've had a corporate event when we invited everybody over for Christmas parties a couple years. I've had things at my house, but this last year really made a difference. The noise level and the traffic level, all of a sudden, it really geared up. And that was after the designation of state winery. The state gave them the winery license, and then they could have supposedly events to promote the wine. And then things just started to grow and get out of control. This has not been going on for 10 years. We have not seen this traffic and heard this music for 10 years. The paid ticketed events in the middle of a residential neighborhood, it just doesn't seem like an appropriate use. There have been many, many events there without any permits. We kept asking Milton, why aren't you stopping it? Why isn't it stopping? So yes, on April 10th, there was a special events permit, but there were many more other events with music and noise. Why wasn't that stopped? None of us understand why it wasn't stopped. You know, by last September, October, Painted Winery knew that everyone was questioning their ability to have these events. They're having permission to have these events. And yet they went ahead and signed a contract committing to 12 or 8 or 10, however many concerts this year. Why would you do that? If you didn't know that you had the ability legally to have these events at your place, why would you commit to the next year to have all of these paid events? You know, I could have gone out and got Cirque du Soleil to come on my property and do it every month and signed a contract and then come in and said, oh, but I signed a contract for it and I have to do it. I mean, I'm sorry that she is in that position. I have sympathy for her. But I think signing that contract without having the use permits, when she knew Milton was really looking into all that and talking to them a lot about it, and we were all talking about it, then to sign that contract and commit to that, I don't understand it.
Thank you. Okay, we have another comment. Have you already filled out a card? Yes, you can fill one out after.
Good evening, Jesse Shannon, 1820 Bethany Way. I don't envy you guys with the night that you've had so far. I did want to submit one thing to the record, though. My wife and I recently relocated from Manhattan about 1.5 years ago, so we're not going to be a good barometer of noise for you guys. Our concerns around these permits have mainly been around safety on the roads. Drinking and driving is a sensitive subject for us. I graduated from Milton High School, lost a classmate, just fished a drunk 19-year-old out of my front yard in Bethany Way about 6 months ago, flipped his truck over in the yard. So that's mainly where our concern lied and really the reason why we wanted to be here and the only reason why I'm speaking in opposition to this permit specifically. We haven't had an opportunity to go to the winery yet, only because of COVID. Otherwise, we'd absolutely be supporting it. What I did want to say is that I can't help but feeling after listening to these proceedings for the last 5 hours that it feels like there's quite a bit of confusion around the last permit that we listened to and sort of the in-between there. And as a resident, objectively going through this process, receiving the notice, coming to the information meeting, listening to all of these things, I think that we probably could have been armed with maybe a little bit more clarity and information around some of this stuff. It did feel a little bit half-baked to the point I think that others have made. And I just can't help but feel like there probably could have been a better middle ground to what happened in the last permit with regards to daytime use versus nighttime use and some of the audible levels and decibels being talked about and acoustic versus amplified music. So I just felt like that needed to be put into the record and someone needed to say that because I think it's been, obviously some heated discussion and a lot that's gone on here, but that was my observation from that. So thank you guys very much.
Thank you.
We have about 4 minutes.
Okay.
Again, I'm Joseph Canals, 800 Cooper Sandy Cove. I just want to say one thing here. I'm concerned, maybe I'm a little sensitive, but on one hand, I want to be a good neighbor. I'm not the kind of guy that complains, because I could be the next person on the end of a complaint. But I'm a little concerned on one hand where we have somebody come up. I've been to your farm too. I had a birthday party there. It was great. During the day, 12 kids, who wants sympathy for entering into an agreement. Again, like Mimi stated better than me, when she knew she needed to get a permit in order to enter into a contract. Highly concerned, and I brought this up earlier, that this is getting your nose in the tent. So you can do the next thing and the next thing and the next thing. I'm concerned that her attorney then comes up, and whether it was meant as such, it was perceived as such, a threat. Well, our next permit, we're going to ask for 14 days. And then what are you going to do? To me, as sweet as she is, that's a big, I'll refrain from saying it to my face. Well, my next permit's going to be 14 days. And by the way, I'll do something whether or not I have a permit or not. So now you're going to put a 14-day festival in my backyard? Is that what I heard? So I'm concerned about that. That's what she said. Yeah, you did. So I'm also concerned about this contract. We don't have a copy of the contract. Most contracts, you can go on hotels.com and book a hotel and cancel it the day before you go for COVID or for any reason. So you enter into an agreement that you know you probably need permission for. You want sympathy for that, and I believe in honoring your agreement, but you don't have a copy of the contract. Have you guys requested it? Does anybody have it? Do you have a copy of the contract here? No. Maybe there's a contract, maybe there's not. They have an out if there's COVID, the performers. So, I mean, we're all common sense people here. And I think the wool's being pulled over our eyes. Again, it's a residential neighborhood. Amy said it best. It's a residential neighborhood, and they're conducting commercial activities. And the last thing is, I said this point earlier, and the last gentleman repeated it. I still don't know what you guys are voting on or recommending, because they'll come up and have a suggestion, and then Wendy will say, well, we can do this or this or this or that. What are you approving? What's in writing that we know you're actually approving? Because after this, I want to be able to go to the city council members and say, I don't like this and I don't like that, and give them my opinion as well. I don't know what you're voting on. I don't know what you're approving, because they come up and say one thing, and then they turn around and we've modified it somehow that I've heard, but can't necessarily digest. Again, I would recommend that you table these things. I respect the contract issue. I think you need a copy of it. And I am really concerned in the conflict of having a rural area and then not having sidewalks. That's my last comment. Thank you guys again for listening.
Thanks.
We have about 30 seconds left.
Okay. Anybody else in opposition here? No. Anybody on Zoom? If so, please raise your hand if you'd like to speak. Anybody still awake out there? Okay. All right. We will close that side of the public comment, and now we'll open up the floor for any discussion, questions?
They do have some time left,
Okay, please.
about 4 minutes.
Not to belabor this, but just to be clear, the use permit that was applied for did not have limitations that related solely to a private contract. We proposed those limitations after hearing from neighbors at the CZIM and otherwise. We proposed those limitations to comply with contractual obligations. The contract was signed before there was any comprehension that this was a problem for the city. So with respect to the last speaker, I stand before you, and it's not just a little offensive to be called a liar, but I'm a member of the bar. I'm telling you that the contract was signed, but in any event, this description with respect to the special events permits was not intended to be a threat. It was intended to be informative that that's the city's process and that's an application that any property owner can make, and that it's for 2 events per year, for 2 nights, or for a festival that could go up to 14 days. Wasn't any threat. It's a request to limit the uses requested for this application to no more than 7 events, with all of the limitations with respect to time, traffic, parking, and the like. Just so you're hearing it too, because it was raised, the reason to request no sidewalk, there's not a sidewalk there. The city's project that puts in the roundabout is not proposing a sidewalk. We're not saying eliminate a sidewalk that should be there or shouldn't be there. It's a requirement because we're in the overlay district. This particular permit would be considered a commercial use. There would normally be a requirement to install sidewalk. It would literally be a sidewalk going to nowhere. So the request was for the variance to not install the sidewalk because it has no connectivity to any other part of the city's right of way. I'm happy to answer any questions. I appreciate your long time for not just this application, but all of them this evening. Thank you.
Thank you. Okay. Anybody else have any other questions for staff or applicants? Open the floor up for any discussion. Anybody have any discussion or comments? Or I'll open the floor up for a motion. Anybody?
All right, so I'll go. I recommend denial of petition U25-3/VC21-04, including its 7 concurrent variances.
Okay. We have a motion to deny the use permit and the 7-part concurrent variance, which is U21-03, VC21-04.
Second.
And we have a second. Is there any discussion? Okay. All those in favor say aye.
Aye.
Please raise your hand if everybody can raise your hand. Okay. And anybody else opposed? All right, so that use permit has been denied.
Can I ask who seconded it? I'm sorry. Braun. Okay,
Ron.
Thank you.
Okay, and I think that is the last item on the agenda. Do we have any other items on the agenda?
No, we don't.
Okay, I would just like to say thank you, everybody, for coming out tonight and speaking. We really appreciate your opportunity to come and take your time out of your night and day to make your voice heard. And at this point, I would like to entertain any motions for adjournment.
Move we adjourn.
We have a motion to adjourn. We have a second from Commissioner Nolte. All those in favor say aye. Anybody opposed? Better not be. Thank you. We are adjourned.